Good morning, Judge. This is video first appearance. Well, my name is Bianca. I'm going to be your tech support for today.
Okay, perfect.
Do you want me to explain how this Zoom is formatted?
If you could.
Okay, perfect. Well, actually, just hi.
Hi, how are you?
Oh, I'm doing well, thank you.
Okay.
This Zoom works as a webinar, so there are
So it's not like my regular Zoom.
No, no,
Okay.
these are very different. Well, not too different, but you know.
Mm-hmm. Okay.
There's attendees and panelists. Attendees cannot turn on their microphone, camera, nothing.
Okay.
Panelists can do that, and they need to be given explicit permission by either the host, which is you, or the co-host, which is myself, to do.
Okay.
I can monitor everything from where I am on the 8th floor.
Yeah.
So
And that's what I was gonna ask, if you can monitor, because sometimes they'll raise their hand or they'll put something in the chat. I'm not gonna be looking at the chat. I normally don't do that unless I'm prompted to do so. So if you can monitor chats in case anybody wants to speak, I can,
right. And I've already, sorry.
No, go ahead, go ahead.
I've already taken the liberty of promoting a private attorney for the felony calendar later today.
Okay.
As well as an individual who would wish to speak for a specific defendant, and I'm not sure which calendar it's for.
All right, and the other thing, as it relates to interpreters, you'll be able to do that. Click on the interpreter when needed. If there's a different, I know that the Spanish interpreter is automatic, but if there's an interpreter, Creole interpreter, someone else, another type of interpreter needed, you can guide me through the procedure.
Good morning, Judge. This is a Spanish interpreter. We normally, the interpreters who are assigned this duty, we take care of that, Judge.
Okay, perfect. All right. All right, so we have the state here in front of me, and I see the public defender.
Good morning, Judge. This is Assistant Public Defender Natalie Lightman for the record. I just have one brief question before we begin.
Yeah.
Does Your Honor wish to,
recording in progress,
announce that you are appointing the public defender, or is there a standing order that for each case we will be appointed?
Let's do a standing order, temporary appointment, depending on the affidavit that's provided by the party,
Okay, Judge. Thank you.
unless an attorney appears.
Yes, of course.
All right.
Oh, and I'm sorry, this is video. Madam Public Defender, can I get your name again? Because
Yes.
the record just started.
Assistant Public Defender Natalie Lightman.
Thank you so much.
And if I could get an appearance by the state.
Good morning, Your Honor. Assistant State Attorney Chad Lyle on behalf of the state.
Good morning, Your Honor. ASA Justin Barquette on behalf of the state.
Okay. Any relation to Judge Barquette? Any relation to Judge Barquette?
We're the ones with you, Your Honor, sadly, not the K.
Okay. Okay. All right, so whenever we're ready, what are we doing first, misdemeanors or domestic?
Domestic violence, Judge.
Domestic, all right.
And Your Honor, I can approach with the packet of priors and the calendar for this.
Oh, please.
Judge, I can't see the defendant, so I need to swear them in.
All right. How do you?
Priors and.
Okay, so, for the video, okay, there we go. The defendants are present. Do you need the microphone?
Yes, Judge.
Okay, they're unmuted. Go ahead.
I need everybody in the chapel to be sworn, please.
Le pido, por favor, para prestar juramento.
Raise your right hand to be sworn.
Levanten la mano derecha para prestar juramento.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Need you say I do?
Pero afirman solemnemente que dirán la verdad, toda la verdad y solamente la verdad. Si es así, contesten que sí.
I don't hear anything.
We can't hear you.
They said I do.
Okay. All right, got it. State, do we have the stay away orders that I can,
Yes, Judge.
just have a pack of them? Thank you. And they're in order, I guess, right?
Yes, they are.
Well, thank you. With the name already there. Thank you. All right, thank you so much. All right, the first case I have is Falco Manso, first
Yeah,
name
he's a-
Berta.
He's at awardee. We need to reset it for tomorrow.
All right, so before clerk, someone help me here.
Just write reset yours there.
Reset.
Yeah.
I guess is 9-2, right?
Let's put all that.
Okay, just reset.
Just reset is fine.
All right.
Pass it to me. And the still wait. You want me to call the calendar for you?
No, I'll do it. Lorenza Pastora Duarte.
Judge,
And she,
this is video. For the preservation of the record, do you mind also announcing?
You want me to announce the clerk?
Yes, but the judge as well, if possible.
Oh, Angela Roll, clerk for domestic violence.
Thank you.
okay. All right, let me read the A form.
You should announce Judge.
Oh, this is Judge Luis Perez Medina,
Soy el juez Luis Pérez Medina.
and I'll be presiding over all these cases this morning.
Presidiré sobre todas estas causas esta mañana.
Judge, can you hear me?
Yes,
Okay. I just wasn't
Ye-
sure before. Were you able to hear that Miss Duarte requires the services of the Spanish interpreter?
okay, no, I didn't. All right,
¿Usted escuchó que la señora Duarte necesita un intérprete de español? No, no la escuché.
okay. Does she have the headphones on?
Ella tiene los auriculares.
No, she can hear him.
No, ella
Okay,
la escucha.
all right, perfect.
Muy bien, perfecto.
Yeah, but they told me to go get me on the phone when I came in. You don't need it right now? Yeah, it's fine.
No.
Okay.
Okay, I find probable cause for the arrest.
Determino
You're
que
charged with
suficiente
one count misdemeanor battery.
la causa de un delito leve, agresión.
And Judge, I'm
Yeah.
not sure logistically how you want to do this, but I do have an argument for bond if Your Honor is ready for that now.
No sé cómo decir hacer eso, pero tengo un alegato en relación a fianza. Si usted está listo.
And do we have the priors?
Tenemos antecedentes.
Yeah, Your Honor, the defendant in this case doesn't have any priors aside from the PSC case.
Okay, state, do you have, first of all, I'm issuing a stay away order. In this case, ma'am, do you, and I'm gonna ask you to repeat after me. First of all,
Pues,
you're not to, go ahead.
yo no voy a, la acusada tiene antecedentes, no veo ningún tipo de antecedente en el sistema, contesta el fiscal, Voy a expedir una orden de alejamiento. Señora, necesita que repita después de escucharme.
Okay. Ma'am, you're not to engage in any criminal activity. You're not to possess any illegal drugs.
No
And
puede
you're,
inmiscuirse en actividades delictivas, no puede usar ni tener ninguna droga ilegal.
you may not purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and/or concealed weapon permit to the nearest police department and file a receipt with the court. Did you understand that? Did you
Señora,
understand all three?
usted no puede comprar, portar ni tener ningún tipo de arma de fuego, arma o munición. De inmediato tiene que entregar cualquier arma de fuego o permiso para portar armas o municiones a la estación de policía más cercana y presentarle una copia del recibo que le den allí al tribunal. ¿Usted ha entendido lo que le dije?
No,
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 no, no.
no.
Okay, ma'am. All right, so let's repeat it again. I'll go one by one. Do not
Repitámoslo
engage
una
in
vez
any
más.
criminal activity. Do you understand that?
No se inmiscuya en ninguna actividad delictiva. ¿Usted ha entendido eso?
No,
Okay, ma'am, you cannot commit a crime. Do you understand that?
Señora, usted no puede cometer ningún delito. ¿Usted comprende eso?
okay,
Ok.
You cannot possess illegal drugs. Do you understand that?
Usted no puede tener ninguna droga ilegal. ¿Usted comprende eso?
sí,
Yes.
yes,
You cannot
Yes.
use, purchase, or possess or carry a firearm, gun, weapon, or ammunition.
Usted no puede usar, comprar, portar o tener ningún tipo de arma de fuego, arma o munición.
Do you understand that?
¿Usted comprende eso?
sí,
Yes.
Okay, you must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. That is, if you have a weapon.
Señora, si es que usted tiene alguna arma, de inmediato tiene que entregar cualquier arma, munición o permiso para portar armas escondidas a la estación de policía más cercana y presentar una copia del recibo que le den allí al tribunal. ¿Usted ha entendido eso?
sí, sí,
Yes.
Ma'am, you are prohibited from having any direct or indirect contact with the following person hereinafter the victim,
Señora,
Sudi Sanchez.
se le prohíbe que usted tenga cualquier tipo de contacto, ya sea indirecto o directo, con la siguiente persona, Sudi Sánchez. Esa persona, me referiría a esa persona como la víctima de aquí en adelante.
sí, señor.
Yes, yes.
That includes contact in person. In other words, you cannot make contact with Sudi Sanchez in person, in writing, by telephone, through social media, or any other electronic means, or through a third person. Do you understand that?
Señora, eso significa que no puede establecer ningún contacto con Sudi Sánchez, ya sea en persona, por escrito, por terceros, por teléfono, por medios sociales o a través de cualquier dispositivo electrónico. ¿Usted ha entendido eso?
Yes,
Yes, in English.
Okay. You must stay away at least 500 feet away from the victim's home, place of employment, and or school at all times.
En todo momento, tiene que mantenerse por lo menos a 500 pies de distancia de la víctima, el hogar de la víctima, del centro de trabajo de la víctima o de la escuela donde puede estar la víctima.
Okay, now it might be apparent that you both live in the same place. So if you do, that you may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health item, medication, personal and business related paperwork, and work tools. Do you understand that?
Ahora bien, señora, podría parecer que usted y la víctima viven en el mismo hogar. Si así es, entonces a usted se les permitirá regresar a la vivienda que comparten en un plazo de 48 horas a partir de que quede en libertad, acompañada por un policía, para que usted pueda ir ahí a recoger sus pertenencias personales, su ropa, sus cosas que necesita para su salud, sus medicinas, sus documentos personales y sus herramientas de trabajo.
Sí.
Yes.
If you go to the home or remain at the home without the police, you will be subject to arrest by the police officer. Now, the police officers are going to request, and you have to give them all keys and garage door openers to the home from that you have in your possession.
Si usted va a la casa sin la policía o permanece allí sin la policía, entonces usted podría ser arrestada. La policía le va a exigir que usted le entregue a ellos cualquier llave que usted tenga para entrar en ese lugar o cualquier dispositivo que usted tenga para abrir el estacionamiento del vehículo.
Do you understand that?
¿Usted ha entendido eso?
Sí.
Yes.
All right. All right, I do find probable cause. Counsel, do you have any do you have any suggestion? I don't see the priors.
Your Honor, there
Determino
are
que hay suficientes
always
indicios. No veo los
All right.
antecedentes.
for this defendant aside from this.
Okay, so what is the standard bond?
The standard bond is $1,000 and that's the amount this is.
All right, and the defense wanted to be heard on the issue of bond.
Yes, Judge.
Go
La
ahead.
defensa quiere que se le escuche en relación a la fianza. Sí. Excuse me, Your Honor, this is the interpreter speaking. The interpreter is having great difficulty hearing the attorney for the state.
Oh, yeah, you might have to. You could sit down. You don't have to stand every time. But
Thank you.
Mr. Interpreter, is this a better volume?
Much better. This is the
Okay.
interpreter speaking, yes.
Okay, is there any part of what I said that you want me to repeat?
Anything this is the interpreter. I was unable to hear anything you said, sir.
Okay, so the state requested standard bonds in the amount of $1,000 for this case.
La fiscalía pide que se fije la fianza estándar en este caso, que son $1,000.
And
All right.
Judge,
go ahead.
in light of the fact that Ms. Duarte has absolutely no priors and the fact that Your Honor just issued a stay away order, I believe ROR with the stay away order is sufficient to reasonably protect the community and assure the presence of Ms. Duarte at trial and assure the integrity of the judicial process. If Your Honor is not inclined
Su
to
señoría, en vista de que la señora Duarte no tiene antecedentes y que su señoría ha expedido una orden de alejamiento, en mi opinión, basta con que se le permita salir bajo fianza para asegurar que ella va a comparecer a todas las audiencias en el futuro, que la comunidad permanecerá asegurada y que la integridad de los procesos judiciales se respetará.
If Your Honor is not inclined to grant ROR, I'd ask for pretrial services and the alternative.
Si su señoría no está dispuesto a permitirle salir bajo palabra, pido que se le permita salir a cargo de servicios previos a juicio.
All right, I'm going to issue the standard bond, $1,000 bond.
Voy a imponer la fianza estándar, $1,000.
All right, thank you, ma'am.
Gracias, señora.
There you go. All right, the next case is Abigail Riva Sevilla. Interpreter needed or not?
Yes, Judge, Ms. Viva Sevilla does require the services of the Spanish interpreter.
All right,
Eh,
let me read the A form.
Yeah, she has a
Acaba.
hold for immigration.
Leer
Okay.
el formulario de red. Ella tiene una orden de retención por parte de las autoridades migratorias.
Okay.
can just see if it works. If it doesn't work, we can take it off.
Mr.
Señora, ¿me
Interpreter,
oye?
Okay.
Excuse me, Your Honor, I believe that equipment is not in use at the moment because we were having difficulty, this is the interpreter speaking, with the changing of the covers for the cushions and so on. So the equipment to use that, the headphones is in another location. It's not the regular Zoom.
Okay, all right, that's fine. So I could hear you. I'm assuming that at Bond here in the detention center, you could hear the interpreter.
Como que en el centro de detención escuchen al intérprete.
Is that correct?
Yes, Judge.
Correcto.
All
Sí,
right,
pues.
so we'll just leave it the way it's working fine.
Dejémoslo así, funciona bien.
All right, I find probable cause.
Determino que hay suficientes indicios.
And this, I'm sorry, what is the name of the defendant again? I just want to make sure I have the right file.
No te sabe cómo
Abril
se llama.
Valdivia.
Okay, that's fine. Okay, I find probable cause.
Determino que hay suficientes
I
indicios.
mean, right, ma'am, I'm gonna issue a stay away order.
Señora, voy a pedir una orden de alejamiento.
I'm gonna ask you to, I'm gonna read it to you and then ask if you understand.
Se la voy a leer y le voy a preguntar si me ha entendido.
There's certain conditions here, like, you must stay away from the victim, you can't go to you must stay away 500 feet away from the victim, place of home, place of employment and school. And so there's certain conditions, I'm gonna go through them and I wanna make sure you understand. Do you understand that?
Señora, hay ciertas condiciones con las que usted tiene que cumplir, como tiene que, por ejemplo, tiene que mantenerse alejada de la víctima y que tiene que mantenerse alejada también no solamente de la víctima, sino también del hogar, de la casa de la víctima, de su centro de trabajo, escuela, y yo se lo voy a leer todo esto. ¿Me comprende?
Sí.
Yeah.
Okay, so the first condition is you cannot engage in any criminal activity. Do you understand that?
La primera condición con la que tiene que cumplir es que no puede inmiscuirse en actividades delictivas. ¿Usted comprende eso?
Sí.
Yes.
Okay, you cannot possess any illegal drugs. You understand that?
No puede tener o poseer ninguna droga ilegal. ¿Comprende eso?
Sí.
Yes.
Okay, you cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You understand that?
Usted no puede usar, comprar, tener o portar ningún tipo de arma de fuego, munición o arma. ¿Usted comprende esto?
Sí.
Yes.
Okay, if you possess any a firearm, gun, weapon, or ammunition, you must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. Do you understand that?
Si usted tiene algún tipo de arma de fuego, pistola, munición o permiso para portar armas escondidas, tiene la obligación de entregar eso al departamento de policía que le quede más cercano y presentar una copia del recibo que le den allí al tribunal. ¿Comprende eso?
Sí, no
Yes.
tengo.
No, I don't have any.
No.
Okay, but if you did, you understand that you're supposed to turn it in. Is that
Pero
correct?
si usted los tuviera, usted comprende que tiene la obligación de entregar eso.
Sí.
Yes.
Okay, okay. You're prohibited from having any direct or indirect contact with the following person, hereinafter referred to as the victim, Sergio Perez, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Do you understand that?
A usted le está prohibido tener cualquier tipo de contacto, ya sea directo o indirecto, con la siguiente persona que se conoce de aquí en adelante como la víctima, Sergio Pérez. Esto significa que no puede tener contacto con esa persona, ya sea en persona, por escrito, por teléfono, por medios electrónicos, a través de terceros o a través de medios sociales. ¿Usted comprende eso?
Sí.
Yes.
Okay, you're to stay away at least 500 feet away from the victim's home, place of employment, and or school at all times. Do you understand that?
En todo momento tiene que mantenerse por lo menos a 500 pies de distancia de la víctima, de su hogar, centro de trabajo o escuela. ¿Comprende eso?
Sí.
Yes.
Okay. All right, is there any priors?
¿Hay antecedentes?
Your Honor, this defendant does not have any priors.
What's the standard bond?
Your Honor, in this instance, the standard bond would be $1,000, but given the fact that there are no priors and the facts of the case, the state, would request pretrial services, with an alternate bond of $1,000.
Okay,
She has to hold for
uh,
immigration, Your Honor. She's not going
l-
to.
I'm sorry?
En,
She has a hold for immigration.
en vista de que ella ¿cuál es la fianza estándar? $10,000. La fiscalía comenta que como carece de antecedentes y en vista de los hechos en el caso, se pide que se le permita salir a manos de servicios previos a juicios
Does she
ah,
qualify for
y
for
fianza
pretrial
como
service?
alternativa.
Judge, she won't be
Se le
able to be
indica.
released to pretrial services because of her immigration hold. And so for that reason, the defense is asking for a $1 bond. The $1 bond in conjunction with her immigration hold can reasonably protect the safety of the community, assure the integrity of the judicial process, and assure her presence in court.
Sí.
Señoría, dado que tiene una orden de retención por parte de las autoridades migratorias, la defensa pide que se le permita salir o sea, se le permita ser retenida a cambio de una fianza de $1, porque ella no califica para servicios previos a juicios debido a la orden de retención por parte de las autoridades migratorias. Y se indica además por parte de la Defensoría Pública que una fianza de $1 sería suficiente para asegurar la seguridad de la comunidad, que ella comparezca en los procesos posteriores y la integridad del sistema judicial.
Your Honor, if pretrial services is not an option, even once the immigration hold is resolved, the state would just request standard bond in the amount of $1,000.
And then I'm gonna give the $1,000 bond.
Señoría, si el servicios previos a juicios no es una opción, dada la retención por parte de las autoridades migratorias, la Fiscalía pide una fianza de $1,000. El juez ordena, por tanto, dispongo que la fianza será $1,000.
All right, thank you.
Muy bien, gracias.
Te van a deportar, ¿ok?
Sí, yo la pago.
Si tú la pagas, te van a deportar.
All right, the next case I have is Maggie Gonzalez. Does she speak Spanish? Does she need an interpreter?
Which do you prefer? English is fine, Judge.
English is fine. There's no immigration hold on that one?
No, Your Honor.
Are you Maggie Gonzalez? Yeah.
She's deaf, I'm sorry. She can't
Yeah.
hear well.
Okay,
And I can't read lips.
Okay.
If you speak loud, that would be great.
Judge, for the record, Miss Gonzalez is hard of hearing, so if everyone could speak loudly,
I
that would
will.
be appreciated.
No problem. Put the microphone a little closer. Do you have whiteout? I can. All right, let me read the A form first. No? Okay. Okay, I find probable cause. Ma'am, you're charged with one count, a misdemeanor count of domestic violence violation, so violating an injunction. It indicates here that there was a restraining order issued under case number 25-018205 FC 04, and you were sitting in the porch. So I do find probable cause. I am going to issue a stay away order. I'm going to ask you, I'm going to read it to you and ask if you understand. So I do find probable cause. Council, state, this is a violation of restraining order. What is your position on release?
Your Honor, the state's position is that we would be asking for $1,000 bond. The standard bond for a nonviolent first degree misdemeanor is $500, but the state is asking for the elevated bonds due to the fact that the crime alleged is a violation of an existing.
I'm sorry, I don't believe that Ms. Gonzalez was able to hear any of that. If the state could please speak louder.
Yeah, just talk right into the microphone.
Your Honor, the state's requesting $1,000 bond. The standard bond for a nonviolent first degree misdemeanor is $500, but the elevation the state is asking for in this case is due to the fact that the crime alleged is a violation of an existing court order.
Judge, the defense is requesting TAP at this time. I don't believe Ms. Gonzalez has an address, so pretrial services would not be an option for her. But TAP with a stay away order can reasonably assure the safety of the community. Again, this is a nonviolent allegation.
Yeah, the problem I have with that is that she had already a restraining order and she violated that restraining order. So I'm gonna follow the state's recommendation of $1,000 bond. And let me read the stay away order. Ma'am, do not engage in any criminal activity. Do you understand that?
I understand that.
Do not use or possess any illegal drugs. You understand that?
I do.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You understand?
I do.
If you have one, you must immediately, if you have any of the above, you must immediately surrender any firearm, ammunition, and/or concealed weapon permit to the nearest police department and file the receipt with the court. You understand that?
I understand none of the above apply.
Okay. You're prohibited from having any direct or indirect contact with the following person, hereinafter referred to as the victim, Raul Leon, including contact in person, in writing, by telephone, through social media or other electronic means, or through third persons. You understand that?
I do. I don't communicate with him.
Okay.
I don't have a relationship with him.
Okay, you must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
I understand.
Okay, ma'am, not only, if you go back again, not only will you be in violation of that previous injunction, you'll be in violation of this court order. And there could be further penalties. You understand that?
I understand.
All right, thank you so much.
Mr. Jackson, I want y'all to stand up in the box. Give the attorney breathing room. Counsel, can you turn the microphone to the door?
Javis Jackson?
Other than the address where this happened.
No, I don't stay down here. I stay in Temple.
Good morning, sir.
Good morning.
If you gave you pretrial services, you would have an address that's not this one.
I'm staying in Temple. Temple is my address.
Okay.
Don't stay down this way.
Okay.
Good morning.
Good morning.
Good morning.
Good morning, sir.
Good morning.
Good morning.
Same thing like going in out too, right?
All right, I find probable cause. Yes, sir, you're charged with misdemeanor battery, domestic violence. Misdemeanor battery, I find probable cause based on the A form. Is there, what are his priors?
Your Honor, the state just wanted to draw your Honor's attention to one prior. It is a no cross prior, but because it's a crime of domestic violence, the court has authority to consider priors that did not result in conviction.
Okay,
So the prior specifically is in F15, it's F153975. It's a past domestic violence battery that also included a robbery, sudden snatch charge. Because of this prior, Your Honor, the state would be requesting a $1,500 bond in this case.
all right, defense?
Judge, I just highlight that that is not a prior, that is a null cross, and he actually has no local priors. The only things on his record are withholds of adjudication, which, as Your Honor is well aware, those are not considered priors. Moreover, those two withholds of adjudication are both nonviolent and remote in time. The most recent one is from 2014. Even if Your Honor is considering that battery, robbery, sudden snatching case, that is also remote in time, that is 10 years ago now. That was in 2015. So in light of the fact that Mr. Jackson has no priors, we would be asking for pretrial services with an alternate bond of
Okay, I'm gonna issue a bond of 1,500. Sir, I'm gonna read the stay away order from you, to you. Make sure you follow it. If you don't, you could be arrested for violation of the stay away order. Do you, make sure do not engage in any criminal activity, do not use or possess any illegal drugs, and do not use, purchase, possess, or carry firearm, gun, weapons, or ammunition. Do you understand that?
Yes, sir.
You must immediately surrender any firearm, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You understand that?
Yes, sir.
You're prohibited from having any direct or indirect contact with the following person, hereinafter called, referred to as the victim, Young Shakwa Young, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person. You understand that?
Yes, sir.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes, sir.
And you do have a child in common.
Yes, sir.
Do you live at that home?
What home?
The person where the victim lives?
No, I don't stay down here, Your Honor. I stay in Temple.
Okay,
I just came to visit. That's it.
all right. Okay, no, that's it. That's it for the stay away order. All right, thank you, sir. So the bond is set at 1,500.
And Judge, for the record, for
Yeah.
the next case called, Mr. Jones, I do have a probable cause argument before Your Honor makes a finding.
All right, thank you. Okay, so Everett Jamal Jones. Okay, make your argument.
Judge, domestic violence relationship is defined by Florida statute 741.28. There is no allegation of any domestic relationship in the four corners of this arrest form. Thus, there's no probable cause for the offense of domestic violence battery. And for that reason, we're asking that Mr. Jones be released outright.
State?
Your Honor, the state would agree insofar as the facts of this arrest form, not pointing to a domestic violence relationship, that can be something that is fleshed out.
Does point to a battery.
Trial, exactly, Your Honor. So in lieu of finding probable cause for a domestic violence battery, the state asked Your Honor to find probable cause for a regular battery, and issue bond in the amount of $1,000.
Does he have any priors?
Your Honor, the defendant in this case does not have any priors.
Okay, so on a regular battery, he would, the bond would be less than 1,000, wouldn't it?
The standard bond is $1,000 for a regular battery.
Okay, does he
Judge, I'm sorry, for a regular battery, the presumption is in favor of non-monetary release as opposed to a domestic battery. So that is why the distinction is important, because there's a presumption in favor of non-monetary release. We are asking for ROR with a stay-away order that can reasonably assure the safety of the community, Mr. Jones's presence in court, and the integrity of the judicial process.
No, I'm not, does he qualify for pretrial release? What are his priors?
He has no priors.
No priors, Your Honor.
He's from Texas. All right, I'm gonna issue a bond of 5,000. I mean, of 1,000, I'm sorry. PC found for regular battery, for M1 battery. Hey, sir, I'm gonna read to you a stay away order. I'm gonna ask if you understand what I'm reading. Do not engage in any criminal activity, do not use or possess any illegal drugs. You may not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. Did you understand all three of those?
Yes, sir.
All right. Yes, you're prohibited from having any direct or indirect contact with the following persons here and after referred to as the victim. Deandra Baker, you know who that is?
That's my baby mom.
Okay. Including contact in person, in writing, by telephone, through social media, or any other electronic means, or through persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes, sir.
All right. Thank you, sir. Edward Stanley Denson.
Yes, sir. Good morning.
Good morning, sir.
Judge, I have a probable cause argument for this one as well, whenever you're ready.
All right. Okay, what's your probable cause argument?
Judge, this is the same probable cause argument as the last one. There's no allegation of a domestic relationship as defined by Florida statute.
Date?
Your Honor, it is not charged as a domestic violence battery. This case is only charged as a regular battery.
All right. Priors?
Your Honor, there are a few withholds of adjudication. In this case, the rest of the prior arrest or no action cases, because this is not a crime of domestic violence, I won't read those to the court, but I did want to point out to Your Honor the 2008 withhold of adjudication, felony, and the charge there for child abuse, no harm. There's also a conviction for resisting without violence in 2011, as well as a cannabis selling with,
So what's the standard bond?
the standard bond in this case, Your Honor, would be $1,000. The state would ask for an elevated bond of $1,500 just based on the facts alleged in the arrest affidavit.
Judge,
Yeah.
since this is not charged as a domestic, there is a presumption in favor of non-monetary release, and there are conditions that can reasonably assure the safety of the community. Mr. Denson's presence in court and the integrity of the judicial process, all of the priors listed by the state, only 2 of which are actual convictions, are remote in time, and pretrial services can accomplish all of the goals that I stated earlier.
I don't, well, when was the prior? Was the last prior? I'm sorry? Yeah, that's, when was the last prior?
The most recent, Your Honor, the conviction is from 2011. There is a withhold of adjudication for cannabis possession from 2013.
Okay. I'm gonna find for a bond of 1,000. Not domestic. 1,000. And there's it appears that Mr. Davis lives with the victim, so I'm gonna issue. Okay, if you don't, that's fine, but I'm still issuing a stay away order to stay away from the victim's home. Okay, so sir, I'm gonna read you a stay away order. Do not engage in any criminal activity. Do not use or possess illegal drugs, and you may not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and or any concealed weapon permit to the nearest police department and file a receipt with the court. Do you understand that? You understand that, sir?
Yes, Your Honor.
All right. You're prohibited from having any direct or indirect contact with the following persons who's identified as the victim: Adriana Davis, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. You understand that?
Yes.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes.
Now, if you don't live, that's fine, but if you live in the same place with the defendant, with the victim, in this case, you may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer, to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and from you, and turn them over to the victim. Do you understand that?
Yes.
All right, thank you, sir.
All right, have a blessed day, Your Honor.
You too.
English? Yes.
All right. Ricardo Jose Garcia. Good morning, sir. Do you need an interpreter?
No.
No, all right, you're charged with battery, domestic violence. Give me a second to read the arrest form. Okay, I find probable cause for domestic battery. What are the priors?
Your Honor, the defendant in this case has no priors.
And what is your suggestion on bond?
Your Honor, because this incident took place in front of the couple's minor children, both of them were being bathed by the victim. At the time, the state's asking for a $15,000.
And from the defense?
Judge, in light of the fact that Mr. Garcia has no priors, he does have a place where he can stay that is not the incident location, that is separate from the alleged victim in this case. We are asking for pretrial services. Like I said, Judge, he has absolutely no priors. And if your honor is going to issue a stay away order, all of the goals can be achieved of assuring the safety of the community, Mr. Garcia's presence in court, and the integrity of the judicial process.
Okay, I'm gonna issue a bond for 1,000 and a stay away order. All right, sir, I'm gonna read the stay away order to you. I want to make sure you understand the requirements, all right?
Yes, sir.
Okay, so the first thing is you cannot engage in any criminal activity. Second, you cannot use or possess any illegal drugs. Third, you cannot use, purchase, or possess any or carry any firearm, gun, weapons, or ammunition. You understand that?
Yes, Your Honor.
Okay, now it seems like you do have a firearm, so you must immediately surrender any firearms, ammunition, and or concealed weapons permit to the nearest police department and file a receipt with the court. You understand that?
Yes, Your Honor.
Okay. You're prohibited from having any direct or indirect contact with the following persons, hereinafter referred to as a victim: Kelly Garcia, 9/26/1946. I'm sorry, I guess that's the date of birth, April 26. I can't read this. Clerk, is that a 4 or is that a 9? Because it would it looked like 1946. That would be, so I'm assuming that's a 9. Yeah. Yeah, but I'm not sure why the date of, is that a parent or,
It's Ricardo Garcia.
right? And why was the date of birth was put there?
It's 9/7/19.
Okay, the 9 looks like a 4.
Yeah.
Thank you for catching that, Your Honor.
Yeah. Okay, so it's Kelly, all right, so you're prohibited from having any direct or indirect contact with the following person, hereinafter referred to as the victim, Kelly Garcia. Again, is it September 26, 1996,
For the victim, Your Honor, it's 1990.
94? But it's September 26, right? September 26, 1994, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes, Your Honor.
Since this person is a spouse, since this person is a spouse and you live at the same place, you may return to the victim's residence one time only within 48 hours of the entry of the order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officer shall request all keys and garage door openers to the home and will provide them to the victim. Do you understand that?
Yes, Your Honor.
All right. All right, thank you, sir. Is this clerk, Madam Clerk? Is this two defendants?
LaRoche Hernandez, that's name. LaRoche Hernandez.
And then, but there's also Rolanda Berna. Ma'am? Ma'am?
Yes,
There's also a Rolanda Burnham. So is this a form for two people?
no, that's his whole name.
All right.
Roland LaRoche.
Roland Berna? All right, so I have here Roland Berna LaRoche Hernandez. Is that your full name?
Yes, sir. Yes, Your Honor.
Okay, got it. Sorry about that. A little confused. Okay, you're charged with misdemeanor battery. Doesn't seem like it's domestic.
That's correct.
Okay. Step.
Actually,
Yes, it does seem, because it's a grandfather, right?
that's correct, Your Honor, and so based on the facts in the arrest warrant, we would ask Your Honor to find probable cause for domestic violence battery.
Okay.
We have one juvenile.
I'm sorry? You have a juvenile, what time? Okay. All right, thank you. Okay, I find probable cause for domestic, misdemeanor battery. Priors,
The state didn't have no priors, Your Honor.
bond, request,
The state would be requesting standard bond in the amount of $1,000.
okay. All right, so, the court will issue a standard bond.
Judge, may I be
Yeah,
heard?
go ahead, yes.
Mr. LaRocha Hernandez has absolutely no priors, and Judge, a monetary bond is not necessary here to protect the safety of the community. We are asking for pretrial services and a stay away order.
Okay, what are his priors?
No
None.
priors, Your Honor.
Does he qualify for pretrial? Is domestic violence, so he does or doesn't? Okay, I'm gonna do pretrial services. Does he have a place to stay? Because he's not gonna be able to go back to the home.
I know, Judge, I believe he'll need to figure that out, but this is his residence where he resides with his girlfriend. I don't know if the alleged victim lives there or not, but in the
It
event that-
doesn't, it indicates according to the A form that she does. So the problem is, does he have a place to stay?
And Your Honor, we can do pretrial services alternate.
Yeah, that's what I'll do. I'll do pretrial services.
alternate 1,000.
Yes. All right, sir, I'm gonna read stay away order to you. I'm gonna ask if you understand. All right? You cannot engage in any criminal activity. You cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. That is if you have any of those. Do you understand that?
Yes, Your Honor.
You're prohibited from having any direct or indirect contact with the following persons here and after the victim: Naomi Vedaluz, date of birth 8/31. It says here 25. I'm sure that his granddaughter was not born in 1925.
I apologize, Your Honor.
Yeah, why are you putting? Do I sign? This.
You see?
Up there. Thank you. All right. Okay, so it's, all right, so you're prohibited from having any direct or indirect contact with the following persons hereinafter referred to as the victim: Naomi Devalux or Devalu, DeVoe, Naomi DeVoe, date of birth 4/24/2003, including contacts in person, in writing, by telephone, through social media, or through any third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Do you understand that?
Yes, Your Honor.
All right, and since you both live in the same place, you may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officers shall request all keys and garage door openers of the home from you and turn them over to the victim. Do you understand that?
Yes, Your Honor.
All right. All right, thank you, sir.
Mr. Alvarez Hernandez requires the services of the Spanish interpreter.
All right.
Interpreter present.
All right, let me read the A form. And sir, you're charged with domestic violence battery.
Permítame leer el formulario de su arresto. Caballero, a usted se le acusa de agresión doméstica dentro del contexto de violencia doméstica.
All right, fine, probable cause for domestic violence battery.
Determino que hay suficientes indicios de criminalidad, de agresión dentro del contexto de violencia doméstica.
I'm going to read, sir, I'm going to read a stay away order to you.
Caballero, le voy a leer una orden de alejamiento.
All right, sir. You cannot engage in any criminal activity. You cannot possess any illegal drugs, and you cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. Do you understand that?
Caballero, usted no puede participar en ninguna actividad delictiva, no puede usar, poseer o portar ningún tipo de arma de fuego, municiones, y no puede usar ni tener ningún tipo de droga. ¿Usted ha entendido?
Sí.
Yes.
Okay. You must immediately surrender any firearms, ammunition, and or concealed weapons permit to the nearest police department and file a receipt with the court. You understand that?
De inmediato, usted tiene la obligación de entregar cualquier arma de fuego, munición o permiso para portar armas escondidas a la estación de policía que le quede más cercana y presentar una copia del recibo al tribunal. ¿Comprende esto?
Sí.
Yes.
You're prohibited from having any direct or indirect contact with the following persons here and after referred to as the victim: Gretchen Longos Veita. You know who that is?
Caballero, a usted le está prohibido tener cualquier tipo de contacto, ya sea indirecto o directo, con la siguiente persona que se va a referir de aquí en adelante como la víctima. Se llama Gretchen Longos Veita. ¿Usted conoce quién es esa persona?
Sí.
Yes.
Okay. You cannot have contact in person, in writing, by telephones, through social media or any other electronic means, or through third persons. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
A usted no le es permitido tener contacto con la víctima, ya sea en persona, por escrito, por teléfono, a través de medios sociales, a través de terceros, o de ninguna otra manera. ¿Usted comprende eso?
Sí.
Yeah,
Sí.
yeah.
All right, since you do live in the same location, you must leave the home. You may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. You understand that?
Dado que usted ha convivido en la misma casa, tiene la obligación de marcharse de esa casa, pero se le va a permitir regresar allí solamente una vez a partir de 48 horas de que se expida esta orden acompañado por un policía con el fin de que usted pueda recobrar allí sus pertenencias personales, su ropa, sus medicinas, sus artículos de salud, sus herramientas de trabajo y sus documentos personales. ¿Comprende?
Sí.
Yes.
Okay. If you go to the home or remain at the home without the police, you will be you will be subject to arrest. The police officers when you go to the home, the police officer is going to request all keys and garage door openers to the home and from you so they can turn it over to the victim. You understand that?
Si usted va a la residencia o permanece en la residencia de la policía, usted podría ser arrestado. Cuando usted esté allí, la policía le va a pedir que le entregue a ellos cualquier llave o dispositivo que usted tenga para abrir el estacionamiento del vehículo con el fin de entregárselos a la víctima. ¿Comprende usted?
Sí.
Yes.
All right. As it relates to a bond,
En relación a una fianza.
state, what are the priors?
Your Honor,
¿Qué antecedentes hay?
I apologize, Mr. Interpreter. The defendant in this case has no priors, Your Honor.
Okay, he has no priors according to the state.
El acusado no tiene antecedentes de acuerdo con la fiscalía.
The bond request?
Your Honor, because the allegations in the arrest warrant include the breaking of the gold chain, the state would be asking for probable cause for criminal mischief in the amount of $0 to $200. And so for a bond amount for that count, the state would be requesting $100 bonds. For the battery, Your Honor, the state would be requesting standard bond in the amount of $1,000.
Su
Defense?
señoría, dado que hay un alegato de que se quebró, se rompió una cadena de oro, la fiscalía pide que se determine que hay suficientes indicios de daños dolosos en un monto de $0 a $200 y en relación al delito de fianza, pedimos que se imponga una fianza de estándar de $1,000. Defensa.
Judge, we are requesting pretrial services, just like Mr. LaRocha Hernandez, who Your Honor just granted pretrial services. Mr. Alvarez Hernandez has absolutely no priors. And for that reason, pretrial services is appropriate. And we are requesting pretrial services on the battery count and any other count that Your Honor finds probable cause for.
Okay, I did
Su
find
señoría.
probable, I'm finding probable, I'm sorry, you have to
Determino-
interpret, yeah, go ahead.
Determino, señoría, yo pido que se le permita salir a cargo de servicios previos a juicio, al igual que el señor Laroche Hernández, que usted acaba de permitir que salga a cargo de servicios previos a juicio. El señor Álvarez no tiene ningún antecedentes, por tanto, no tiene antecedentes, por tanto, pido que se le permita salir en relación a manos de servicios antes de juicio, en relación al cargo de agresión y cualquier otro cargo que pueda haber.
And Mr. Alvarez Hernandez does have a place to stay that is not the same residence where the alleged victim lives.
Señor Álvarez Hernández tiene un sitio en el que puede quedarse que no es la misma residencia que la presunta víctima.
Okay, I'm also finding probable cause for criminal mischief. I'm going to grant a bond of 1,100.
Determino
Standard bond.
que hay suficientes indicios de daños dolosos, por tanto voy a imponer una fianza estándar de $1,100.
You know, we don't have him in custody on any criminal mischief, just the battery.
No lo
Okay.
tenemos detenido por daños dolosos, solamente
Well,
el
that's
delito
fine.
menor de agresión.
I'm posting a bond of I'm gonna leave it at 1,000 just on the DV battery, not 1,100, 1,000 bond, but I do find probable cause for criminal mischief. The state can file an information if they choose.
Determino entonces que la fianza se queda en $1,000 en relación al cargo de agresión y determino que hay suficientes indicios de criminalidad para sustentar el cargo de daños dolosos y digo a la fiscalía que si ellos estiman conveniente pueden radicar una acusación en relación a daños dolosos, delito menor.
And that's straight bond, Your Honor?
Yes,
Y esto es solamente una fianza, juez, sí.
yes.
Sí.
All right, thank you. Thank you, sir. Good luck.
Gracias. Caballero, buena suerte.
Angel Andres Ordóñez. All right, sir, you're charged with domestic violence violation of injunction. Let me read the A form. Okay, I find probable cause for domestic violence violation of injunction. What is the bond requirement by the state?
The standard bonds for nonviolent first degree misdemeanor is $500, but as in previous injunction violation case, the state would be requesting $1,000 bond, given the fact that this is a violation of an existing court order.
And defense?
Judge, we're asking for TAP in this case. I think the arrest form makes clear that there's other things going on here that Mr. Ordonez, you know, has some mental health struggles that may have contributed to the allegations here. And I think TAP is appropriate with the stay away order. Again, this is a nonviolent allegation.
Your Honor, at this time, the state would still be asking for $1,000 bonds. The defendant has been previously instructed by the court to stay away from this victim. And the allegation in this case is that the defendant ignored that order. Meaning that I still believe an elevated bond would be appropriate.
The court agrees.
Mr.
Yeah,
Ordonez has absolutely no priors. So that is another fact in favor of a non-monetary bond.
Okay, the court.
He's unable to post any bond, so holding him with a monetary bond is tantamount to no bond.
Okay, the court, this could be addressed in regular court. Right now, at this point, I am going to issue a $1,000 bond. I did find probable cause for domestic violence violation. I am going to enter a stay away order. Mr. Ordonez, I'm going to read to you the stay away order. I just want to make sure that you understand it. Sir, you may not engage in any criminal activity, possess any illegal drugs, and you cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You understand that?
Yes, sir. Yes.
Okay. You must immediately surrender any firearms, ammunition, and or concealed weapons permit to the nearest police department and file a receipt with the court. Do you understand that?
Yes, Your Honor.
All right. You're prohibited from having any direct or indirect contact with the following persons, hereinafter referred to as a victim, Norma Ordonez. You understand that?
Yes, Your Honor.
You cannot have contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. You understand that?
Yes, Your Honor.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes, Your Honor.
Yeah.
Judge,
Yes,
my name is Norma. I am Angel's mother.
right,
Okay, I would like to say a few words. I know that
okay,
okay, my son right now, he's going to a mental crisis. He's suffers from mental bipolar disorder.
right.
I have put a restraining order on him because he had never hit me. He only verbally abused me,
All
but I
right,
wanted to teach him.
ma'am, first of all, let's swear you in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, go ahead.
So I am requesting the court that instead of releasing my son, that he needs to go to a mental hospital to get the help that he needs right now. Right now, he is in a mental crisis. I saw it yesterday. He's paranoid. He's hallucinating. He hasn't been with medication, no food, no nothing. His feet are swollen. I got a message from a hospital where he went to the ER to get treated. He has blisters and he has an infection on his feet. Throwing him on the street is not the right thing for him to do right now. He's just going to be a number there. I want him to get the right treatment, the medication he needs, the vaccine that he needs. He was on a vaccine. He stopped taking it in April, so it's been 2 months. That medication was keeping him balanced.
Okay.
So it's a totally different case. He's mentally ill. I feel that he's being, I'm not even, I know he violated the law, but that was
Okay.
desperate because he had to put his feet up. Look at his feet. Look at his feet. Look at him. I know he needs some mental treatment.
Okay.
He needs to be
Well, let me
transferred to a hospital, to a crisis unit where he can get that help. He tried to get help himself, and they didn't give it to him.
All right, let me hear from the state.
He's
All right,
been
ma'am.
he's been in and out of the streets
Judge,
for
if
the
I may.
past.
Yes, go ahead.
While I'm sympathetic to Mr. Ordonez's mother's concerns, this is not the forum for asking for any sort of mandated mental treatment. Your Honor is not allowed to do that under the law in a misdemeanor case. So I don't think there's any action that needs to be taken here other than the bond that Your Honor has already set.
Judge, I have tomorrow a Zoom with Honorable Judge Eloisa Correa at 9:30 in the morning in reference to the petition and trying to get in mental health. Is there any way?
Well, I
he doesn't even
can't, ma'am, I can't make a decision. If you have a hearing tomorrow, that's where you should address this, but let me hear from the state.
So something also that the victim should be aware of is that the defense attorney can make an appropriate motion to have the defendant released if there is a concrete plan for them to leave and get treatment. So this is something, and the bonds that Your Honor set can stay for now, and the defense attorney that is helping Mrs. Ordonez's son can file an appropriate motion later if there is a treatment plan and ask the court to grant that or grant leave so that the defendant can seek treatment pending these criminal charges.
All right, did you hear that, ma'am?
No.
Okay, the attorney for the defendant can file the appropriate documentation to get him relief and to get him help if that is what they're requesting. But she is defending she's there to defend the defendant. So it is up to the defendant and her to make the request. If you have a hearing tomorrow, the best place to address this issue would be with the judge overseeing the
Yeah,
case.
but the thing is that the judge wanted to hear his side of the story, and she delayed. It was supposed to be originally August 19th, then they changed it to September 2nd. because he was on the street. He has no phone. He has no money. He has nothing. How is he going to get to talk to the judge if he has nothing? He's just going to be thrown out on the street and
Well,
no
ma'am,
place to go.
ma'am, at this point, he's not being thrown out. There's a bond. He has to be able to post a bond to get out. If he cannot post a bond, he will not get out. So unless you pay for the bond, and the defense attorney said that he has no money, so he's going to be kept in custody until he goes in front of the judge. Unless
Okay.
he's able to post a bond. If you post a bond for him, then he will be released. But at this point, there's $1,000 bond that the court has placed. I do
Is
find.
there any way?
Judge,
if he's-
respectfully,
if
corrections
he's-
is asking me whether we're ready to move on.
Yes,
Mr. Ordonez's
ma'am, at this
son-
point, there's nothing more I can do. I do want to ask one question from you, ma'am. Does he live with you, or did?
Yes, he lives with me.
All right,
I
so,
am his only sole survivor. I am the
Okay,
only
all
person
right.
that he has.
All right, so I'm going to enter a stay away order that he's not allowed to return to the home. Sir, you may not return to the
Judge,
victim's
hold on one
residence.
moment. I think they released Mr. Ordonez and they might need to bring him back. I thought Your Honor already issued a stay away order in this case.
I did.
Your Honor, is there any way
If you could bring him
from
back.
the court? Is there any
Sir,
way
ma'am,
from the court?
ma'am, that there's nothing more I can do today. You understand?
Okay.
All right.
Okay.
Mr.
Thank you.
Ordonez is back, Judge.
All right, so, sir, since you do live with the victim, you cannot go back to the home. You can return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medications, personal and business-related paperwork and work tools. If you go to the home or remain at the home without a police officer present, you'll be subject to arrest. The police officer shall request any keys if you have them and any garage door openers to the house, and they will take them from you and give it to the victim. Do you understand that?
I do understand, Your Honor.
All right, thank you, sir. All right, now we're completed. Thank you.
Thank you. Thank you, Judge.
And Judge, Mr. Reyes Jimenez does require the services of the Spanish interpreter.
All right, thank you. Did I do the wrong?
Yeah, you get $1,000 bonds.
All right, did I put it on the wrong? All right, let me have it. Yeah, I got it. Okay. All right, let me put this here. Well, that's fine. Let's see what happens.
Yeah.
I did sign the, all right, thank you. All right, Mr. Manuel Belén Reyes Jimenez, that's you, sir?
Manuel Belén Reyes Jiménez. Caballero, ¿ese es usted?
Sí.
All right,
Yes.
give me, you're charged with one count of misdemeanor battery. It doesn't say it's domestic.
Se le acusa de un cargo de agresión a un delito leve, pero no dice que es violencia doméstica.
Okay. Let me read the arrest form.
Permítame leer el formulario de arresto.
Yes.
This time, Your Honor, the state would ask for probable cause for domestic violence battery. The parties in this case, the defendant and the victim, have a child in common, which would place them under the domestic violence statute.
La fiscalía pide que se determine que ha habido violencia doméstica, que hay suficientes indicios de criminalidad para establecerlo, porque la víctima y el acusado son padres de un mismo niño.
I do find probable cause for domestic for misdemeanor battery, domestic misdemeanor battery.
Determino que hay suficientes indicios de criminal para sustentar el cargo de agresión doméstica.
All right, state. Any priors?
Antecedentes.
Your Honor, so because Your Honor is found probable cause for domestic violence battery, under the domestic violence statutes, Your Honor is allowed to consider no actions priors or prior arrests for domestic violence crimes at the bond hearing. Your Honor, this defendant does have domestic violence aggravated assault with a deadly weapon prior from last year. There was no action. And Your Honor, the same victim in the instant case was the victim in that case.
So what do you propose?
In addition to that, Your Honor, there was the 2-year-old child in common of both parties was present for this incident. So, Your Honor, the state is requesting a $2,000 bond for the domestic violence battery in this case.
Okay.
Judge, defense.
Bueno, como este es un caso en el cual su señoría ha determinado que hay suficientes indicios de criminalidad para sustentar el cargo de violencia doméstica, delito menor, contexto de violencia doméstica, agresión, entonces su señoría puede tomar en cuenta incluso arrestos anteriores, aunque no hayan resultado en condenas. A este acusado lo acusaron el año pasado de violencia doméstica, agresión con agravantes, con un arma mortífera. Ese caso quedó desestimado. Y su señoría, dado que el niño de la pareja, de esta pareja que tiene 2 años de edad, estuvo presente durante este último incidente, pedimos una fianza elevada de $2,000.
Judge, the defense is requesting TAP with an alternate bond of $1,000.
Señoría, la defensa pide TAP con una fianza alternativa de $1,000.
As the state mentioned, Mr. Reyes Jimenez has absolutely no priors.
Okay.
Oh, I wasn't Judge, I wasn't done. I was just giving time for the interpreter to interpret.
Como dijo la fiscalía, el señor no tiene ningún antecedente.
Mr. Reyes Jimenez is not able to afford any amount of bond, so holding him on even a $2,000 bond is tantamount to no bond in this case.
El señor Reyes Jiménez no tiene fondos para pagar ningún tipo de fianza, por tanto, reteniéndolo a cambio de $2,000 es equivalente a retenerlo sin derecho a fianza.
There's no indication that Mr. Reyes Jimenez would not follow Your Honor's stay away order. So TAP is sufficient to reasonably assure the safety of the community and the other conditions.
No hay ninguna indicación de que el señor Reyes Jiménez no cumpliría con las órdenes de su señoría, por tanto, el programa TAP es suficiente para asegurarnos de que él va a comparecer ante cualquier otro proceso, en el proceso y también la seguridad de la comunidad.
All right, I'm going to issue a $2,000 bond. The fact that there was a felony, even though there was no process, I'm finding probable cause for domestic DV. The court can take that into consideration. And it was last year, and it was to the same victim. So I am elevating the bond to $2,000. I'm going to issue a stay away order from the victim and the victim's place of residence. Sir, I'm going to read you the stay away order. I asked to see if you understand.
Bueno, dado que ha habido, yo he determinado que hay suficientes indicios de criminalidad para sustentar el cargo de violencia doméstica, agresión. Por tanto, puedo tomar en cuenta arrestos anteriores, incluso si el caso fue archivado. Y en el caso, de hecho, fue un caso del año pasado con la misma víctima. Por tanto, voy a imponer una orden, voy a imponer una fianza elevada de $2,000. Caballero, le voy a leer una orden de alejamiento.
All right, I want to make sure you understand the conditions. So I'm going to ask for I'm going to ask you if you understand.
Me quiero asegurar de que usted comprende las condiciones bajo cual se encuentra en libertad pendiente de juicio y quiero asegurarme de que usted entiende.
All right, so you cannot engage in any criminal activity, you cannot possess any illegal drugs, and you cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. Do you understand that?
Usted no puede participar en actividades delictivas, usted no puede usar ni comprar ninguna droga ilegal, usted no puede portar, tener ni usar ningún tipo de arma de fuego, munición o arma. ¿Comprende usted?
Sí, sí comprendo, no, no fumo ni bebo siquiera tampoco, ¿no?
Yes, I understand. I don't smoke or drink even.
Okay, okay. You must immediately surrender any firearms, ammunitions, and or concealed weapon permit to the nearest police department and file a receipt with the court. That is if you have any of those. Do you understand that?
De inmediato tiene la obligación de entregar cualquier arma de fuego, munición o permiso para portar armas escondidas a la estación de policía más cercana y presentar una copia del recibo que le den allí al tribunal. ¿Comprende eso?
Sí, sí,
Yes,
sí lo entiendo.
yes, I understand.
Okay, you're prohibited from having any direct or indirect contact with the following persons, hereinafter referred to as a victim: Flor Saltos Cueraca.
A usted se le prohíbe tener cualquier tipo de contacto, directo o indirecto, con la siguiente persona a quien nos referiremos más adelante como la víctima: Flor Altos o Saltos Cueraca.
You cannot have contact, you cannot have personal contact in writing, by telephone, through social media, or other electronic means, or through third persons. Did you understand all that?
Usted no puede tener contacto con ella en persona, por escrito, a través del teléfono, a través de medios sociales, a través de dispositivos electrónicos o a través de terceras personas. ¿Usted ha entendido eso?
Sí, entendí.
Yes, I understood.
Okay, you must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Usted también tiene que permanecer por lo menos a 500 pies de distancia de la víctima, del hogar, el centro de trabajo, la escuela de la víctima en todo momento. ¿Usted comprende eso?
Sí comprendo.
Okay, since you do live in the same address, you have to leave the residence, so you may return to the victim's residence one time only within 48 hours of entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business-related paperwork, and all work tools. You understand that?
Dado que usted comparte el mismo hogar con la presunta víctima, tiene la obligación de marcharse de ahí. Sin embargo, se le permitirá regresar allí en un plazo de 48 horas a partir de que se expida esta orden de alejamiento acompañado con un policía, para que usted pueda recoger su ropa, sus pertenencias de salud, sus medicinas, sus documentos personales y sus herramientas de trabajo. ¿Comprende?
Entiendo, sí entiendo.
Yes, in
Okay,
English.
you need to understand that if you go to the home or remain at the home without the police, you will be subject to arrest. The police officers shall request all keys and garage door openers to the home from you and turn them over to the victim. Do you understand that?
Usted necesita entender que si usted va a esta residencia o permanece ahí sin la policía, usted podría ser arrestado. Y la policía le va a pedir a usted que usted le entregue a ellos todas las llaves que pueda tener de ese lugar y cualquier dispositivo para abrir el estacionamiento del vehículo, y le entregará esas cosas a la víctima. ¿Comprende eso?
Sí, comprendo.
Yes,
All
I
right.
understand.
Thank you, sir, and good luck.
Gracias, caballero. Muy buena suerte.
Gracias.
Thank you.
Your Honor, we need to take one out of turn. Is the last person on the calendar for DV. He's from Pretrial Detention Center, and I need to take him now.
Okay, what's his name?
Judge, it's Reginald Fleury-Nord. He's the last person on the DV calendar.
Judge, I do need a moment as we don't have the arrest form for that yet, so I would be unable to proceed at this time until that's provided to me. My colleagues are working on printing that now.
All right, so let's continue with the next person, and then we'll hear from him once you have the A form.
No, not tomorrow. Oh, okay. They're printing it now, Judge. If we could just hold on for a moment until it's printed.
Okay, what was his name again?
It's a write-in. It's Reginald Fleury-Nord.
I got it.
They're printing it for me. We're gonna proceed in a minute.
He has a pending case.
This is an added charge. He has a felony, a possession of a controlled substance with a bond of $1,000.
Okay. Yeah, here.
Yes, he has a warrant And it says no bond, and I gave you a date, I turn it over, so I gave you a date when you could set it for a report.
Okay, where? Let me see. Go ahead, show me.
Set it for a report on that date.
All right, so don't do anything now.
Give him, the no bond, because he said for, I think it's a arrest warrant for probation violation. Thank you. Maybe one, yes.
Okay.
And you can set it for that date that's on the file.
Judge, I'm having trouble hearing what is being said in the courtroom.
Okay, he's on a probation violation warrant. So at this point, the court is not gonna issue a bond. It's gonna reset the case to September 4th, 2025 at 9:30. He'll be held no bond until then, and then he could address the court on that date.
Did the warrant not have an amount attached to it?
It said no bond.
Okay.
Yeah. So at this point, the court is not issuing a bond. Reset to 9.
Excuse me, Judge.
Yes.
Good morning. My husband Guillermo Claure. I was supposed to go to the court today.
We haven't gotten to him yet, ma'am.
Okay, thank you.
Right. I put it on here, no bond. Thank you. Thank you. Thank you, sir. Good luck. All right, let's go. Continue in the order. Lee, Amand Lee.
And Your Honor, in this case, the state would actually be asking for probable cause for regular battery and not assault. Your Honor, the facts alleged in the arrest form, paint a picture of a battery, and not an assault.
All right. Is that Mr. Lee there?
Yes, sir.
Okay. All right, let me read the A form. Okay, I do find probable cause for a domestic battery, not assault.
Judge, I believe it would be a non-domestic battery. There's no allegation of a domestic relationship in the A form.
Let's see. It says here, Ahmad and on today's date and time, defendant Ahmad Lee and girlfriend of 3 years got into a verbal dispute. It
Judge,
does say
the
this the girl.
statute defines domestic relationship and it doesn't include girlfriend. It includes spouse, persons related by blood or marriage. I can go on, but judge, girlfriend is not included in the definition.
The defense is correct, and not Your Honor, so this time the state.
It's just a battery then.
That's what the state.
So I'm just gonna find PC for battery. All right, priors
This defendant has no priors.
and recommendation for bond.
The state would be requesting $1,000.
Judge, defense is requesting pretrial services. Mr. Lee does have a place where you can stay that is separate from the alleged victim in this case. Like the state said, he has absolutely no priors. So pretrial services with a stay away order is sufficient to protect the safety of the community and his presence in court. Pretrial services with an alternate of 1,000 is what the defense would be requesting.
Does he qualify?
And if Your Honor does grant pretrial services, the state is requesting.
Yeah, that's what was defense said. Does he have a place to stay? Does he live with the victim?
He does have a place to stay, judge, that is independent of where the alleged victim stays.
Okay, I'm gonna issue a stay away order also from the residence of the victim. So if he does live there, he would have to move. So I'll enter pretrial services. Alternate bond, 1,000. And a stay away order. All right, sir, I'm gonna read the stay away order to you. I'm gonna ask for to see if you understand. All right, so the first thing is you cannot engage in any criminal activity. Second, you cannot use or possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. And if you have any of those, you must immediately surrender any firearm, ammunition, and or concealed weapon permit to the nearest police department and file a receipt with the court. Do you understand that?
Yes, sir.
All right. Um, you are prohibited from having any direct or indirect contact with the following persons, hereinafter referred to as the victim, Eleanor Morale. Do you know who that person is?
Yes, sir.
All right. You can have a contact, including contact in person, in writing, by telephone, through social media, or other electronic means, or through third persons. You must stay at least 500 feet away from the victim's home and place of employment and or school at all times. You understand that?
Yes, sir.
All right. I'm not sure if you live in the same address that she does or not, but if you do, you must leave the premises that she occupies. You may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing. Okay, to retrieve your personal clothing, personal health item, medication, personal and business related paperwork, and work tools. If you were to go to the home or remain at the home without the police officer, you'll be subject to arrest. The police officer shall request all keys and garage door openers to the home from you and turn them in to the victim. Do you understand that?
Yes, sir.
All right, thank you, sir. I am giving you pretrial release, alternate bond of 1,000. Good luck to you. Yes, alternate bond 1,000.
Excuse me, Your Honor.
I'm
May I
sorry?
speak? Hello. Good morning, Your Honor.
Good
My
morning.
name is Maria Elena Dips. I am
Okay,
the
okay,
wife.
ma'am, wait until I call the case. All right. Okay, I'm calling Guillermo G. Clower, and ma'am, you need to wait until I call on you. All
Okay.
right, let me read the A form. All right, sir, you're charged with one count of domestic violence battery. The court finds probable cause for domestic battery violence. First degree battery. Um, who's the person that was speaking?
I am speaking.
And what is
I
your
am
name?
Maria Elena Dips.
Gibbs?
Dips.
Beeps.
Dips. DIPS.
You're the victim?
I am Guillermo's wife.
Okay.
I am not pressing any charges against my
All right,
husband.
well,
Please,
I
Judge.
I understand that, but at this point, he was arrested, so it's no longer it's the state attorney's,
But
decision.
if you can allow me, please.
All right, first of
I
all, ma'am, let me swear you in. Raise your, do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, what is it that you want to state?
I have been married for over 29 years now. I have 2 daughters with him. We have a happy marriage. This is a complete misunderstanding. My husband never touched me in a violent way. I am a survivor of breast cancer. He always take care of me. He always support me. I only have love for him. I want to ask you, Judge, please, to remove the restraint or any order because I did not press any charges, and I do not want to press any charges because I do not fear my husband. We live with my 28-year-old daughter. She is with me, and we will be with us at home. I want to kindly ask, please, Your Honor, to remove any restraining order. Thank you,
All right.
Your Honor.
All right, state, unconditional modified stay away order, what is your position? Does he have any other priors?
Your Honor, this defendant doesn't have any priors. This state would object to a modified stay away order at this time only because the incident happened yesterday. So
Okay.
the state's position is that there has not been a sufficient cooling off period between these two parties to do that.
Okay, and the defense?
Judge, I don't believe it's the state's prerogative to determine when someone has cooled off enough to determine whether they believe a stay away order is necessary. We heard sworn testimony from Ms. Dips that she wants her husband to return home, and Your Honor can enter a no harmful contact order, which allows the contact that Ms. Dips is requesting and just prohibits any harmful contact, which sounds like what is exactly appropriate in this situation. I don't believe the state should be able to override Ms. Dips herself, who is here, has provided sworn testimony to the court. And furthermore, Your Honor, I would actually argue that there's no probable cause based on Ms. Dips's sworn testimony to this court that there was never any violent touching committed by Mr. Clark.
All right, at this point, I'm not gonna dismiss the case. I did find probable cause based on the arrest form.
And Judge, to be clear, I wasn't asking you to dismiss the case.
Okay.
I was asking you to find no probable cause and release him outright.
No, the court's not doing that. I am granting, modified stay away order based on the victim's, statement that she's been married, I believe more than 20 years and that the defendant has no prior records of, or any arrest for abuse. He was intoxicated at the time, so at this point, the court is going to issue a modified stay away order. And let me read it to you, sir, see if you understand. You can, first of all, you cannot engage in any criminal activity. You cannot use, possess any illegal drugs, and you cannot use, purchase, possess, or carry any firearm, gun, weapon, or ammunition. And if you had those, you must immediately surrender those firearms, ammunition, and/or concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand that?
Yes, I do.
All right. Here. Now, you're allowed to have contact with the victim, but you are prohibited from being physically threatening or violent towards the victim in any manner whatsoever. Do you understand that?
Yes, I do.
All right, as it relates to a bond,
Your Honor, the state in this case would be requesting a standard bond in the amount of $1,000, and the state would hold fast to that. The state would object to doing pretrial services at this time, and would just ask for the $1,000 bond in lieu of requesting probable cause for additional counts, including disorderly intoxication here, which the state may well file an information charging at a later date. At this time, the state would just be asking for $1,000 for the domestic violence battery.
okay, I'm only holding him on domestic violence battery. You can file what, if you want to add an extra charge when you file the information. Go ahead, counsel.
Yes, Judge. Based on Ms. Dips' sworn testimony to this court that she is not fearful of Mr. Clark, that they have had a 29-year marriage that has been happy and that he has never physically harmed her, and in light of the fact that Mr. Clark has no priors at all, I believe that ROR is appropriate in this case, Judge. There's no danger to the community based on the alleged victim's sworn testimony to this court that he never physically harmed her and that they have had a 29-year happy marriage.
Okay, I'm not gonna do ROR. Does he qualify for pretrial? Okay, so no, I'm gonna issue a bond, the standard bond, 1,000.
Judge, sorry, did someone say he doesn't qualify for pretrial services?
That's what I got. Yeah, where it's indicated that he has no ties. She doesn't know where he's from or how long he's lived here.
Judge, you can still grant him pretrial services. Pretrial services would have to confirm that he qualifies and that he has an address. So we would ask for pretrial
Wait,
services.
stop.
If he's not from here, Judge, we cannot grant him.
Okay, so at this point, it's indicated that they cannot.
Judge, it's my understanding that he's lived here for more than 15 years. And like I said, Judge, it's not for us to determine whether he qualifies for pretrial services. You can grant him pretrial services, and then pretrial services can look into the issue of whether he qualifies. If he doesn't, he will remain on the bond, the alternate bond. And if he does, he'll get out on pretrial services. If Your Honor thinks pretrial services is appropriate in any circumstance, you should grant him pretrial services with an alternate of whatever bond Your Honor was going to issue. It is not our determination to make. Pretrial services makes that determination on their own.
And I'm hearing from corrections that, what was that?
It's been here more than a year, you can, if it's under a year.
Okay, but that could be determined, I mean, either way, it's going to be an alternate bond of 1,000. So if he doesn't qualify, it's going to be 1,000. So I'm going to enter pretrial services, alternate bond, 1,000. There you go. All right, next person. Thank you, sir. Good luck.
Yeah.
Merrick Walker.
Yes, sir. Good afternoon.
Good afternoon, sir.
Your Honor, he has a hold for immigration.
Thank you. All right, sir, you've been charged with domestic violence, assault, a second-degree misdemeanor. Let me read the A form, see if there's probable cause.
And Judge, I do have a probable cause argument on this case whenever
Oh,
Your Honor is ready.
Yes.
Sorry, if you let me know when you're done with reading the A
Yeah,
form.
I'll read it.
Okay.
I'm a little slow reader, so
That's fine.
bear with me. Okay, go ahead.
Sorry, Judge, I was looking at the wrong note. That wasn't for this case.
Okay. All right, so I find probable cause for domestic violence, assault, a second-degree misdemeanor. And bond, does he have priors?
The defendant has no local prior, Your Honor.
Okay, bond,
The state would be requesting bond in the amount of $500.
defense,
Judge, defense is requesting a bond of $1. Mr. Walker has an ICE hold, which means he's not going anywhere. So even if he posted the $1 bond, he'd be released to ICE. He would not be released back into the community. So no bond more than $1 is required to ensure the safety of the community.
okay, I'm gonna issue a bond for 500. Let's see. And sir, there's gonna be a stay away order. Do not engage in any criminal activity. Do not possess any illegal drugs. You may not use, purchase, possess, or carry a firearm, weapon, or ammunition. You must immediately surrender any firearms, ammunition, or any concealed weapon permit to the nearest police department and file a receipt with the court. Did you understand that?
Yes, sir.
The department is prohibited from having any direct, you are prohibited from having any direct or indirect contact with the following persons hereinafter referred to as the victim, LaCrevelle Brown, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Do you understand that?
Yes, sir.
Let me read this. Give me a second. What's the relationship between the victim and the defendant? Because,
Your Honor, it's not specified in the narrative on the arrest warrant.
so how is it domestic?
This is charged as a simple assault, Judge. The statute is not a domestic statute.
No, but it is, I apologize, counsel, but Your Honor is correct that it's the arrest warrant charges this as a domestic violence battery, but the state would stipulate that the facts of the arrest warrant will give rise to simple assault, domestic violence assault.
That's what I find. I don't see anything indicating here that he's related in any way to that would make it a domestic violence case. So I would find probable cause simply for an assault, a second-degree felony. I mean, a second-degree misdemeanor.
And that's the same statute that's cited in the A form, Judge. It is the simple assault statute, the second degree misdemeanor statute.
Right, but they put domestic violence on it, but it's just assault.
Right, but the statute listed is not a domestic statute, so.
Okay.
Statute.
All right, so for is the bond remain the same, or would that change?
Your Honor, based on the facts alleged, the state would maintain its request for $500 bonds, but Your Honor, just for transparency, to the court, the standard bonds for a second degree misdemeanor, in this case would be $250.
I'm going to change it to 250.
And for the record, Judge, because it's not a domestic case, the presumption is in favor of non-monetary bonds.
Right. Okay, I'm keeping it at 250. So not domestic. All right, thank you, sir. Good luck.
This one, or just like modify stay with it on that one? Modified stairway, it's just right, modified stairway.
Thank you. Jonathan Monteojino.
Your Honor, he has a hold for immigration.
He
Okay,
also requires the services of the Spanish interpreter.
okay, sir, you've been charged with 1 count of misdemeanor battery.
Ya verá, se le acusa de un
With,
cargo menor
with domestic violence.
de agresión intrafamiliar.
All right. I find probable cause for a battery. Is this a domestic battery?
Determino que hay suficientes indicios. Este es un caso de violencia intrafamiliar doméstica.
They did the domestic battery, Your Honor, and all under the jurisdiction of the domestic violence statute because the victim and defendant in this case were residing together.
Okay, that's the main issue that they were reciting. All right, I find
Your
probable.
Honor, the interpreter still is having difficulty hearing the state.
Okay, that is domestic, the state indicated that it was domestic because they were living together in the same residence. So the court does find a probable cause for domestic violence battery.
La fiscalía indica que es un delito de violencia intrafamiliar porque convivían. Por tanto, este tribunal determina que hay suficientes indicios de criminal de que ha habido violencia intrafamiliar.
Indication as to bond
¿Qué
priors.
se pide en relación a fianza? ¿Antecedentes?
Your Honor, the defendant has no priors in this case, but the state is requesting $1,000 bonds. And would object to pretrial services just based on the significance of the battery alleged here. Which includes facts in the arrest form that say that the defendant punched the victim with a closed fist in the face and then bit him on the upper right chest.
I'm gonna I'm gonna agree with the state, so I'm gonna issue a $1,000 bond.
Judge, I would object to you issuing a bond without being heard, without the
All right,
defense
go-
being heard. Just because
go
the
ahead.
state, just because the state says something is appropriate doesn't mean it is.
No, but I did
La
read,
fiscalía.
I read the A form and what I find appropriate is that what he's saying as it relates to the facts in the A form are corroborated.
I understand, Judge, but I don't think it's proper for you to make any determination without hearing from the defense first.
I apologize. I will hear from you.
Determino que le voy a imponer una fianza de $1,000 y sin derecho a servicios previos a juicio, por, como dice el fiscal indicó previamente que es el acusado le dio con el puño cerrado en la cara a la otra persona y posiblemente le hizo algo más en el hombro. Y en vista de todo eso, le impongo la fianza de los $1,000. La defensa alega que no se debe imponer una fianza sin escuchar a la defensa. El juez pide determina que eso es cierto y le pide excusas a la defensa y le permite a la defensa interponer un alegato.
The
Go
defense,
ahead.
the defense is asking for a dollar bond in this case, Judge. Mr. Montero Hino has an ICE hold, and I'm going to pause now, but just for the interpreter, I'm not done making my argument.
Sería, en este momento, pido que se le imponga al señor Montero Quino una fianza de $1. Él tiene una orden de retención por parte de las autoridades migratorias. Hago pausa ahora para la interpretación. No he terminado.
He has absolutely no priors that indicate that he would be a danger to the community. But even so, Judge, he has an ICE hold, so he will not be released back into the community. He will be released to ICE and then deported.
Señoría, él no tiene ningún antecedente, por tanto, no presenta ningún peligro para la comunidad. Él en este momento está siendo objeto de una orden de retención por parte de las autoridades migratorias, por tanto, quedará retenido y no presenta ningún peligro a la comunidad.
Any bond in excess of $1 is not appropriate in this case. And again, I would just reiterate that just because the state says a certain bond is appropriate does not mean that it is.
Y cualquier fianza por encima de $1 sería excesiva e incorrecta en este caso. Y el mero hecho, reitero, de que la fiscalía pida o diga que una cierta cantidad de fianza es lo correcto, por el mero hecho de que ellos lo digan, no es lo correcto.
Okay, I've been doing a few of these cases this morning, and I've issued a $1,000 standard bond when it requires it. And just because someone has an immigration hold, I'm not going to treat them any differently than I would any other defendant that is that is a resident. If I'm holding them with a $1,000 bond, I'm holding this individual with a $1,000 bond based on the facts that I read in the A form, which the state provided to me or reiterated, but, and I'm not going to read it again for the record, but I did read, there were substantial allegations in the A form that, for me to find that a $1,000 bond is appropriate. And again, I will not treat an individual that's not a resident any different than I would an individual that is a resident. So it is a $1,000 bond. I am going to issue a stay away order. Go ahead.
I believe you may need to
translate.
pause for the interpreter.
Yes.
He venido, en los casos que he venido manejando, en ellos se ha impuesto una fianza de $1,000 en casos semejantes. No voy a tratar a este acusado de manera distinta a las demás personas por el mero hecho de que tiene una orden de retención por parte de las autoridades migratorias. Si le impongo una fianza de $1,000 a un residente, no veo por qué no se lo debo imponer a este acusado. Y de hecho, y lo hago en base a los hechos que me explicó y me narró la fiscalía, que no los voy a reiterar aquí en este momento, pero que han sido corroborados de alguna manera. Yo pienso que los alegatos que está encarando este acusado son sustanciales y no estimo que es correcto tratarlo de manera distinta a cualquier otra persona residente. Por tanto, le impongo una fianza de $1,000 y le voy a leer el contenido de una orden de alejamiento.
Okay, sir, you need to understand that you cannot engage in any criminal activity. You cannot possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. Do you understand that?
Caballero, no puede participar en ninguna actividad criminal o delictiva, no puede poseer, ni usar, ni tener ninguna droga ilegal, no puede tener, portar, comprar ningún tipo de arma de fuego, munición o arma. Y si usted tiene cualquier arma o municiones o permiso para portar armas escondidas, tiene la obligación de entregar eso lo antes, lo antes posible, de inmediato, a la estación de policía que le quede más cercana. ¿Usted comprende eso?
You got to say yes.
Tiene que contestar
Yes.
sí.
Yes.
Yes in
Okay.
English.
All right. Sir, you are prohibited from having any direct or indirect contact with the following persons, hereinafter referred to as the victim: Jimmy Martinez Quintero, including contact in person, in writing, by telephone, through social media, or any other means, or through third persons.
Caballero, a usted se le prohíbe tener cualquier tipo de contacto, ya sea directo o indirecto, con la siguiente persona, a quien nos referiremos a continuación como la víctima, Jimmy Martínez Quintero. Se le prohíbe que usted tenga contacto con esa persona por escrito, en persona, a través de terceros, a través de medios sociales o a través de cualquier otro dispositivo electrónico. ¿Usted comprende?
Sí.
Yes.
You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Did you understand all that?
Usted también tiene que permanecer por lo menos a 500 pies de distancia de la víctima, del hogar de la víctima, del centro de trabajo de la víctima o de la escuela de la víctima en todo momento. ¿Comprende?
Sí.
Okay,
Yes.
since both of you live at the same place, you may return to the victim's residence one time only within 48 hours of release of the entry of this order or from the time of release, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. If you
Bueno, dado,
go ahead.
dado que usted comparte la misma vivienda con la presunta víctima, tiene que marcharse de ese lugar, pero se le va a permitir regresar allí en un plazo de 48 horas a partir de la fecha en la que se expida esta orden o que usted quede en libertad condicional, con el fin de que usted recobre allí sus pertenencias personales, su ropa, sus artículos de salud, sus medicinas, sus documentos personales o sus herramientas. ¿Comprende?
Sí.
Yes.
Okay. If you were to go to the home or remain at the home without the police, you will be subject to arrest. When you go to the home, the police officer shall request all keys and garage door openers to the home from you and turn them over to the victim. Did you understand that?
Si usted va a esa vivienda o permanece en esta vivienda sin la policía, usted podría ser arrestado y la policía le va a exigir a usted que usted le entregue a ellos cualquier llave que tenga de ese lugar o cualquier dispositivo que usted tenga para abrir cualquier estacionamiento de vehículos. ¿Comprende?
Sí.
Yes.
All right. Thank you, sir. Good luck.
Gracias, caballero. Buena suerte.
Did I give you the right one?
Yes, the next guy has two cases, Judge. One is a crimes case and one is a domestic violence case.
Okay, one is a battery and the other one is the.
The 19456 is for the crimes case, the 3 counts on that one.
Okay.
4 counts.
All right. Wait, let me ask the state, are we doing a stay away order from the same person for both cases, or is there any stay away orders needed from any other individual
Your
in
Honor,
those A forms?
all that the state has for this case, it would be the stay away order it's actually, for this case, there are 2 victims. It's Enrique Hartman and Javier Castro.
Okay, because I only have one for Enrique Hartman.
The case number is B25-19456.
I only have Enrique Hartman, and on the other one, I only have Enrique Hartman.
Is there, Your Honor, I know the state did fill out stay away orders for each.
Let me see.
We're in the files.
No, I don't have that many more. Here's what I have. Here, give it to me. This is what I have left. I have 2 Enrique Hartman, 2 for this case, for the 2 cases, and they're both Enrique Hartman, and I don't have.
Yeah. 19456, we got 2 cases and then 2 stairway orders.
For the same victim.
19456.
Yeah, so I need the stay away orders for the other person as it relates to whatever case it is.
If you send me one of those,
Sure.
the state will do the second one.
All right, I'm gonna be doing the domestic one first, so here, use this one. All right, sir, you've been arrested on 2 cases in case number M25019455. You charged, it says your battery, I'm not sure if it's domestic or not. It looks like the body indicates domestic, so I'll read it.
Okay.
See if there's probable cause. Then the other case, you're charged with 1 count of battery, 1 count of assault of a police officer. It's a misdemeanor, assault of a police officer, firefighter, or officer. A second degree, that's a first degree misdemeanor. A second degree misdemeanor of assault, and I also have a disorderly conduct and Miami Beach ordinance violation.
Yes, sir.
All right, so I'll be reading the domestic violence first, see if there's probable cause.
That's enough. Looking for the second victim in the case ending in 26 or 56.
All right, I'm finding probable cause for the domestic battery. Let me read the other case.
Judge, are you gonna set bond on this case before you address the other case, or?
Let me read the other one first.
I do have a probable cause argument on this case, so if you let me know when you're ready.
On where, on the second one or
second
the
one.
domestic battery?
The second one.
All right. Okay, what is your probable cause argument?
Judge, first, with respect to the second listed charge, assault of a police officer. Judge, the elements of assault include imminence and apparent ability to follow through on any threat. Neither of those things have been alleged in the A form. The allegation is that Mr. Alfredo told an officer he was going to kill her 3 times. There's no temporal element to that. And furthermore, Judge, this could not have been imminent precisely because there was no apparent ability to carry through on the threat. That's because at the time, Mr. Alfredo was in the custody of these officers in handcuffs and had no ability to do anything to harm these officers. So there's no probable cause for assault of a police officer.
State?
Your Honor, so what the arrest form says is that the defendant told Officer Azarian that he was going to kill her 3 times. The arrest form is unfortunately not specific about at which points during the interaction.
You want to reset it for tomorrow for the officers to come in?
Yes, Your Honor.
All right, so I'll reset this for. I'll reset the B 25-19456 for a probable cause hearing. And it'll come in tomorrow?
I give that to the crimes clerk when they come in, Judge.
Okay.
Go ahead and address the 5-5.
All right, so I'm gonna reset this tomorrow. We can hold the stay away orders till tomorrow on this one until it's heard. Reset, so that's 9-2, right?
Judge, sorry,
Yes.
I've spoken to Mr. Alfredo and we will waive the issue so that we can proceed today.
All right. Never mind. Okay, the court finds PC. All right.
This is the special order for that one, the B case.
Okay. And this is the only stay away order for this case? State?
For the B case, say.
For the B case, Your Honor, there was a stay away order from Enrique Martin, and there's a non-DV stay away order for Javier Castellano.
All right, and do you have the one for Hartman?
For Hartman, Your Honor, I believe that's the one Your Honor kept the copy of.
Well, I kept it for one case, but then I gave you for the second case.
I apologize for the confusion with that, Your Honor. They did not provide us any form for the first case, so.
No, I have, but wait.
Judge, if you wanna just, since the first case, the 19456 is crimes, I can hold that for the next calendar for the next clerk. Maybe I have to stay away order in that one.
Okay.
Just address for just a minute case, 19455.
All right, so on 19455, I do find probable cause. There was another stay away order I gave you. Do you have that? Did you tear that away or because this one is
The
19?
It was duplicated, I gave you two of the same one, but for 5-5 mistake and pass off the stay away.
Right, but I don't have that. Okay, so,
5-5, Your Honor, is the case that,
right,
yes.
okay, I have the B. I have that one, so I do need the one for 19455. I gave you the wrong stay away order.
And he'll pass one, just give him.
Yeah, just issue another one. All right. But it's the person's Enrique Hartman, correct?
A moment to confirm, I was able to get the arrest form after we arrived here. No, Your Honor, and it's good that Your Honor got that. The stay away order is gonna be for Brandy Albino.
Okay, so you'll write that up?
Yes, Your Honor, I'm doing that right now.
All right, let's address then B 25-19456. I'm gonna issue 2 stay away orders on that case, sir. And I don't think this is a domestic violence case.
That's correct, Judge.
That's because I have a domestic violence stay away order on that one, on the Enrique Hartman.
Case.
So that's wrong too.
We'll pass out, correct.
All right, so the first stay away order, sir, is on case number B 25-19456. You're prohibited from having any contact with the following named person hereinafter referred to as the victim. Javier Castellanos, that was the victim in that case with the assault, the battery, the assault on the police officer. So in that case, you're to stay away from Javier Castellano, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third person. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Also, electronic contacts such as emailing, texting, Facebook messages, or by Twitter is prohibited. Do you understand that, sir?
Yes, sir.
All right. All right, so there's another stay away order that's coming on this case.
And the stay away order, the second stay away order, Your Honor, is for the protection of Enrique Hartman.
All right, so it's going to read the same way. You're to stay away, and the defendant is you're prohibited from having any contact with the following named person, hereinafter referred to as the victim, Enrique Hartman, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third person. You must stay away at least 500 feet from the victim's home, place of employment, and or school at all times. Also, electronic contacts such as emailing, texting, Facebook messages, and or Twitter is prohibited. You understand that, sir?
Yes, sir.
All right. Let's see. Order from...
And Your Honor, the state is passing up that order right now, as well as a correct domestic violence stay away order for the case ending in 5-5.
Okay.
So that's the one you just read, and then the back is it.
All right. Perfect. And then we'll address bond after I read the stay away order on all three cases. I mean, all two cases. Okay, we can throw this out. Thank you. All right, and on case number M25-01-455, you're not to engage in any criminal activity. You cannot use, possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearm, ammunition, and or concealed weapons permit to the nearest police department and file a receipt with the court. Do you understand that?
Yes, sir.
The department, you're prohibited from having any direct or indirect contact with the following persons hereinafter referred to as the victim, Brandy Offend, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. You must stay at least 500 feet away from the victim's homes, place of employment, and or school at all times. You understand that?
Yes, sir.
Now, I know you don't live in Miami, but I'm
No,
going to
sir.
issue a stay away order from the victim's residence anyway.
Yes, sir.
All right. So the defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by the police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officer shall request all keys and garage door openers to the home from you and turn them over to the victim. Do you understand that?
Yes, sir.
All right. So now let's address the bond. All right, so I need the... All right, state priors,
It has no prior decided on these two open gate.
but he's not a resident of Miami-Dade County, right? So he doesn't qualify for pretrial release. All right, so what is the standard bond in this particular case? And if the defense wants to address bonds, I'll hear that before.
Yes, Judge, defense always wishes to address bond. Thank you.
Okay, that's, I figured. All right, go ahead.
Your Honor, I apologize, Your Honor, the defense wants to go first.
Let the
No,
defense go
the state
first.
should go first. I
All right,
believe
go
the state-
ahead, sir.
Your Honor, the state's requesting $1,000.
On both, for both cases or
For
the misdemeanor one?
For the domestic violence charge, the case ending in 5-5, the M25 case, the state's requesting $1,000.
Okay, let me hear from the defense.
Judge, the defense is asking for a $500 bond in this case. Not only does Mr. Alfredo not have any local priors, Your Honor noted he is not from here. He does not have any national priors either. That's why a bond of $500 is appropriate in this case, as well as a stay away order. There's no indication that Mr. Alfredo would not abide by a stay away order, and that can reasonably assure the safety of the community as well as the $500 bond.
All right, this is a domestic violence case, so it is gonna be $1,000 bond. What is the bond request on the other?
Your Honor, for the other case, the state will give this request count by count, but for the battery in the B25 case, the state is requesting $1,000 bonds. For count 2, which is the assault on a police officer, the state would be requesting $500 bonds. For count 3, the state would be requesting a $250 bonds, and for count 4 of disorderly conduct, the state would be requesting a $250 bond.
On the, so number 1, number 2, number 3. Assault. Okay, defense,
Judge, I would be asking for a bond that totals to $1,000 for this case. Mr. Alfredo has informed me that he would be able to post a $2,000 bond. Any bond in excess of $2,000 would be holding him tantamount to no bond in this case. If Your Honor would like a breakdown, I would suggest $500 for count 1. For count 2, if Your Honor is inclined to grant the standard bonds for counts 3 and 4 of $250 and $150, I would ask for a bond of $100. I think that's appropriate in light of the fact that there was a probable cause argument, which I know we waived, but I don't believe that the A form alleges an actual assault of a police officer.
okay, I'm gonna issue a $500 bond for the battery. $500 bond for the assault. And $100 bond, $250 on the second assault and $100 for the misdemeanor, for the ordinance violation. So that would be a total of 1,350.
And Your Honor, on the other case, you said a bond of 500, correct?
No, on the other case is 1,000. On the first one, M25 19455 is 1,000.
1,000.
On this one, the total is 1,350. All right, thank you. Thank you, sir. Good luck. We're almost done. All right, and the next one is Pedro Sevilla Gomez.
How you doing? Good afternoon.
Good afternoon, sir. You speak English?
Yes, sir.
All right, you were charged with domestic violence battery, first degree misdemeanor.
Yes, sir.
Let me read the A form.
Judge, I do have a probable cause argument. whenever-
Yeah, I figured, let me see here. Okay, go ahead.
Judge, this is charged as a domestic battery, but I don't see anywhere in the A form that alleges a domestic relationship.
That's what I was gonna get to, because I didn't see it either. State?
Your Honor, the state would agree that there are no facts in the forefront of the arrest form that give rise to a domestic violence relationship. However, the state would argue that there are facts in the arrest form that give rise to probable cause for regular battery, so that is what the state would be asking, Your Honor.
Yeah, and I agree. So I'm gonna find for simple battery. M1, no domestic. Priors?
Your Honor, the defendant in this case, only has a no action previous arrest, so the state won't read it for the purposes of.
Yeah, so there's no priors. No, I mean, no, he has no prior arrest. Was,
He does have a prior arrest. Your Honor.
right, but no prior convictions. And what do you propose as a bond?
So, Your Honor, even though the defendant in this case did not have priors, there are a couple factors that the state went to draw Your Honor's attention to for the purposes of determining a bond. One of those is the presence of a minor witness, a 17-year-old brother of one of the parties. The other factor that the state would have, Your Honor, to consider is the fact that the facts allege that the defendant grabbed the victim around the neck, and then dug his fingernails into her neck. So Your Honor, the state would be requesting an elevated bonds based on these facts of $1,500.
Okay, the standard bond for battery, simple battery is what?
It's $1,000, Your Honor.
For just simple battery?
That's correct, Your Honor. The standard bond doesn't vary for the domestic violence battery or regular battery. The violent first degree misdemeanor is $1,000.
And defense?
Well, first of all, I would just inquire as to where the state is seeing that one of the witnesses was 17 years old. I might be missing it, but I don't see that listed in the arrest form.
No, I didn't see it either.
So
It might be in the, it might be in the back, but I don't see it.
No, I don't see that. So I would ask Your Honor not to consider that because that is not a fact that we have.
Fine.
in front of us.
I'm not gonna consider that. All right?
Okay, and Judge, Mr. Sevilla Gomez has absolutely no priors. And in light of the fact that he has no priors, we would be asking Your Honor to grant him pretrial services. He does have a place to stay that is separate from the alleged victim in this case. So Your Honor can grant him pretrial services and issue a stay away order, which would reasonably protect the safety of the community. And I think that's appropriate in this case.
Okay, I'm gonna issue the standard bond. I did read basically what happened. There were more than just it was a violent attack, so I'm gonna find $1,000 bond. And I'm gonna issue a stay away order, sir. You do not engage in any criminal act. You cannot engage in any criminal activity. You cannot possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, or any concealed weapons permit to the nearest police department and file a receipt with the court. Do you understand that?
Yes, sir.
All right. You're prohibited from having any direct or indirect contact with the following persons hereinafter referred to as a victim: Jasmine Diaz, this includes contact in person, in writing, by telephone, through social media or other electronic means, or through a third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. You understand that?
Yes, Judge.
All right. It appears that you live together, so you may not return to the victim's residence one time. You can return to the victim's residence one time only within 48 hours of entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject you to arrest. The police officers shall request all keys and garage door openers to the home from you, and they'll turn them over to the victim. Do you understand that?
Yes, sir.
All right, thank you so much, sir. Good luck.
Thank you so much. Yeah, have a good one.
You too,
Your
sir.
Honor,
Yes.
I would like to address that stay away order with Pedro Sevilla.
Okay, I wish you would have spoken up a little sooner. Go ahead.
It's just that we have a daughter together, and he needs to be with his daughter. I don't want him to be without his daughter. I don't know what to do in this case.
All right, ma'am, when does this case go into division?
I don't understand the question.
No, I'm not asking you, mom. Ma'am, what is it? September 3rd.
Your Honor, but if the defense wants to, they can file a motion.
I can't hear the state judge.
He's saying that if the defense wants to, you can file a motion sooner. And at this point, given that there's children involved and based on what I saw in the A form, I'm not gonna issue a modified stay away order. I am having the defendant stay away from the home. You can file a motion with the court and have it heard earlier if you'd like, and have the victim present in court to address and modify the stay away order. But at this point, I'm not gonna modify the stay away order. I'm issuing it as is.
Okay.
All right, thank you. All right, next person, I have Yosbel Arguelles Arias.
He has a hold for immigration.
He also requires the services of the Spanish interpreter.
Go ahead.
Present. Él tiene una orden de retención por parte de las autoridades migratorias.
All right, let me read the A form.
Permítame leer el formulario de su arresto.
Okay, I found probable cause for domestic violence, battery.
Determino que hay suficientes indicios de criminalidad para sustentar el cargo de agresión intrafamiliar.
All right, so, issues on bond.
Temas de fianza.
Let me ask the state, does he have any priors?
Permita preguntar a la fiscalía, ¿tiene antecedentes?
The defendant has no priors in this case, Your Honor. However, the state would be asking for an elevated bond, considering the facts of the arrest form say that the defendant struck the victim multiple times with punches and slaps against her will. And I'll let the interpreter translate, and then I will tell Your Honor the bond the state's requesting.
Señoría, este acusado no tiene antecedentes pero la fiscalía pide una fianza elevada en vista de los hechos que se alegan en el formulario de arresto, incluyendo que el acusado se alega que le pegó varias veces con el puño cerrado a la víctima y también la abofeteó en contra de la voluntad de ella. Voy a hacer una pausa para que el intérprete interprete.
Okay, what is your proposed bond?
The state's requesting a $1,500 bond.
Okay,
¿Qué propone en
and
relación a fianza? $1,500 de fianza.
defense?
Defensa.
Judge, I'm asking for a $1 bond. I know Your Honor has said you're not going to treat people differently, but I think the
Yeah.
fact that someone has an ICE hold is entirely relevant to what level of bond is necessary to protect the safety of the community. I'll let the interpreter interpret.
Señoría, yo pido una fianza de $1. Yo sé que usted, su señoría, ha dicho que el hecho de que la orden de retención por parte de las autoridades migratorias no debe importar a la hora de fijar fianza, pero yo pienso que es un elemento muy relevante en términos de lo necesario para proteger a la comunidad.
So Mr. Arias will not be released back into the community, which means that a $1 bond is appropriate and that a $1,000 bond, let alone a $1,500 bond, is not necessary.
Okay, I'm not gonna issue a $1,500 bond, but I will issue a $1,000 bond for the
Una
same reason.
fianza de $1 sería suficiente y una fianza de $1,500 sería excesiva y también una de $1,000. No voy a imponer una fianza de $1,500, contesta el juez, pero sí le dicto que determino que la fianza serán $1,000.
Okay, sir, I'm gonna read a stay away order. I want to make sure you understand it. You're not to engage in any criminal activity and you cannot possess any illegal drugs. You cannot use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. If you have one of those, you must immediately surrender any firearm, ammunition, and any concealed weapon permit to the nearest police department and file a receipt with the court. Do you understand that?
Caballero, le voy a leer una orden de alejamiento. Me quiero asegurar de que usted entiende los términos de la orden de alejamiento. Usted no puede participar en ninguna actividad delictiva. Usted no puede comprar, portar o tener ningún tipo de arma de fuego, municiones. Si usted tiene armas de fuego, municiones o permisos para portar armas escondidas, está obligado a entregarla de inmediato a la estación de policía más cercana y presentar una copia del recibo que le den allí al tribunal. ¿Comprende eso? Yes.
Okay. You're prohibited from having any direct or indirect contact with the following persons here and after referred to as the victim, Rafaela Morales, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through a third person. Do you understand that?
A usted se le prohíbe que tenga todo tipo de contacto con la siguiente persona, a quien nos referiremos de aquí en adelante como la presunta víctima. Se llama Rafaela Morales. Se le prohíbe a usted tener contacto con ella en persona, por escrito, a través de medios sociales, a través de dispositivos electrónicos o a través de terceras personas. ¿Usted ha entendido eso?
Sí, correcto.
Yes, correct.
Okay. You must stay at least 500 feet away from the victim's home, place of employment, and school at all times. You understand that?
En todo momento tiene que mantenerse por lo menos a 500 pies de distancia de la víctima, del hogar, el centro de trabajo o la escuela de la víctima en todo momento. ¿Comprende?
Correcto.
Correct.
All right. You may return, since you live in the same address, you live together, you may return to the victim's residence one time within 48 hours of the entry of this order, accompanied by a police officer to retrieve your personal clothing, personal health item, medication, personal and business-related paperwork, and work tools. Do you understand that?
Dado que usted comparte el hogar con la presunta víctima y no puede volver allí, usted se le va a permitir que usted regrese ahí en un plazo de 48 horas a partir del momento en que quede en libertad o que se dicte esta orden, para que usted regrese allí acompañado por un policía para recoger sus efectos personales, su ropa, sus artículos de salud, sus medicinas, sus documentos personales y sus herramientas de trabajo. ¿Comprende?
Comprendo.
I understand.
If you were to go to the home or remain at the home without a police officer, you will be subject to arrest. A police officer shall request all keys and garage door openers to the home from you and provide it to the victim. You understand that?
Si usted va o permanece en aquella vivienda sin la policía, usted podría ser arrestado un policía le va a exigir que usted le entregue a él o a ella cualquier llave que tenga, cualquier dispositivo que tenga para abrir el garaje. ¿Comprende usted?
Comprendo.
I understand.
All right, thank you, sir. Good luck.
Muy bien, caballero, muy buena suerte.
All right, I have David David Calendario Rubio.
Your Honor, he's awardee. We need to reset it for tomorrow.
All right, reset. And I have Latoya Hyman. And this,
Your Honor, we don't have anybody else.
oh, this was a write-in apparently.
We weren't notified about that, Your Honor.
All right. Let me see here. Here, you can look at the file.
It's been reset since August 30th.
Okay, so she's not here? All
No,
right, so-
we're not advised that there was another write-in.
Reset since August 30th.
Yeah, it's been reset August 30th to August 31st, reset August 31st to September 1st. So she's not there?
No, Your Honor.
All right, reset again to September 2nd. There you go. All right, so we're done with the domestics. And I have to go to juvenile at 1:30. So do you want to get started on you want to take a break for like 5 minutes or?
Recording stopped.
We're ready to go when the clerk gets there, Your Honor.
On the what? On the criminal?
For misdemeanors, as soon as the clerk is there, we are ready to go.
Yeah, we're
Okay.
ready, Judge.
Your Honor, Joanne Hennessy for the City of Miami
Recording
Beach.
in
I'm here for the
progress.
jail arraignment calendar.
Okay.
And if I could be made a panelist, Your Honor, good afternoon, Attorney Orlando Rodriguez here.
Okay, let me see.
Oh, I already took care of it, Your Honor.
Good, thank you. I knew you were there somewhere. Thank you.
Mr. Rodriguez,
Is that person that we reset on in Ward D? Clerk? The preset, okay, perfect. Here you go. Nice seeing you. I know, it looks that way. A lot of DVs, a lot of reading of.
But DV is the whole lot. Once you get past DV.
Yeah, let's take,
The stairways, that's.
Yeah.
Yeah.
yeah, let's take a 5-minute break real quick. And
I
then,
just text the clerk, so they're coming from this.
all right, so let's wait for the clerks to get.
Recording stopped.
That's what I'm telling you. So when they come, they can set up and you can start.
All right, so I'm gonna take a break.
Judge, if
I'm
I
taking
may
a-
just ask, Judge,
Yes.
how long are you leaving for at 1:30? We have 40.
I apparently I only have one juvenile, so depending how quickly, if I see we're getting to the end, I'll finish the misdemeanors and then go over
Okay,
there,
because
but.
we have more than 40 misdemeanors and more than 60 felonies to still do
Right.
here.
Right, I understand, but. All right. All right, let's take a break until the clerk gets here.
Mr. Rodriguez, I just wanted to inform you, this is a video, by the way. We're going to begin the misdemeanor traffic calendar. So felonies is after that calendar.
Thank you so much, Your Honor.
Thanks for letting me know. I appreciate it. I'll hang around here and turn off the video, but thanks for the heads up. I thought he was doing felonies next.
Oh, yeah, sorry.
Okay, no, thank you.
So how did you get on that? No, I was touching felony.
How does a private counsel get access to the arrest reports these days on a weekend bond hearing?
That's why I told you.
You know, I'm not too familiar with the process, but I think you can just ask the state.
Yeah, he's asking if there's a breakout.
Let's get it over.
We'd have to call correction. Oh.
No, for real. Gino. Yeah, I don't know if they have. Probably not. I don't know. I don't know if they have a breakout of the corrections, but we just finished, and like I told you, it's almost 60 something, 50 something, or it's gonna be a lot. No, maybe taking up our dinner break, but to be realistic, it's gonna be probably 3, 4, or 5 o'clock before. So, find the moderation. Most of the time. Yeah, like.
I hear you.
Yay.
Oh, yeah.
Okay. Oh, okay.
You got it.
Okay. So there's a lot. So go ahead.
Appreciate it.
Thanks, sir.
You should have hired me before.
Yeah, you're probably good. Because it's not over right now. They didn't pull them yet. They ain't pull them yet. I mean, no, they ain't pull them. I don't think they pulled them yet because Mr. Leonard's gonna be. They might have, I don't know, I'm not sure. I don't have the number over there. Give me a second, let me get back to the office. I'm gonna call corrections and then I'll let you know, okay? Yeah, because I want them to take it out of order too for you since you've been here so long. Picked it up. Whatever you want. Okay, all right, and I'll call you when I get up there. All right. Okay, fine. Okay, bye, sir. I'll read something that's.
Does you need to use the bathroom or anything?
Thank you for being patient with us.
Well, before.
They were still doing the felony packets when I went up to juvenile, and we usually get a packet for that. The last time I was here, I think that TCF is the one who hands them out, but they didn't have them today.
Yeah.
It is, but to be honest with you, because it's Labor Day weekend, I'm a little surprised that it's not more. It's still a lot, but.
I remember doing this. Yes,
Did you do county or domestic violence when you first started? Okay. Justin is in county, I'm in courthouse center and the domestic violence division.
She's a large girl.
Yeah, she was, I was on the, she's a great judge, she oversaw mental health court for a little bit when we still had it, and I was one of the ASAs on it, so we. Maybe every Thursday or every other Thursday at least, she would provide over that calendar and it was fun.
Is it only county court that does these? Not felony, right? When I was in town, it was only county doing.
Yeah, I think you can still do it as a felony ASA if your name is still on the list. If unfortunately you just moved up, but you were placed on a list while you were still a.
I heard you got your.
County ASA.
Yeah. I think front
and for a while, they've removed juvenile as a stepping stone, so now it's its own starting point, but.
Okay.
For a while, you would still do it even after moving on
here.
county or county or domestic violence.
Captain came there and he was like, yeah. Or you gonna be here, go there, like, it's a waste of manpower.
I was curious about doing it, so I would have preferred that they did it as a stepping stone, just to enjoy learning how to handle those types of cases. When we come here for weekend once and do the juvenile calendar, I have no idea what's going on.
He came here, and he was like, I got a person standing as soon as. I got one before the max, one after the max, and then he said that's something he was doing. Yeah, that he had people there.
Okay, well, things like that, they told him to do it.
Nah, that's something he's doing.
Okay,
Get that because. One time. Pass.
Well, we definitely appreciate your understanding, that's
Surely he was at the first floor.
it is a lengthy process.
I would be just looking downstairs. So I had this one. So it was like, you went through and the switch it back. Basically, this shit glass on. I said, all right, I went out to my car.
So you, the judges only have to do it once a year.
Yeah, you know, once a year.
Okay.
This is why. You're supposed to. So I was like, wait, I see somebody walking in, let me see if they're like with court service. So I know I haven't done this since like cheap glass. Yeah. I go up, I'm like, what's up, chief? Do you work here? Yes, yes, I do. He's all because there was nobody else, so this school just dealing with the 34. I heard you used to be a major here. You know how hard it is.
Which when you ready to say which felony division did you?
He's like, oh, is everybody okay? Yes, everybody's okay, we're dealing with 34, but you're asking why you didn't see nobody down here. I mean, the judges have all chose, so you would know who they are. Right, then there Jason was coming next, that's so Jason said the top one, so I called or a little bit on me. But, before like that, it was like almost something. I was a division chief for like 3 years there. Yeah. What's that? It was. Yeah, I still you know, to the west side of the house where I get parts of the see it? Parts of part of how way is my gun came? Yes, that happened. And he just happened to come in as I'm going. I have a serious because of that. Oh, October 1st. Yeah. I just went up this.
They didn't say anything.
No, because
That's a story.
I couldn't invent because when he came, when he came, everybody was with. With glass belt. Everybody, he was tripping, his fucking down, it was. So as I come in, I got to, you know, they want to give us $1,000. I was like, hey, I don't know.
Honestly, I used to all the cases honestly. This
so, yes, sir. Oh, I found one. I found one. They don't let him down this line. All the other cars, and I remember just doing all those people. Stop praying on fire. You have South Spain on? Went on there and fall back. I'm not so well.
He came to. Sorry.
You know, you actually said this one is like also is down. You know, like the fake news, yeah, I'm saying this also for all these about level advertising and they see like 1,000 or like. And then last year, the people here was that and then being huddled. They're out of here. Literally,
Bro, you know, 235 told us, so you know, 234 right now. Just think, you know, 41. So it's very fun to see. Everybody fine.
it was fun, actually, really.
Yeah. We just walked around. You want to make an offer on something?
Okay, yeah, I would feel, I've never done that before, but this is our county ASA, because I'm in the third thing. You wanna close out some of them today?
I mean, if you know you owe. No, yeah, that's fine.
Oh, this is supposed to be. I'll let you do this. You don't have to go. Yes, because you have.
No, I'm not. You need something?
No, it's okay, just moral support.
Oh,
That's
your
all.
child?
Tomorrow's a trial day, it's just a lot of heavy lifting, like she does traffic trials.
Right.
DUI trials, and then DUI soundings, so. It's a lot.
The main thing is she's gonna be late on the soundings.
Those aren't
Okay.
happening till like, yeah.
Yeah, is there anything definite on your soundings? Or you- No, okay, so don't worry about it.
Yeah.
Don't worry about it. Concentrate on the items. Forget about that. And the main thing is don't interrupt her. And the other thing is do you have anything that's definite, like, on your offers or anything like that?
Right, I need to be sure about that.
Yeah,
That's what I'm checking.
that's key, because as soon as she says, oh, it's there, or you can go at the beginning and go, Judge, I have all these. Right. You get that off of your head, those early on, your calendar's all of a sudden getting smaller.
Right, nice and quick, a lot quicker at that point.
Right, and remember this too, it's tough, but she depends on you a lot. For guidance.
Let me tell you.
You're feeling it now, right?
I think, because you've seen my rotation, so I've had very different experiences.
Yes, it's not a Nunez.
Yeah.
I'm sorry.
There we go, yeah.
Yeah.
I welcome it at the same time, but also.
Yeah, it's a slower gear, but you got more work on your end.
Right, I gotta be able to bring it to her.
Here's the thing, get in there, 9 o'clock, be ready to go.
Yeah.
If you do that, you win points with her.
Right.
And Felipe too. Now, remember this about Felipe tells the judge everything. Okay, so what he sees and hears, coming up.
Yeah.
Okay, worst thing he hates is you show up at 9:30 for start checking in witness.
You guys know your microphone's on?
No, we don't, but.
You weren't having fun listening to us?
Yeah.
Not at all.
Okay, so,
You have TPOs for the people or?
they always.
Your Honor, they are all. They're after every single case in the stack, so if it works for you, then we can pass them up as we crack the case.
Any stay away with
Judge,
That's.
I'm sorry, is that the judge?
Yes,
I'm concerned that there's some ex parte communication happening right now.
No, I just wanted to know if there was TPO. If they had a TPO.
I'm just a little unnerved by the fact that Your Honor was just had an extended private conversation with the state.
There was no.
That wasn't, that was, no.
No.
Your Honor.
I was in the bathroom and I just came back. Yeah.
Hi, this is Marcus, I'm the clerk.
Recording
Me and
in
the state
progress.
attorney, we're both in the same courtroom. It's not a case on calendar, it's not a case for today. We're just talking about our court during the week.
Yeah, I was in the bathroom, so I don't know what was discussed. I just came in and I asked if there were TPOs for the traffic cases. To make it easier to review. All right, so. Can you guide me on this, how this one? This is the clerk,
Yes.
is this the calendar?
This is the calendar, yes.
All right, so, but this is the files, right?
Yes.
So this is, and this is what,
I can hand these up to you.
those are the priors, right?
Priors,
Or
yes.
the TPOs, or you don't have the TPOs, okay,
No, TPOs are for traffic.
okay, and are we doing okay, the traffic has,
The misdemeanors.
got it,
And then you're gonna have females,
okay,
and then we'll have regular traffic after that.
got it, all right. All right, let's see how much we can get before I have to go down. Maybe I could get through the misdemeanors before I get to the traffic.
The misdemeanors and the traffic are together, Judge.
Okay, well, let's see how far we get. All right, we ready to proceed?
Yes.
Have the defendants been sworn in?
Have the defendants been sworn in?
Judge, they were all sworn in at the beginning of the day.
All right, perfect.
They're PD appointed on all cases?
Yes, temporarily appointment until there's an affidavit filed.
La Defensoría Pública se nombra para que represente a todos los acusados y pendiente la declaración jurada.
Where do you want me on these, to write the,
Yes, this is a new misdemeanor A form.
right,
Okay, you'll be writing all the recent information here.
okay,
Okay, if they're homeless, you can set them with an ROR on this calendar.
okay,
Okay, if you close it out, that will be at the top.
okay. So,
Paper file, you'll be, there's a history.
yeah, there's, that one I have no problem. It's just these here. All right. Yeah, there is ready?
We're ready, Judge.
All right, well, let me go to do the
They don't have it
juvenile.
here.
I'd rather just get the juvenile out of the way. It's only one case and I'll be quick and I'll be back and then we'll get started and finish on this. So let me take a break on this and I'll go do the juvenile first.
Recording
Oh, yes.
stopped.
Thank you.
Recording in progress.
All right. We're missing corrections.
They're here.
All right, but don't I need one here?
No, they don't, on our session, the pretrial people, they don't come, but if you need to order some of them pretrial, you can.
Okay, so we're good to
Yeah,
go.
we're good. We
Oh,
can start.
perfect. That's all I want to know.
Yeah.
All right, we're ready. All right, first case is Priscilla Smalls. This is misdemeanor, second degree alcoholic beverage, drinking in public, and first degree misdemeanor, resisting an officer without violence. Let me read the A form. Okay, I find probable cause for the resisting without violence. Is there any, what does the state want to do with, the alcohol beverage?
Your Honor, we just ask that, the case be set at standard bond for both charges.
Okay, so okay, so I also find probable cause for the alcohol beverage or drinking in public. Does she have priors?
No, Your Honor.
Is she homeless?
No, Judge.
Does she qualify for pretrial?
I'm not sure what Your Honor means by qualify. She has an address
Okay.
locally. So,
Alright.
but pretrial services will make that determination if Your Honor grants pretrial services.
I have a
Go ahead.
Has she lived here longer than 1
Okay.
year?
Has she
Judge-
lived here longer than a year?
Yes, Judge. But before Your Honor gets to pretrial services, I would just remind Your Honor, I know the state requested standard bond. I would remind the state and Your Honor that pursuant to Florida statute 907.041, it is the intent of the legislator to create a presumption in favor of release on non-monetary conditions. Judge, I'm not sure why Your Honor would be inclined to grant pretrial services instead of ROR. These allegations are entirely non-violent. Ms. Smalls has no criminal history whatsoever. ROR can reasonably assure the safety of the community and her presence
Go
in
ahead.
court. Sorry, Judge, what was that?
No, go ahead.
What was that a response to my argument?
No, go ahead.
Oh, okay. I'm not sure how pretrial services achieves any of those conditions more so than ROR, Judge. If there's any candidate for ROR, it is Ms. Smalls with absolutely no criminal history and entirely non-violent allegations. That is the starting point is non-monetary conditions. I'm not sure why the state is requesting monetary bond, but ROR is entirely appropriate in this case.
State?
Your Honor, once again, the state would just be asking for a standard bond.
Okay, I'm gonna ROR. As long as there's no priors, correct?
Correct, Your Honor.
And that's for both counts, Judge?
Yes. All right. Terry Marie del Cansandro.
Your Honor,
is,
Joanne Hennessy for the city of Miami Beach.
Okay, and she's charged with camping on a prohibited, in Miami Beach, which is prohibited by county ordinance or by city
By
ordinance.
city ordinance, Your Honor.
Yes. She's homeless. Yeah, I find okay, state. I find probable
Your Honor.
cause. I find probable cause for
And the
camping.
standard bond is 150. I'm not sure how long Ms. Delta Sorando has been in the area. So it does appear that she's homeless and I don't see any local priors.
Okay. No,
And
but no
Judge-
prior. Yes, go ahead.
Again, I understand that there is a standard bond, but the Florida legislature has made it clear that the presumption here is in favor of non-monetary bond. Miss Del Tassandro was arrested for sleeping in public. That is entirely non-violent. She is
Mhm.
homeless and ROR is appropriate here. There's no indication
Well, has she
whatsoever
been,
that
she's never been, she hasn't been arrested before on this issue? Because the
Nope.
A form indicated that. Let me see. She indicated she was arrested in the past for it, so that's why I ask.
Yeah, and
But
there's
there's
a
no
diff-
priors, there's no priors.
but it does say here that she was arrested in the past. I don't see this case number. This is not a case number. This is
Okay, I'm gonna issue an ROR.
On this calendar?
Yes, and ma'am, since you are, you need to appear on October 1st at 8:45 a.m. in courtroom 6-8 of this building, the courthouse. What's the address here?
1351 Northwest 12th Street.
1351 51
West
Northwest
Street.
12th Street.
Yes.
Okay, so you need to appear, or an arrest warrant will be issued for you, or a bench warrant will be issued for you. So you need to be here October 1st, 2025 at 8:45 a.m. in courtroom 6-8. This is the only notice you will receive. You understand?
Yes, I do. Is this TKG or TGK?
This is TGK. This is gonna
Okay,
be in the
could you write
Richard
that
E.
on there?
Gerstein. It's here. I'm
Okay.
writing it down for her, Judge.
Correct.
Thank you.
All right, thank you, ma'am. Good luck. Ana Guadalupe Thomas, trespass property after warning. She has an open case. She has two open case. She has two open cases, correct?
Yes, Your Honor. Just two open prior trespass.
All right. Let me read this. Okay, I find probable cause. I'm issuing a stay away order. Hey, ma'am, you're to stay away from the McDonald's located at 2300 Southwest 87th Avenue, Miami 33165. A violation of that will be an arrestable offense. Priors, well, obviously she has two open cases. Would this violate her pretrial, her release status in the other cases?
From my understanding, yes, Your Honor.
Okay. I'm issuing, holding her no bond until she gets in front of the,
Judge, she has two bench warrant, Judge M25 12950. She's in custody on that. And also M25 13962, Judge. And both.
all right, go ahead. Go ahead, what were you saying? I apologize.
Correction, Judge, Miss Thomas has a bench warrant. The case number is M25 12950. The bond in the amount is $150. Also M25 13962. The bond in the amount is $150.
Okay, all right, so I'm holding her until that case comes up and when will she be
Judge,
heard on that case?
If I may, Judge.
It's
Yeah.
on calendar, Judge.
Okay,
Judge, first of all, the fact that the bench warrant was issued in the amount of $150 means that the judge who issued it found that that was the appropriate bond for this case. I would object to you holding her no bond.
well,
The
but
judge has already spoken by
okay, wait,
issuing a $150
wait, ma'am, address the fact that she was on either release, ROR release or on a bond or something, and then she commits a crime while she's pending two other cases. Isn't that enough to hold her until the judge hears that case?
Your Honor, I mean, you could hold her no bond, but I don't think that's appropriate given the allegations in this case. It's a trespass. This is a misdemeanor. It's entirely nonviolent. We're gonna hold someone in jail no bond for a trespass.
I'm holding her no bond until she can go in front of the judge on the other cases. It seems like the other case. Let me see what else.
If you go to record, Judge, should let me know which one of the cases you want to hold her bond.
All right,
M25
give me a second.
And Judge, I will just say that I work my normal division is the jails division, and
Right.
Judge Correa usually defers to the bond that was set at first appearance, so it's not the normal practice for someone to be held no bond initially at first appearance. On a
No,
misdemeanor.
it's not no bond on this case. I'm holding her on the other two until she goes in front of the judge. I'm gonna issue a bond on this one. What's the standard
Okay,
bond on
I'm just
this?
telling you that's not the normal practice in the jails division in county court to hold someone
Okay,
no bond on a
alright.
The new
misdemeanor at
case,
first
Judge,
appearance.
it's bond 500.
Okay, I'm issuing a bond of 500 on the new case. I'm finding probable cause, $500 bond. On that case, and a stay away order from the McDonald's. That's that. And then on this one, let me see, let me have that real quick for a second. And let's see, let's look at the case number M25-12950. She was issued a stay away order. Can I have the stay away order I just signed?
Yes.
She was issued a stay away order from 2300 Southwest 87th Avenue, Miami, Florida 33165, which is the same stay away order she received here. Let's look at the other case. In the other case, and that's M25-13962, she was issued a stay away order from
Judge,
a
our
different property.
Wi-Fi has stopped working. You've cut out
Okay,
completely.
so on the other case, she was issued a stay away order from a different property, but on, that's on M25-13962, but on M25-12950, she was issued a stay away order from the same place she went to now and got arrested for it. And now we have a second stay away order, so I'm holding her no bond until she gets, and then the judge could address her bond status on the other two cases when they go in front of her in jail division in 2 days. But for now, she'll be held no bond on those other two cases. Thank you. All right. Macania Harker.
Your Honor, Joanne Hennessy, for the city of Miami Beach, for the new cases.
Okay, so she's charged with camping on a prohibited, camping in Miami Beach, prohibited, which is prohibited by county ordinance, 1 count. And entering a park after hours, also a violation of county ordinance or city ordinance, not county ordinance, I apologize. And then there was a bench warrant on the other case, and let me just see what the arrest was for that. And that has an information.
It's for petty theft, Your Honor, and trespassing.
Okay. All right, and, all right, so she has a whole, is there a bench warrant in that other case or? No,
There is, Judge, but I'd like to address the bench warrant.
all right, I got it. All right, and that's case number 2020, M25007950. How much is the bench warrant for?
It's showing your own hands.
I think it's for $200, Judge.
$200.
But Judge, I would like to address the bench warrant.
Okay,
The bench warrant was not a willful failure to appear. Ms. Harker has informed me that her assigned public defender mistakenly informed her that that was a court date that she did not have to be present for. We have waivers on file for our clients. Some days they do have to be present, sometimes they don't. And this was a case where she was given incorrect information from her assigned public defender. So it was not a willful failure to appear. The bench warrant should have never issued, and we're asking that she, that the bench warrant, it was served and that she be ROR'd in that case.
All right, state.
Regarding the.
No, wait,
ordinances?
I'm addressing the misdemeanor.
For
Okay.
the bench warrant, Your Honor.
Okay, I'm gonna issue.
No objection to setting aside the.
No objection setting aside the bench warrant? Okay. All right, so the court will set aside bench warrant.
And is Your Honor releasing her on her own recognizance in that
No,
case?
I'm, State, do you want to address the fact that she got, picked up on a new case while on, what was she on bond or was she ROR before?
Well, Your Honor, for the new cases, I think that's something the division ASA who's currently assigned to that underlying misdemeanor case, and if they want to
Okay.
respond in that case, that's something.
All right, so,
The whole purpose of bond hearings, what's the purpose of today's bond hearing if every time someone has picked up on a new case, we're gonna defer to someone else who's not present today? The purpose of Your Honor being here today is to set.
I know, I don't, normally I would hold them no bond. That's why I asked, because as far as I'm concerned, if you're on bond or on release and you commit a new crime, I'm holding you no bond until the next hearing date.
Okay,
That's
and
my
Your Honor
preference,
understands
but
that.
I asked the state and the state didn't want to do that, so that's fine. I will address it, if you want me to revisit that, I'll be happy to do so, but I'm telling you my stand. If you commit a crime while on release from a pending case, my preference is to hold you no
Okay,
bond into the hearing.
And the quote unquote crime that was committed here was sleeping in public, which it happens because someone is homeless. I was waiting to. No.
All right, so let's go to this case. I find probable cause for all three counts.
The new one has 2 camping and parking and entering after hours.
Okay. But there's a third ordinance violation.
Yeah, the.
Oh, no,
third is
that
the-
was a
is the
warrant.
bench
I
warrant.
apologize. That was a warrant. All right. Which was set aside. So, all right.
Judge, corrections, if you may, Judge, could you please tell us which one of the cases you're addressing, please?
And now I'm addressing, I apologize. I'm addressing a. Yeah, I don't see a case number on it.
I believe it's 2519426.
I got it. Yeah, B250194426. Okay, I did find PC on count 1 and count 2.
Yeah, it is standard bond is 150. It does appear that the only prior is the bench warrant.
All right, and since they didn't want to they wanted to set aside the bench warrant, I'm going to RR her on this case. Ma'am, you need.
We would ask for a $1 bond because she's being held on the other case. So ROR, if you ROR her on this case, she's going to continue to be held and not get credit for this case.
Okay. All right, so $1 bond.
And Judge, so on the.
So either way, she's still going to the other, to be held to the court.
Well, I'm
right?
just confused because Your Honor has the ability to ROR her on both cases. But
I'm not doing that. I'm not doing that on the other case. So.
Okay, so on the other case, her bond is $200.
Okay, so you want a bond then? All right.
Well, I just don't understand what Your Honor did. You set aside the bench warrant, but there still has to be a bond.
I asked the state.
Your Honor, but the bond will be addressed in division. At least that is the way that this version of the state has always done it. That is an existing case that has had a bond set. You set aside the bench warrant today, Your Honor, and if that ASA wants to readdress bond, then they can, but that is not typically something that we do at the bond hearing because it's not a new case.
All right.
Judge, the bond would be the amount of the bench warrant. Just because you set aside the bench warrant, there's still a bond. Because she was initially R-Ward. Corrections is agreeing with me. I don't know if you can hear them.
Right.
Judge,
either-
if you set aside the bond, if you set aside
The bench warrant,
you
the bench
still have to
warrant.
place a bond for correction so she can be released.
Okay. And that's, all right, I'm going back to 250 then.
There's two counts.
So it's gonna be, there's two counts?
There are two counts. But for the bench warrant case, it's petty theft and trespass after warning.
And what, was there a previous bond before?
100 each.
Yes,
It's 200, Judge, so it could be 100 each count.
so it's 100 per count.
Okay. So I'm reissuing the bond, but at 100 apiece.
And that's at M257950, Judge.
Right.
And on B25 19426, each count 150 each, $1, $1 each.
The new case they're asking.
On the new case, I ROR her.
Judge, no, we had asked for a $1 bond.
Oh, I'm sorry, a $1 bond
Each count.
on each count. So that'd be
$2
$2 per count. So $2. And I'm issuing a bond, $100 each on the other case. All right. Thank you. And I did the stay away order, right? On this case?
On the other case it was for.
On this one?
No, this one.
No stay away order. Okay. All right, the next one bonded out, which is Mary Patricia Klintz.
Yeah,
You
so
need
just
me to-
write- all you do is write spelling BO right there. Your initials. That's it.
All right. I have Misty Lay Giles. There's a bench warrant in case number B250-12758.
I didn't know.
And Judge, with respect to that bench warrant, it's already been served, so it doesn't need to be set aside, but it was not a willful failure to appear.
No.
Miss Giles was unaware of her court date, and
Yeah,
so
they postponed it and
there was confusion, but it was not a willful failure to appear.
not at all.
How much is a bench warrant for?
It's sort of $300,
Okay,
But there are two counts, so.
600?
No, it's Judge, it's
You-
150
you
each
wanna
count.
break it.
Okay.
300 total, so I believe it would be 150.
150 apiece. Okay, I'm gonna issue a bond of 150.
Each count, Judge?
Yes.
And so, Judge, that's on B25 12758.
125-12758.
Thank you, Judge. Now you gonna do the phone call there? I don't know. I think so. You talk to him. Oh, you ain't crazy.
All right, and let me look at this one.
You need to put.
And this is petty, you have one count of petty theft and one count of, and the bench warrant, so just one count of petty theft.
We cannot hear the state. Can you please speak up? and
Okay,
into the
yes,
microphone?
please, can you talk into the microphone?
Yes, my apologies, counsel. It is one count of drug paraphernalia possession and one count of petty theft for this case.
I only see the petty theft, I don't see the drug paraphernalia.
So
That's the
Your Honor-
benchmark case. That is not the new case.
The new case I have here is
It's only one count, Judge, and an M25 19447.
Yeah, that's what, I have petty theft. I
Yes,
don't
sir.
have,
Yes.
My apologies, the arrest form in front of us is only for the old case. The state can pull up the new one.
okay, so I'm reading the new case, the B. I have it in front of me. I'm sorry, the M250 19447. I find probable cause. What are the priors?
Your Honor, in addition to these two open cases, there is a prior petty theft conviction. It's a B22 case, 2022 branch court case. Conviction for petty theft. That's the only prior conviction for this offense.
Okay. All right, I'm fine. I'm issuing a stay away order from Publix at 1100 and at 1100 6th Street, Miami Beach, Florida 33139. That applies to this case, which is B. Okay. This has the wrong case number, state.
So
Is this the right one?
Judge,
Is
the
it-
current case number, the new case is M25.
Right, that's what I have, but the stay away orders for the B, has the old case number.
Well, fix it, Your Honor.
That's right, but I just want to make sure that the location is the correct one for this case.
And Your Honor, we're passing up a new stay away order. The location for this case, M25 19447, is the Publix at 1776 Biscayne Boulevard in Miami.
Okay. All right, so on this case on M25 109447, there's a stay away order from the Publix at 1776 Biscayne Boulevard, Miami, Florida 33132. Okay, I did find probable cause on that case. What is the bond?
The state's requesting $150 bond, Your Honor.
Okay, I'm issuing, go ahead.
Judge, again, I would just ask that before Your Honor makes a decision about bond, you allow the defense to be heard on this issue.
All
It is
right, go
very
ahead.
important, okay? Judge, I would ask that you issue a bond in the amount of $1. As I've noted multiple times before, pursuant to Florida statute, the presumption here is in favor of release on non-monetary conditions. I'm not sure why the state continuously requests standard bond and ignores this presumption without supplying facts to the court, which would give Your Honor a reason to overcome that presumption. Okay, Judge, Miss Giles, is Your Honor gonna let me finish?
Yes, go ahead.
Okay, Miss Giles has only one prior conviction from 2022. And I would also note that the same statute that I've been referring to, statute 907.041, states that it is the intent of the legislature that the primary consideration be the protection of the community from risk of physical harm to persons. So petty theft does not fall under that category. Physical harm, petty theft does not create a risk of physical harm to persons. That is the allegation in this case, and that is the only prior convictions that Ms. Giles has. So we are asking for a bond of $1 because she is being held on the other case, so she should get credit, but there have been no facts provided to Your Honor that would support a finding that the presumption in favor of non-monetary release has been overcome in this case. The state has provided no justification for asking for standard bond.
Let's see here. Give me a second. Let's see. The other stay away order was from a Publix, and it was also for petty theft. So I'm going to issue a bond. Of
And Your Honor is
$150.
aware of the physical harm piece of the
I
statute.
understand,
read to Your
but
Honor.
I am going to issue the standard bond, $150.
And Your Honor, what facts support a finding that the presumption has been overcome in this case of a non-monetary bond?
The fact that she committed a crime while on
No, Judge,
that she was arrested for petty theft when she was also has a pending case for petty theft. So
but
the
Judge,
court,
that goes into your consideration for the bond on the older case, not the newer case. You already considered the fact that she was out on bond and picked up a new case when you addressed bond in the older case.
ma'am, I'm going to keep it at 150. All right, so thank you. State your order. All right, now we go to I have some traffic cases here.
Good afternoon, Your Honor.
Okay. This is one case. Let me see.
Judge, Ms. Lay has a related felony. She will be on your bond hearing calendar next.
All right. So it's Maria Elena.
Yes, sir. Yes, Your Honor.
Okay. Let me look here. Name form. Okay, we're dealing with the child neglect on the felony division at a later
That's
time.
later, Judge,
No,
that's
next
later.
calendar.
Next calendar. So right now I'm just focusing on the driving under the influence. So I find probable cause for driving under the influence.
Judge, I have a probable cause argument for the third listed
The DUI
charge.
refusal.
Refusal to test after license suspension. There's nowhere in this A form, unless I missed it, does it allege that there was a prior suspension of her license?
State.
And Your Honor, it mentions in the A form on page 4 that upon the officer's investigations that they did see that the defendant's license was indeed suspended.
Where does it say that? Give me the paragraph.
And actually, apologies, Your Honor, it wasn't that it was a suspended license. She was in possession of 2 Florida driver's licenses at the time.
Which is the last charge,
Right.
not this charge.
So as it relates to that charge?
Judge, we're asking she be released outright on the second misdemeanor count that's listed in the A form because there's no probable cause.
And Your Honor, as to the refusal after suspension, state has no objection.
So no ROR on the, what is it? The
Judge,
refuse?
it wouldn't be ROR, it should be
I mean,
released
no
outright.
PC found, right?
Yes, release outright. It's different than ROR.
Got it. No PC found on count 3.
Count 3 listed in the A form, yes.
Right. So count 2, I do find probable cause of driving under the influence, and I do find probable cause as to the traffic infraction of driver's license, more than one license. I am finding no probable cause as it relates to count 3.
And Judge, if I may corrections, please, Judge, could you please go on record to tell me the case? We have Alpha Lima, Sierra 4, Lima Echo Echo. Is that the case?
Okay, all right, I got it. I understand what you're saying. All right. So the DUI misdemeanor is AD 4A 5, I'm sorry, 4AE 5E. So I find probable cause on that one. What do you want?
Bond?
Yes, okay, so where do I put probable cause?
You just put your PC found.
PC found. What's the standard bond for DUI? 1,000?
Yes.
You want to address it?
Yes, Your Honor.
Yes, Judge.
Okay, well, let me hear from the defense first.
Judge, in this case, we're asking for pretrial services. Miss Lay is the full-time caretaker of her 3 minor children. Her husband works full-time, and so her whole family unit is dependent on her being home to take care of the kids. Without her being home, there is no one to care for the kids while her husband works. So pretrial services is sufficient. I will also just note that all of her priors are extremely remote in time. Her most recent prior is from 2009, so over 15 years ago. So pretrial services can reasonably assure the safety of the community and her presence in court.
State?
Your Honor, as mentioned by defense counsel, the defendant does have priors, 2011 criminal mischief, battery on law enforcement officer, and resisting without violence conviction, as well as a 2007 burglary of an unoccupied dwelling, as well as a grand theft conviction punishable by life, and was revoked from probation in 2007.
Okay, so what did you suggest the bond? Standard?
Yes, Your Honor, the state would ask for a $2,000 bond on the DUI.
That's
Okay.
not the standard bond, Judge. The standard bond is
I'm
1,000.
gonna issue the standard bond at this time for $1,000. No bond on wait, okay, so let's go to the next one, I have here, which is on this one. All right, the second one I have is ALS4LEE. That is, let me see here.
That's the charge for which he found no
More
probable
than
cause.
one, that's having more than one license. I
The
did,
one that ends in Echo Echo, which I believe is the case number Your Honor just read, is not the. Oh, I'm sorry. Yes.
it is. Yeah, so that's the, having the, more than one license, I find probable cause for that. You want to address the bond? It's not gonna be ROR. You already made that argument. It's not gonna happen. The standard bond is 250. So I'll make
Judge, I'd
that.
ask for a $1 bond in this case.
Okay, that's gonna be 250.
Having-
Go ahead.
Okay, I wasn't done with my argument. Possessing more than one license indicates not at all that Miss Lay is a threat to the safety of the community. There's no reason that this charge should be anything other than a $1 bond. Possessing more than one license is one of the more innocuous crimes, quote unquote, that exists.
Okay, I'm issuing a bond of 250. Let's go to the next one.
This is the one that should be released outright, Judge. No.
This is ALS4LDE. And that was refused to test.
No PC.
Okay. All right, no PC, so there's no bond on that one.
No, it's not no bond, Judge. It has to be
Release outright,
released
Judge,
outright.
no PC.
All right, no PC, that's it.
Release outright, Judge.
Yes,
Very important. There's a
no,
major difference between no bond and release outright.
all right, so release.
Released out then.
Is that for
I'm just gonna put release.
Okay,
Okay, that's fine.
All right. And then the rest will hold for the felon. Yeah. All right, let's go to the next one. I have. This is case. Where is it? It's a traffic infraction. Where's the case? Where's the ticket?
Right here on top, right here too, if you want to look.
Oh, right here, I see it. Okay, it's ALQ 905E. And this is leaving the scene with leaving the scene of an accident with property damage. Okay. I find probable cause for leaving the scene of an accident with property damage. PC found.
And Your Honor, the state would actually ask that you find probable cause for driving under the influence.
I was waiting for someone to ask, but go ahead, defense. There seems to be indicate by what I read that the defendant, she was identified by the driver. There was markings on the card that indicated she crashed into the gate, and she was there was a strong odor of alcoholic beverage emanating from the person, and she was seen stumbling. It does seem like there should be probable cause for DUI at the same time. Do you have an argument?
There was no breath test done, nor were there any FSEs conducted. And Judge, just because she smelled like alcohol does not mean she was impaired to the point where she could not drive.
Okay. I'm gonna find PC for DUI. There, since it wasn't listed, I'm not issuing any bond on that. It could be addressed later on when the state files the information. I'm finding PC for leaving scene of accident.
And Your Honor, if you are setting bonds based on those leaving the scene of an accident, the state would be requesting a $250 bonds. It would be requesting that you issue a monetary bonds because of the facts alleged, including the odor of alcohol and the property.
Judge, I would like to be heard.
Yes, go ahead.
Miss Echevarria has absolutely no priors. Not only does she have no priors, she's never even been arrested before. She is not a danger to the community, and her presence in court is not something that Your Honor needs to be concerned about. Again, the presumption here is in favor of non-monetary bond. I'm not sure if I heard the state, if they alleged facts that supported a finding that presumption has been overcome, but given her history, I believe that ROR is entirely appropriate here.
Okay, I'm issuing a bond of $250.
And Your Honor, you understand the standard bond for this is $150.
Is it $150?
No, that's not correct. Counsel, the standard bond for a second-degree misdemeanor that involves any amount of force or threat of force against the person is $250. If you're reading the facts of the counsel, I let you make your arguments. Will you please let me finish? If you're reading the facts of the arrest form, it does say that she crashed into a fence multiple times, which I would certainly describe as an amount of force.
Yeah, but it's not against a person. Yeah, it's not against a person.
The standard bond is listed right here as $150 on the form that of the calendar. That would have been, if she had bonded out before today, that would have been the bond, $150. That's the standard bond.
I'm issuing for $150. So if that's the standard bond, that's what I'm going to issue, the $150. All right. Here you go. Thank you. Next. All right, I have Rakeem Lewis. And is he present?
Not yet, Judge.
All right, call then. I'll pass him then. Is he on his way or do you want me to pass?
Direction?
Mr. Lewis is here.
Okay, perfect. All right, thank you. All right, Mr. Lewis, good afternoon. This is case number M250-19315. You're charged with one count of petty theft, value of 100 and over 750. Let me read the A form.
Judge, before you is not Mr. Rakeem Lewis. Before you, he refused.
Okay, so reset for tomorrow then. And this was reset from 8:31 and reset from 9:1, so we're resetting again. 9:2. Got it? And let me sign initial. Okay, I have Luis Cesar Menendez de la Cruz. Is that Mr. de la Cruz?
Mr.
Yes,
Mr.
Judge.
Menendez de la Cruz requires the assistance of the Spanish.
Okay, interpreter. All right, so this is case number B250-193-70. Let me read the A form.
Este es el caso B25-19370. Voy a leer el formulario de arresto.
And Judge, Mr. Lewis has a new felony. He will be on your bond hearing calendar next.
Okay.
Y, señoría, el señor tiene un arresto por un delito grave. Comparecerá ante usted en el calendario de los delitos graves.
Okay, I find probable cause for petty theft, second degree. Any priors?
Determino que hay suficientes indicios de hurto menor, segundo grado, delito leve. Antecedentes.
State?
No prior conviction, Your Honor.
All right.
No hay antecedentes, señoría.
He's homeless, does he qualify for TAP?
Él no tiene hogar, califica para TAP.
Judge, I see an address listed on the arrest form. Unfortunately, I don't speak Spanish, so I can't ask him directly, but nonetheless, we would be asking for ROR in this case, or we would be asking for a dollar bond in this case in light of his felony hold. Again, Judge, the presumption here is in favor of non-monetary release, and the legislature specifically indicated that the primary consideration is the protection of the community from risk of physical harm to persons. The facts alleged in this arrest form indicate no basis for concern that the physical safety of the community is at risk. Moreover, he has no priors at all. So all of these taken together indicate that there is no risk to the physical safety of the community should Mr. Menendez de la Cruz be released or be given a dollar bond.
I'll issue a dollar
Señoría,
bond. Go ahead, you do the translation.
no he podido verificar si él tiene una vivienda. Aquí en el formulario de arresto figura una dirección, pero como yo no hablo español, no he podido confirmarlo con él. En este momento pido que se le permita salir a cargo del programa TAP. No hay ninguna indicación que el señor Menéndez presenta un riesgo de fuga, un riesgo para la comunidad y el tener that's basically, Judge. The counsel went on for a bit, and I'm not so sure the interpreter was able to capture everything. Su señoría, la abogada habló por un rato y no sé si el intérprete pudo capturar todo lo que ella dijo.
All right, I'm going to issue a $1 bond. And we'll address the rest of the bond when I hear the felony.
Voy a ponerle una fianza de $1 y ventilaré el resto de la fianza cuando escuche el caso por el delito grave.
Okay, and the defendant, there's a stay away order from for the defendant to stay away from Gables Inn, 730 South Dixie Highway, Coral Gables, Florida, 33146.
Y te pide una orden de alejamiento de que el caballero se mantenga alejado de Gables Inn, que queda en el 730 suroeste de la Dixie Highway, Coral Gables, Florida, 33146.
All right. Thank you, sir. I'll see you in a little
Gracias,
bit.
caballero. Lo volveré a ver en breve.
Okay, I have Cedric Phyllis is trespassing property after warning.
Judge, Mr. Cedric, he refused. Philip Cedric refused court, Judge.
All right, so he was reset from yesterday, so resetting again. to tomorrow.
Yes, Judge. Before you is Mr. Columnaris Jason. Judge, he was out on felony bond F25-15516.
Okay, Mr. Rodriguez, are you representing Mr. Colamares?
Good afternoon, Your Honor. No, I'm here on a felony. You're not on felonies yet, are you?
Not yet, no,
Okay.
no. You just popped up, that's why I asked. Okay,
I thought I heard my client's last name, but I'm sorry about that.
okay, all right. So we're talking about Jason David Colamares. There was a bench warrant. Was it on what type of case?
Vessel with expired registration, count 1, and failed to comply with boat regulations, count 2.
Let's see, does she have any crimes? All right, state.
Your Honor, this, I believe it's a big warrant, and the amount's $100, so we would ask that the bond be set for $50 per count. In addition to that, Your Honor, we'd be asking for a felony hold for F25-15516.
Okay, and he has a pending felony?
That's correct, Your Honor.
What's the case number?
F25-15516.
F25, what is it?
15516.
Defense?
Judge, we'd be asking for a $1 bond for each count in this case. The allegations here, similarly to every single case we have seen in this calendar, have the presumption of a non-monetary bond, and there have been no facts presented by the state which would justify Your Honor finding that that presumption has been overcome. But in light of the felony hold, that is why we were asking for a $1 bond on each
Okay,
count.
I'm gonna issue a bond of $50. So how many counts is it on this? Two. So $50 per $50 bond per count.
Your Honor, did you find probable cause?
Counsel, it's a bench warrant.
It's a, yeah, it's a bench warrant, so, and he's the person that was on the bench warrant, so. $50 per bond, per count, and felony hold until he goes in front of felony judge. Ignacio Martin Vargas. Okay, and this is resisting an officer without violence to his person and petty theft, case number M250-19407.
Judge, he's not here yet. If we could wait momentarily.
Okay.
Judge,
I'll be-
Mr. Vargas was relocated to Metro West. Reset for tomorrow. Reset for 9 to
Okay, so reset tomorrow?
Yes, Judge.
No. Thank you for checking.
And a few we'll do at the end.
Yeah, that's fine. All right. I have a bench warrant on case number 25-140-146. Let's see. Seems like there's a $10,000 bench warrant.
That's what the state showed, Your Honor.
Yes, Judge. This was not a willful failure to appear. Mr. Prosser was unaware of his court date, which is why he failed to appear. And we're asking that Your Honor adjust the bond.
I have no idea whether there was a $10,000 bond, but that was Judge Mato. I'm just going to hold him until she sees him. So when will she appear in front of Judge Mato?
Well, we'll be jail report in 2 days, Judge, and then after that.
Okay. So I'm gonna hold him until he comes up in jail division.
Judge, you're gonna hold him no bond?
Unless he wants to post a $10,000 bond.
Would it be more correctly described as a misdemeanor hold, Your Honor? Not
Right.
holding no bond, but
Right, a misdemeanor hold. I'll do a misdemeanor hold.
So Judge, you're holding him no bond? A
I'm
misdemeanor
holding,
hold is essentially holding him no bond. You're
you want
getting,
me to issue a $10,000 bond? Because that's what's on the bench warrant. That's what I will issue.
I mean,
For
Judge,
whatever reason, someone put on here a $10,000 bench warrant. Not sure why, but that's what it says.
well, I would just suggest that you leave that bond then instead of holding him no bond.
I'll leave that bond then. $10,000.
Of course, that's only if you're not willing to readdress it.
No, I'm not gonna readdress. I'll let the judge readdress it. So I'm holding. What do I need for-
10,000.
So bond, 10,000. 9/1/2020. I'm not gonna second guess the judge. So if there's someone held him for 10,000 bond, I'm leaving it. There you go. Thank you. Frederick Isaiah Woodward. Misdemeanor cannabis possession.
Judge,
One
I
gra-
believe he's not here. It may need to be reset for tomorrow.
Reset.
Judge, you refuse. Reset.
Okay. 9/2. Oh, I need to sign it, right?
Yes.
Did I sign the other one? There you go. Anthony Smith.
Your Honor, Joanne Hennessy for the city of Miami Beach.
All right, this is a city ordinance, entry on park after hours. Any priors?
He does, Your Honor. He has 2025 two petty theft convictions from May, a trespass after warning also in May, February petty theft, two convictions, felony. And then prior to that, he also has a park after hours adjudication guilty from February or from July of last year.
Does he want to take a plea in this?
Your Honor, I don't have the
DTS?
entire, I'd rather ask for standard bond in this case.
Okay.
Your Honor.
No.
Let me see.
Judge, in this case, we are asking for an ROR and a date certain on the homeless calendar. There are no facts alleged in the A form which warrant any concern for the physical safety of the community. Furthermore, there's no indication or reason to believe that Mr. Smith will fail to appear at any future court date. The allegation here is simply that he was in a park after hours.
What's the standard bond?
Your Honor, it's 150.
150? I'm issuing a bond for 150.
And Judge, may I just inquire as to what facts you find that support the
The facts that he's been doing this before. So I'm finding PC, issuing a bond for 150. I have another city ordinance, alcohol open container.
Joanne
This is-
Hennessy for the city of Miami Beach.
Right. Okay. All right. I remember the state used to dismiss all these open container cases when I was a prosecutor. Go ahead. I found PC for it.
Your Honor, there are several recent priors, some trespass after warnings in 2025, as well as I just switched the calendar. and some trespasses in 2024 as well. I just request standard bond.
Judge, we'd
Which
be
is-
asking for ROR and a date certain on homeless calendar.
All right, I'm gonna RR him. Again, I remember we used to dismiss these cases when I was a prosecutor. So I'm gonna RR him. Sir, you're to come in on October 1st, 2025 at 8:45 a.m. in courtroom 6-8 of the Gerson Building, 1351 Northwest 12th Street. Do you understand that?
Yes, sir.
If not, a bench warrant will
I'm
be
writing it down
issued.
for you. I'm writing it down for you. I'm writing it down for you, yeah.
Which one's this one for? I didn't.
Next one.
That's why I'm gonna record it for this here.
Yep.
So October 1st, recent, okay. Okay. All right, I have Gary Bracknell Baum. 2 counts, drug paraphernalia and false, giving a false ID after arrest. Is he present? All
He's
right.
present, Judge, and I do have probable cause arguments whenever
Okay.
Your Honor is done reading the eighth
Yeah.
one.
Okay, I find, well, what is your probable cause argument?
Judge, I have a probable cause argument as to each count. First, the drug paraphernalia count requires intent to use. There were no facts in the A form that tend to prove that Mr. Baum had the intent to use a pipe. In fact, the only fact about the pipe in the A form suggests that he didn't have the intent to use because it was broken. It's you can't use a broken pipe. So the fact that it was broken shows that he could not have had the intent to use. And with respect to the false name after arrest, Judge, the only part of the narrative that gets at this charge is that Officer Hernandez arrived on scene and identified the offender by his real name and date of birth, but it doesn't say what the real name and date of birth is. So there is no fact to suggest that it is not the name and date of birth that he provided to begin with, which is listed in the A form.
State.
So, Your Honor, I'd say count one. And my mic wasn't working, so I apologize. As to count one, Your Honor, I think, I mean, the state would agree within the 4 corners of the A form, the facts supporting intent to use are not here. If the state gets more information, they could file an information charging that later. But the state would argue that there is probable cause for drug paraphernalia possession without intent to use. Given the fact that it does say that a broken glass crack pipe was found in the defendant's left pocket. The state would also argue for PC for false name or ID after arrest. I mean, the original credentials which were provided to officers were not sufficient to identify him, and then new information was provided. At least that is how the arrest form reads. That did allow them to identify him. That's it. I think it would be a good trial argument, perhaps, or a better issue for trial, or to discuss whether or not.
So wait, are you arguing for PC on the false name or no PC? Because you said no PC at first, and then you're saying yes.
No, the state is arguing for probable cause on the false ID after arrest.
So on both, you're arguing for PC on both.
PC on both, but the state would agree with defense that the facts in the arrest form do not indicate intent to use. So the state at this time would just ask for probable cause for drug paraphernalia possession.
With is that a 2nd degree misdemeanor then?
Judge, I don't actually believe that's a crime. I could be wrong, but if the state could cite the statute under which that is a crime, I would appreciate it. I've never seen a case that charged
And-
drug paraphernalia without intent to
And
use.
maybe things have changed, but when I was a prosecutor, there was also a requirement that they find some type of drug in or some residue in the paraphernalia, but I don't know if that's changed.
So council, Florida statute 893.147, use or possession of drug paraphernalia, is the statute that says it is unlawful for any person to use or to possess with intent to use, drug paraphernalia.
Yes, Judge, with the
So-
intent to use. was
With
the
intent to
keyword there.
use.
Yeah, okay. Understood. I mean, the state would stipulate on the first count that there is not probable cause within the four corners of the arrest form, but the state would still be asking for probable cause for count 2.
Okay, so no PC on count 1. Release. And count 2. Let me see, false name after arrest.
Judge, again, I would just reiterate that nowhere in this narrative does it say that they identified him by a name other than the name that he provided. It just says identified the offender by his real name and date of birth. It doesn't say what the name or date of birth is.
No, but it does say that I asked him for his name, date of birth, which he provided, Pablo Alvarez. A records check of the given information yielded negative results. Officer Hernandez came in and basically he got his real name, which is Gary Bracknell Baum, which is what appears on the A form on top. So I'm finding probable cause for the second count. Priors?
Your Honor, the defendant in this case, the defendant has a 2025 conviction for resisting without violence and trespassing. This defendant also has a 2007 conviction for aggravated assault with a deadly weapon, a 2022 conviction for strong arm robbery, and a withhold in 2005 for marijuana possession.
Okay, so what's the standard bond?
The standard bond in this case, Your Honor, should be $500.
Okay,
And that's what the state is requesting.
all right, go ahead. Make your argument.
Mr. Baum cannot afford any amount of bond in this case, so holding him on a bond of $500 is tantamount to holding him no bond at all. Again, Judge, the presumption here is in favor of non-monetary release, and the priors the state mentioned are remote in time, so should not overcome that presumption in this case. We are asking for ROR.
Okay, I'm issuing a bond of $500, which is a standard bond. Paul Foglia?
Yeah, and
Case
Joanne
number-
Hennessy for the city of Miami Beach.
Okay, case number B 250-19424. Camping prohibited in Miami Beach is a city ordinance, and entering the park after hours, city ordinance.
Your Honor, I would ask for a standard bond on both counts. Although there are no priors, the priors it's a null pros. However, in the A form, it does indicate a reference to a registration violation on page 2.
All right, there's no priors?
No priors at all, Judge, whatsoever.
All right,
Your
I'm
Honor,
finding-
I would just ask you to read page 2. I can read it out, but I think
I'll read
that
page 2.
it's the second to last paragraph.
If that's the
Judge, I
case,
believe-
they should be, yeah, go ahead.
I believe that is in reference to the case that was null pros. So I'm not sure why that is listed in the A form. I also don't think it's necessarily relevant here
It's
to the
not, it's,
allegations at hand.
I'm looking at actual convictions in this case, is not domestic. So I'm finding PC.
Your Honor, if I just may, you know, the registration is, it indicates a prior arrest somewhere, not necessarily in the state of
I
Florida.
understand, but there, unless he's been convicted, at this point, I'm entering, I'm finding PC for count 1 and 2. On count PC, count 1 and 2. I'm entering an ROR. He's homeless. He needs to report October 1st. Sir, you need to go on October 1st, 2025 at 8:45 a.m. to courtroom 6-8 of the Gerson Building, which is the same building where court is being held. It's 1351 Northwest 12th Street. It's courtroom 6-8. You need to report there on October 1st. If you don't, a bench warrant will be issued.
Your Honor, if I could ask you and the court if the state could help me out with the stay away order from the arrest location.
Okay, and I will issue a stay away order from the location, which is, let me see here.
The state is providing that.
Judge, you given
Thank you.
on both counts?
ROR on both counts, yes.
Thank you, Judge.
Let me see.
Your Honor, the location in this case is the 2700 block of
The beach.
Miami Beach, yeah.
Okay, so 20, you
Sorry,
gotta
for the
stay away
record,
from.
Judge,
Yes.
Mr. Foglia was taken away by corrections, so.
Can he be brought back? So I could issue the stay away order.
Okay, he's back, Judge.
Okay, sir, you're to stay away from the 2700. I'm going to issue a stay away order. You're to stay away from the 2700 block of the beach. If you're caught in that area, you will be arrested. You understand that?
I will not be.
Okay. All right. Thank you. All right. All right, I have B250-19425.
Joanne Hennessy for the city of Miami Beach.
Okay, there's a probation warrant. He was charged with entering, he's homeless, entering a park after hours and camping on the beach. And there is a bench warrant issued.
And Your Honor, I believe this is a probation warrant for an open felony.
Okay. Where's the bench warrant? Because I don't see it in.
It's
I
a
just have-
felony, it's a battery on a Leo.
No, I have it, but I don't see the
Oh.
warrant. It's not in front of me. Do we have the warrant?
No. Don't.
Judge, it's a probation, Judge, it's a VOP.
Or it's a violation of
Yes,
probation?
Judge.
The BOP on the felony, Judge, the new case is the misdemeanor.
Okay.
So we would just ask for a felony, hold, Your Honor, so that the judge in the felony case could address.
All right.
bond.
I believe he's already being held no bond on the felony probation.
All right, so it's a felony hold. What do I mark? Everything? Because I don't.
Flip it up.
Judge, he already has a hold, it's a probation violation, there's a hold on it.
It's a hold already?
Yes, Judge, no bond.
Okay, so felony hold. I'm just gonna put it here. It's also.
And corrections to case number, please?
F 25-6506.
Thank you.
Felony hold and. Let me just see on this. I find probable cause for count 2 and 3.
Your Honor, we just asked for the standard bond.
Judge, we would
Uh,
ask for a dollar bond on each count. The only prior conviction I'm seeing is a resisting without violence conviction from 2024. As such, there's no risk that Mr. Menendez is a risk to the physical harm of the community. And we believe that a $1 bond is appropriate on each count, especially in light of his felony hold.
Okay, I'm issuing $50 bond per count. Okay, sir, you're also,
That's from the previous.
oh, I got it. Is there a stay away order on this one?
No.
No, all right. Thank you, sir.
All right, no problem.
I have case number B25019429, Brian Keith Freeman.
Your Honor,
Also
Joanne Hennessy for the city of Miami Beach.
is camping prohibited on Miami Beach and urinating or defecating in public. All right, I'm finding probable cause for both counts. Priors,
No prior.
Your Honor, there is an open camping violation from August 23rd was the file date. B25-18579.
He has no prior convictions here or anywhere else in the country.
I'm going to RR. All right, thank you. Stay away order on this one?
Judge, he is
Oh,
homeless.
yes, he's homeless. He needs to appear at, he needs to appear on October 1st, 2025 at the Gerson Building at 845 courtroom 68. Do you understand that, sir? The address is 1351 Northwest 12th Street. If you fail to appear, a bench warrant will be issued.
And Your Honor, if the state could help me out with the stay away order if you issue
All
that.
right, before he leaves, sir, don't leave yet. I'm going to issue a stay away order from you from,
Your Honor.
300 Lincoln Road.
right, so 300 block of Lincoln Road. Do you understand that, sir? You're to stay away from that. You understand?
Yes, sir.
All right, thank you.
Judge, RR on both counts?
Yes.
Thank you, Judge.
All right, now going to case number M25-10338.
Judge, Mr. Gonzalez has an open felony. It was out on felony bond F24932.
Okay, wait, F24.
932, Judge.
And Judge, Mr. Gonzalez requires the services of the Spanish interpreter.
Su señoría, el señor González tiene un caso pendiente por un delito grave.
All right, I'm issuing a felony hold.
Lo retengo en relación al caso de delito grave pendiente.
F24-932.
F24-932.
All right, and and this is a bench warrant for $500.
Judge, if I may be heard as to the bench warrant.
Yeah, go
Les
ahead.
pide una orden de búsqueda y captura, $500. Si me puede escuchar en relación a esa orden de búsqueda y captura, adelante.
Mr. Gonzalez was in the hospital for 4 months being treated for burns related to an incident that is not related to this case, but that is why he missed court. We are asking for a $1 bond in this case. It was not a willful failure to appear.
El señor González estuvo hospitalizado por 4 meses en relación a quemaduras que sufrió en un incidente que no tiene nada que ver con esto, pero la falta de comparecencia de él no fue intencional, pedimos que se le permita salir a cambio de una fianza de $1.
Okay, State, is there any arguments?
Alegato, estos argumentos.
The defendant indicated that he was in the hospital for 4 months. That's why he couldn't appear.
El acusado dice que no pudo comparecer porque estuvo
It's
hospitalizado.
on the misdemeanor, the bench warrant on the misdemeanor case, which is, it was a case of,
Business without a license.
yeah, business, doing business without a license, that's a $500 bond, bench warrant, I mean.
Sí, esto no compareció en relación al caso de delito leve por hacer algún negocio sin licencia. Le pusieron una purga de $500.
Yes, and do you have the name of the hospital that he
¿Tiene
was
el
in?
nombre del hospital?
Kendall Hospital.
El hospital Kendall.
Kendall Regional?
El hospital regional de Kendall.
Yes.
Yes, in English.
Sí.
Yes.
Your Honor, the state would have no objection to setting aside the bench warrant.
Señoría, la fiscalía no se opone a
All
que se
right, I'll issue a
desestime.
$1 bond.
Le pongo fianza de $1.
And Judge, if I may just confirm, does the felony predate the misdemeanor? Otherwise, there
Señoría,
could not be a felony hold.
quiero confirmar
When is
algo.
when is a
El
felony?
delito grave es antes del delito leve. Si no es así, entonces no debe haber ninguna retención por el delito grave.
What is it?
Felony is F-24.
Right, so yes, this case is well, let me see, this is an F-25, the felony is an F-24.
Okay.
Y esto es un F-25, el delito grave es un F-24.
So Judge, you're gonna hold him on the F-24 case, correct?
Yes, I'm holding it on, no bond, I mean felony hold on that one. No
Thank you,
bond.
Judge.
Felony hold.
Señoría, entonces lo retiene en el caso del delito grave. Así es.
And $1 bond, Judge?
On this one, yes.
Misdemeanor,
Y una
$1.
fianza de $1, sí. En esto sí.
Richard James Davis. Trespass after warning.
Mr. Davis is present.
All right, sir, let me read the A form. This is case number B 019433. Finding probable cause, well, let me see. There's a previous trespass warning. I'm finding probable cause. Priors?
Your Honor, the defendant has a 2024 controlled substance possession conviction. They also have a 2012
Judge, we can't hear the state.
Thank you, counsel. The defendant has a 2024 controlled substance possession felony conviction. The defendant also has a 2012 petty theft conviction. He has a 2012 petty theft conviction, another one, and a 2007 drug paraphernalia conviction. And Your Honor, the state would be requesting a $500 bonds, both because of these priors and also because of the fact that inherent in the nature of this crime was the fact that he was already asked to stay away from this area and he went back again.
All right.
Judge,
Defense?
we're asking for an ROR. In this case, there's no amount of bond that Mr. Davis can afford, so imposing a monetary bond in this case is tantamount to holding him no bond at all. I will remind the court that the presumption here is in favor of non-monetary release. And there are no facts that would overcome that presumption. The allegations here are that he went to use the bathroom. I understand that there may have been a prior trespass warning, but that's entirely non-violent. There is no reason based on the allegations in this A form or any of the priors the state listed, all of which were non-violent, to believe that Mr. Davis is a threat to the physical safety of the community. And that is why we are asking for ROR, because it can reasonably assure the safety of the community.
I'm gonna issue a 250 bond. Stay away order from the Walmart at 21151 South Dixie Highway, Miami, Florida, 33189. I have B 25019439.
Your Honor, Joanne Hennessy for the city of Miami Beach. At this time, it's the state's case. I just am announcing my appearance for
Okay.
the misdemeanor.
He has an open container case for, which is a violation of city ordinance in Miami Beach. And cannabis possession, 1 gram or less. I'm sorry, 20 grams or less.
Judge, I do have a probable cause argument.
What's your probable cause?
Judge, the probable causes with respect to the cannabis possession count. First of all, Judge, there's no reason to believe, I know the officer claims it was marijuana in the arrest form, but there is no basis for that conclusion. It very well could have been hemp, which is entirely legal, and there's no basis to believe it was marijuana and not hemp. Moreover, Judge, there is no indication or reason to believe that Mr. Guyton does not possess a medical marijuana license, which would make it legal for him to possess marijuana. There's no allegation that he was smoking it in public or anything like that, which would make it a crime without, even with him having a license. Just possession, which there's no reason to believe that he committed any crime here because we do not know whether he had a license. There's no reason to believe one way or another, so there's no probable cause that he committed any crime.
State,
Yes, Your Honor. In this case, the state would have an announcement.
go ahead.
In the case of Victor Guyton, case number B 25019439, the state announces David Frost.
As to your count, is that on the full case then, right?
No, that's just the.
The curbside and the camp.
Okay, so,
You at the top, Judge.
okay,
And that's this time you write it to the top, next to the counts.
so just, what do I put?
No lacrosse?
KMP? Right, sir, you're free to go. Thank you.
Your Honor, just to be clear, the count 2, there is probable cause.
All right,
there
but the
is a-
state just
No,
dismissed
the
count 1
state
and 2.
just dismissed count 1. Count 2 is standing, and I'm here to represent the city of Miami Beach.
I understand, but the state just told, they're affirmatively said that they were dismissing both counts. So at this point, both counts are dismissed.
Your Honor, I'd object. The state does not have the jurisdiction to dismiss the city's count.
Okay,
Judge, the state does have the jurisdiction when the
I think they do,
violation is
yes.
charged in a state case.
yes, they do have it, so I am dismissing it at this point.
Okay, over the city's objections, Your Honor.
Okay, thank you. I have Jesus Manuel Ramirez Mata, B 250-19440.
He bonded out, Judge, I believe.
Okay. Found out.
Just to announce my appearance on that case, Your Honor.
All right.
For Ramirez Mata, this is Joanne Hennessy for the city of Miami Beach.
Okay. There you go. Jonathan Rea.
Present, Judge.
This is consuming alcohol within 100 feet of a store. It's a city ordinance. Find probable cause prior.
Your Honor, is it the city's case?
Yes.
Your Honor, no, this is it's a county ordinance, the
Oh, it's a
21
county
dash.
ordinance. Okay, so this is
Yeah.
okay,
This
so
is
it's not a
joint-
city, it's a county
not a
ordinance.
city case.
This was it was in Collins Avenue, but it's, this is the county ordinance, consuming beverage within 100 feet of the store.
Once again, counsel, this is not City of Miami's case.
Right,
In that case, Your Honor, the city would have an announcement.
go ahead.
In the case of Jonathan Rea, case number B25019451, the state announces annual cross.
Judge, if the state could please speak in the mic, I cannot hear anything he's saying.
Is that we have two states, so that Mike states where the other state attorney was, so that's why it doesn't get switched, so go ahead.
In the case of Jonathan Rea, case number B25019451, the state announces annual cross.
All right. Got it. Case number M250194552. It's petty theft, and there's a bench warrant.
Mr. Comnic requires the services of the Spanish interpreter.
Este es el caso M25-194-52. Es hurto menor, hurto de menor cuantía. El caballero necesita los servicios del intérprete de español.
And this is a second degree petty theft.
Este es un delito leve de segundo grado.
There's also a bench warrant on case number M250-06172.
También se expide una orden de búsqueda de captura en el caso M250006172.
Okay, I find probable cause as it relates to the petty theft.
Determino que hay suficientes indicios en relación al caso de hurto leve.
I'm entering a stay away order from Target at 1010 West Flagler Street, Miami, Florida, 33174.
Pido una orden de alejamiento en relación a la tienda Target que queda en el 1010 de la calle Flagler Oeste, Miami, Florida, 33174.
All right, does he have any priors?
¿Tiene antecedentes?
No priors, Judge, not at all.
No tiene antecedentes, pues.
Okay, as it relates to the bench warrant state?
Y en relación a la orden de búsqueda y captura, Fiscalía.
I apologize, Mr. Interpreter. Your Honor,
Use the mic, move the microphone. Okay.
as it relates to the bench warrant, I mean, the bench warrant's in the amount of $1,000. The state would ask for that amount to be retained for the bench warrant for the other case.
En relación a la orden de búsqueda y captura, es a cambio de $1,000, pido que esto se mantenga así en relación al caso.
Judge, I'm a little bit unclear about what the state just requested and which case we're addressing right now.
He says, on the one with the bench warrant, which is 25-06172, he said, there's a $1,000 bench warrant. He asked to retain in other words, to impose a $1,000 bond on that case.
Judge, with respect to the bench warrant, oh, sorry, go ahead, Mr. Interpreter.
En relación al B25-06172, me ha pedido que en relación a la purga de $1,000 por la falta de comparecencia, que eso se convierta en una fianza.
Okay, Judge, with respect to the bench warrant, it was not a willful failure to appear. Mr. Comnic was unaware of his court date, so he did not willingly fail to appear. We are asking for his original bond to be reinstated, which I believe was ROR, because it was not willful. Mr. Interpreter, I'll let you go ahead.
Señoría, en relación a la orden de búsqueda y captura, quiero decirle que el señor Kamnick no faltó al tribunal intencionalmente. Él no sabía cuándo tenía que regresar al tribunal. Por tanto, pido que se le imponga la fianza que él tuvo originalmente en aquel caso. Tengo entendido que fue libertad bajo palabra. Haré pausa para que el intérprete interprete lo que he dicho.
Moreover, Mr. Komnick has no ability to pay any amount of bond, so holding him on a bond of $1,000 is tantamount to holding him no bond at all.
Además de esto, el señor Kalnick no tiene la capacidad económica para pagar ninguna cantidad de fianza, por tanto, imponerle cualquier monto de fianza es equivalente a retenerlo sin derecho a pagar fianza.
All right, I'm gonna issue, what's the standard bond on a misdemeanor second degree?
La fianza estándar de un delito menor de segundo grado, ¿cuál es?
Yes, and second degree misdemeanor.
Delito leve de segundo grado.
For a petty theft, it should be $150.
Okay, and what was the other case he had?
Por un hurto menor son
Also a petty
$150.
theft, was that a first degree or
It's a second degree, Judge.
second degree? So I'll do
And-
one, I'm gonna reissue a bond on the 25-06-172 of $150.
Por tanto, en el caso 25-06-172 le pongo una fianza de $150.
And if I may be heard on with respect to the bond on the other case,
Sí,
On
me
which
puede
one?
escuchar en
On the
relación
new case?
the new case, yes, Judge.
Yes,
a
go
la
ahead.
fianza en el otro caso, el nuevo, sí.
Yeah, go ahead.
Adelante.
Judge, the new case is a second degree petty theft allegation. Again, Mr. Komnick has absolutely no priors at
You
all.
have a stairway order?
There are no facts to overcome the presumption in favor of non-monetary release in this case. We are asking that he be given a bond of $1 in light of his $150 bond in the second case. But again, there's nothing that overcomes that presumption.
Su señoría, el segundo caso es un delito menor de segundo grado. No hay, el caballero no tiene Kalnick no tiene ningún tipo de antecedente y no hay nada que se haya sobrepuesto a la presunción de que no se le obliga a pagar fianza monetaria para salir. Por tanto, le pedimos que se le dé una fianza de $1 en relación a ese segundo caso.
He
Okay,
poses no risk to the physical safety of the community.
All right. Now,
Él no
my
le
view,
presenta riesgo a
again,
la
my view
seguridad.
is if you're on, you have a pending misdemeanor and you commit a new crime, then you're gonna have a bond on the new crime. So I'm giving a 150 on that one also,
Mi
which is
opinión
the
es que
standard bond.
usted tiene un caso pendiente por delito leve y comete otro delito, entonces usted va a recibir una fianza en relación al segundo delito. Por tanto, va a recibir una fianza en relación a este segundo caso y su fianza en ese segundo caso son $150, la fianza estándar.
All right, and there's a stay away order, which I already mentioned against the target at 1010 West Flagler Street. Thank you.
Y nuevamente, como mencioné, hay una orden de alejamiento en relación a la tienda Target en el 1010 de West Flagler, de la calle Flagler Oeste.
Thank you.
Gracias, caballero.
Judge, for corrections clarity, M25-19452, the bond amount is $150?
Yes, 150 on both cases.
Thank you, Judge.
All right, thank you. Virgil Stephen Jordan is a M2 assault with solicitation.
And Judge, I have a probable cause argument whenever Your Honor is done reading. the
Yes, all right, I mean. What's your probable cause argument?
Judge, as Your Honor is well aware, assault requires imminence. Not only is this not imminent because it is a conditional threat, it is not imminent because the allegation is that he said he would return tomorrow. So for both of those reasons, any alleged threat that was made was not imminent, and that the element of assault has not been met in the four corners of this A form. Therefore, there's no probable cause, and we're asking that Mr. Virgil Stepney be released outright.
Anything from the state on that?
No, Your Honor.
Yeah, I don't find PC either. No. All right, so he's no PC, released.
Release outright, Judge, correct?
Yeah, yes. Is he homeless? Yes, so he still has to appear. The case is not gone.
It would have to be an ROR.
So Judge, no PC found, release outright?
Yes.
Yes. I can't ROR him because, so, I mean, is it set for another date?
No.
So no, okay.
No, we just have to set it for homeless calendar, Judge. You can still
Well-
release him outright.
Well, that's what the clerk is telling me, that if I don't find ROR, I can't set it for the homeless calendar, but the case is not gone. The state could refile if they want to, or they can no pros if they want to do that now, but the
But-
case is still open, so if he doesn't show up whenever the calendar is, he's gonna be, a bench warrant will be issued, so that's what I'm trying to address.
I know, that's why he needs to be given oral notice right now for homeless calendar.
Will he be set on the home?
It can't be a homeless.
Wait,
reset.
say it on the.
It can't be a homeless reset because the status would have to be ROR. But it's.
He's still being released. It's just a different form of release. He's being released and he has no address. So I don't understand how that doesn't qualify for the homeless calendar.
Because it's not set up that way. A release is a release. And we don't special set. So you would have to make sure you stay informed with the client.
Okay, because I just anticipate a problem when he doesn't show up for a regular calendar and a bench warrant is issued.
Well, it would be improper for a bench warrant to issue if he had no notice, and we are
Right.
informing the court right now that he has no calendar and he needs.
Okay, what I'll do is I'll special set it. I'll court order special set. For October 1st, 2025 at 8:45 in courtroom 6-8. All right, sir, you're to appear at the same place where the courthouse is at, which is 1351 Southwest 12th Street at 8:45 a.m. on October 1st in courtroom 6-8. If you fail to appear, because it was special set, a bench warrant will be issued. Just because I didn't find probable cause, doesn't mean that the case is gone. I'm also ordering you to stay away from Amanda Garcia. Garcia? Is that the last name? Amanda Garcia. You're prohibited from having any contact with with Amanda Garcia, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third person. You must stay at least 500 feet away from the victim's home, a place of employment, and or school at all times. Also, electronic contacts such as email, texting, and Facebook messages, or by Twitter, is prohibited. You understand that, sir?
I understand that.
Okay, and you are also to stay away from the address of 3948 Curtis Parkway, Virginia Gardens, Florida. You understand that also, sir?
Yeah, I understand.
All right, thank you, sir. Good luck to you. Here you go. All right, now we're going to traffic again.
Your Honor, if I may confirm that the misdemeanor portion of the jail arraignment calendar is complete. That's
Looks like everything I have is just traffic.
great. Thank you. And if I could be excused, Your Honor.
Absolutely. Thank you so much for
Thank
being
you.
here.
Sure, good day.
All right. I have case number, see, A2WQJ9E.
Judge, what is the
Operating a
individual's name?
vehicle with a suspended, canceled, or revoked driver's license on March 4th. And also defendant failed to appear for arraignment March 14th, 2024 with Judge Nelson. Was there a bench warrant issued of $3,000?
Judge, he requires
Yes.
the services of the interpreter.
Excuse me, my interpreter request repetition.
Okay, so the first one is a bench warrant, case number A2WQJ9E. It's operating while driving a suspended, canceled, or revoked license. There's a $3,000 bench warrant for his failure to appear at arraignment on March 14, 2024.
Hay dos
And-
casos. El primero es el A2WQJ9E. Eso es operar un vehículo cuando tenía la licencia suspendida, revocada o no activa. Se expidió una orden de captura porque él no compareció a su lectura de cargos el 14 de marzo del 2024. El monto de la purga son $3,000.
Okay, now we have citation number AM3VBOE.
Ahora tenemos el caso AM3VBOE.
And that's driving without a license, operating while driving, license suspended, canceled, revoked. This was a second citation for the same thing on August 31st, 2025. We have AM3VBQE. No motor vehicle registration. And let me read the A form.
Tenemos el caso M3BOE. Eso es por conducir con la licencia suspendida, cancelada o revocada el 31 de agosto del 2025. Es la segunda vez que él comete esa infracción, presuntamente. Y también tenemos el caso M3BQUE, que eso es por carecer de circulación, de registración de la motocicleta o del vehículo.
I'm finding probable cause for both traffic infractions, driving while license suspended, and vehicle registration failure to have.
Determino que hay suficientes indicios que sustentan ambos cargos, el conducir con la licencia cancelada o suspendida y sin la circulación del vehículo.
Where do I
Judge,
Right here.
Okay,
may I be
PC.
heard?
Yes, go ahead.
¿Me puede escuchar, juez? Sí.
First, with respect to the bench warrant, Mr. Rodriguez Alfonso has a coloscopy bag and has been in and out of the hospital. And it's my understanding that that's the reason he failed to appear.
Primeramente, señor, en relación a la orden de búsqueda y captura por falta de comparecencia, el señor Rodríguez Alfonso tiene una colostomía y ha estado entrando y saliendo del hospital. Ese fue el motivo por el cual no fue a ver al juez.
How
No
about
fue
the
al juez.
fact that he's still driving without a license? Which
¿Qué me
was
dice
the
usted en
first
relación
charge.
al hecho de que sigue conduciendo sin licencia?
Judge, I was speaking on the warrant specifically.
I got it, but he's still committing the same offense allegedly that he did
Thank you, Judge.
before.
Yes, he's presumed innocent. So this
Right,
Bueno,
allegedly.
yo le estuve hablando acerca de la orden de búsqueda y captura. Sí, naturalmente, pero y se le presume inocente. Así es, sí. Presuntamente sigue cometiendo el mismo delito.
So if I may continue on the bench
Yeah, go
warrant
ahead.
issue, because that was not a willful failure to appear, we are asking you to reinstate his original bond, which I believe may have been an ROR in that case.
Y dado que él no faltó al tribunal intencionalmente, le pedimos que le devuelva su fianza original en aquel caso que tengo entendido que fue libertad bajo palabra.
In your honor, the state would be objecting,
Mhm.
and we would just ask for the respective mitigation that defense counsel is claiming to have had to send over to the respective ASA assigned in county when it gets sent over, or the motion to set aside a bench warrant. Furthermore, your honor, for the record, although they are older in time, the defendant does have a 1986 manslaughter conviction and a 2,000.
Okay, he's not ROR, so what's the standard bond for 150 and 150? So I'm issuing a bond of 150 on the AM3V BOE.
La fianza estándar, ¿cuánto es? Bueno, estoy poniendo una fianza de $150 en AM3 BBOE.
And I'm issuing a 150
Your Honor,
bond.
I hadn't yet made my argument with respect to bond on the new cases.
Señoría, no he hecho mi alegato en relación a la
Okay,
nueva fianza
what
en
is your
relación a los
argument
nuevos
on the
casos.
bond on the new case?
¿Cuál es
Judge,
tu
my
alegato en los casos nuevos?
Because that's what I was issuing. I haven't addressed the the bench warrant yet, so I was issuing the
Todavía.
bond on the new cases. So what is your argument on the new cases?
Como había
Judge,
dirigido a lo de la orden de búsqueda y captura, así cuál es el argumento en relación a suyo en relación a los nuevos casos.
Judge, a bond or an ROR is appropriate in this case. There are no allegations that he was driving in a way that would have caused that would have caused a risk to the physical safety of the community. The only allegation that I see is that he was driving with a suspended license and didn't have a vehicle registration. There are no facts to overcome the presumption in favor of non-monetary bond.
Señoría, en este caso no hay ningún alegato de que él estaba conduciendo de manera que ponía en peligro la seguridad de la comunidad. Solamente se alega que él conducía con la licencia suspendida y sin circulación. No hay hechos que se hayan citado que se sobrepongan a la presunción de que se le permita salir sin tener que pagar dinero.
All right, state.
Fiscal.
And Your Honor, state would be objecting that his prior convictions do show that he's a danger to the community.
How's that?
Your Honor, he was convicted of manslaughter in 1986.
And the manslaughter was for what? Do you know?
I do not have the case filed
Okay.
in front of me, Your Honor.
¿Y qué me dice usted, fiscal? Señoría, las condenas anteriores de él indican que él sí es un peligro para la comunidad. Él fue condenado por homicidio en el año 1986. Y ese homicidio, pregunta el juez, ¿por qué fue? El fiscal dice, no tengo ante mí esos hechos o esos datos, señoría. Muy bien.
All right, so I'm going to issue the standard bond of 150 on both misdemeanor cases. Both traffic infractions. AM3V BOE, $150 bond, and on AM3V BQE, $150 bond.
Impongo la fianza estándar en relación a los dos asuntos de tráfico. $150 por el AM3 BBOE y $150 por el AMB QOE.
Okay, and to state, what was your argument that there's a mitigation as it relates to the defendant indicating that he was what the defense argued was that it's presumed that that's why he didn't appear. What is your argument?
Fiscal, ¿cuál es tu argumento? La defensa ha alegado que hubo razones que justificaron que él no compareciera. ¿Cuál es tu postura?
State.
Fiscal.
Go ahead, Mr. Interpreter, if there's anything else you haven't translated yet.
Okay, but what is your position?
Excuse me, Your Honor, the interpreter is having difficulty hearing the state.
Okay. All right.
Your Honor, the state's position, if that is correct, that he was either in the hospital or suffering from a condition that allowed him not to come into court, then the state would have no objection to setting aside the bench warrant.
And Judge, just to be clear, it's already been
Señoría.
served. It doesn't need to be set aside. We are asking to reinstate the original bond. I wasn't asking to set it aside. That's not necessary.
La
Well,
postura
but
de la
you said
fiscalía.
the original bond was ROR.
That's what I'm asking for, Judge. Yes.
De la fiscalía es que si él tenía una condición que justificaba que él no compareciera, la fiscalía no se opone a que se desestime el monto de la purga por no comparecer. Señoría, yo no pedí que se cancelara ese monto, yo solamente le pedí, dice la defensa, que se le permitiera que usara la fianza original que él tenía, que tengo entendido. Dice el juez que era una orden de libertad bajo palabra, es lo que tengo entendido, dice la defensa.
The state has no objection.
All right.
La fiscalía no se opone.
For state, no objection. I'll reinstate the ROR on case number
One
Two
small
judge-
caveat, Judge, because he's being held on the other two cases, we just ask for a dollar bond instead of ROR, so he gets credit.
All right, I'll give you $1 bond.
Por su teoría, en los otros dos en este caso, como él lo está reteniendo en relación a los otros dos casos, le pedimos que le permita salir con $1 de fianza en los otros dos casos para que reciba crédito. Entonces le cambio y le pongo la fianza en $1.
All right.
Judge and Alpha 2 Whiskey Quebec, July 9 Echo, the bond amount is $1.
9 Echo, yes.
En el 9 Eco, sí, la fianza es $1.
And Judge, before we move on to the next one, I just think it's important to highlight that the conviction for manslaughter was 40 years ago. So to the extent that that played a role in Your Honor's decision to impose a monetary bond in the new cases, I would argue that that is
how many years
entirely
ago?
irrelevant. 40.
40. Okay. Let
Bueno,
me explain.
señoría,
Let me explain my
antes-
position so I don't have to
antes
keep
de-
repeating it all the time.
De seguir adelante, quiero señalar que la
If a
condena por
person is out because he has a new case, whether it's RR or on bond, one of the conditions is don't commit any new crimes. Now, this is allegedly. If you get arrested on a new crime while you're out pending another crime, I'm going to hold you. I'm going to issue a bond. I'm not going to RR you again. All right, that's my position. Now I can make this position every time we go forward, but that is my position. So I'm not going to RR. I'll consider other alternative, but I'm not going to RR someone that has been arrested on a crime and then picks up a new case. It's not going to
Judge,
happen.
I just
Bueno,
don't believe
quiero
the
que
law
esto quede bien
supports
claro.
that.
All right,
Una
that's
persona
fine.
que está en libertad libre bajo palabra o libre bajo fianza o caución, si usted comete algún otro delito, lo arrestan por alguna otra cosa, yo no le voy a permitir salir nuevamente bajo palabra. Le voy a exigir que usted pague una fianza para salir. No le voy a permitir salir bajo palabra en esas circunstancias.
All right, so let's go to the next one.
Pasemos al próximo.
This is it's not a bench warrant, so it's a new case. This is Alberto Villaortega Jefferson.
Mr. Villa Ortega requires the services of the Spanish interpreter.
All right, and there's let me see, there's two cases, case number or ticket number A77034E ALCDHHE. That's the
Hay
second
dos
case.
casos, el A77034E y el ALCDHHE.
Okay. All right, let me read it. The A form. One of them is for the first one, A77034E is for, looks like a DUI, yes. It's a DUI. And then the second one is not having a vehicle registration. So let me read the A form.
El primer caso, A77034E, es por conducir embriagado, bajo la influencia de alcohol, y el segundo caso es por carecer de la circulación, de la registración del vehículo. Voy a leer el formulario de arresto.
I'm finding probable cause for the DUI.
Determino que suficientes indicios sustentan el cargo de conducir embriagado.
Judge, I may have missed it, but I don't see the portion of the A form that provides probable cause for the no registration.
Yeah, that's what I'm looking for.
Debería, quizás la pasé por alto, pero no veo la porción en el formulario de arresto que sustenta el cargo de carecer de circulación. Yo la estoy buscando también, no la encuentro.
I mean, all I see here is dealing with the DUI state.
Lo único que veo aquí tiene que ver con el caso de conducir embriagado. Fiscal.
The state would agree that there are no facts within the arrest form that give rise to probable cause for the failure to.
All right, so ROR, not OR, no PC on on the ticket number ALCDHHE, release outright.
La Fiscalía no observa ningunos hechos en el formulario de arresto que sustentan la suficiencia de indicios en relación al cargo de carecer de circulación. Por tanto, en el caso que es el ALCDHHE, no hay suficientes indicios. Queda libre sin condición.
As it relates to any priors?
Antecedentes.
No priors, Your Honor.
No tiene antecedentes, juez.
Okay.
Yes, Judge.
Counsel?
In this case, we are asking for ROR. In light of the fact that Mr. Villa Ortega has absolutely no priors, ROR is sufficient to reasonably assure the safety of the community and his presence in court and the integrity of the judicial system. He is unable to pay any amount of bond, so any bond in excess of an ROR would be holding him tantamount to no bond. And again, here the presumption is in favor of non-monetary release.
Okay,
Nosotros pedimos que se le permita salir bajo palabras, señoría. El señor Villa Ortega no tiene antecedentes y el que se le permita salir bajo palabra, eso es suficiente para asegurar la seguridad de la comunidad, el respeto a los tribunales y no tiene fondos para pagar cualquier cantidad de dinero para salir bajo fianza. Por tanto, el imponerle cualquier monto es equivalente a retenerlo sin derecho a pagar fianza.
Okay, I'm issuing a standard bond 1,000.
Impongo la fianza estándar, $1,000.
All right. Okay, I have a bench warrant of $1,000 on AJKT5XE. Failed to appear for trial in front of Judge Nunez on 8/13.
Judge, Mr. Correa Garcia is not present yet. If we could hold on a minute.
All right.
And Judge, Mr. Garcia, when he gets to the podium, Judge, he has an immigration hold.
Okay.
Also, he has a related felony, Judge.
Oh, okay. Is it coming up later?
Sorry,
No,
correction.
Judge,
Did
should
you
be
say felony
coming right
hold?
now, Judge.
It's a felony hold? Okay, perfect.
No,
Correction.
Judge, immigration hold and a related felony, Judge.
He has a new felony,
A
he
new
will be
felony,
on your
Judge.
bond hearing calendar.
Okay, so he has a new felony today?
Yes.
No,
Yes,
all right.
Judge.
Okay. Is he coming?
He's
All right.
here for you, Judge.
All right. You're Jose Rogelio?
He requires the services of the interpreter.
¿Es usted José Rogelio? ¿Es usted José Rogelio?
I can't hear. What is it?
He said yes.
¿Qué dijo?
Sí, Rogelio Carrillo.
Yes,
Okay,
Rogelio Carrillo.
Jose Rogelio Carrillo Garcia. Okay, he has a bench warrant for $1,000. He failed to appear for trial on 8/13/2024 in case number AJKTSXE. And there's
Y él tiene una orden de búsqueda y captura por no comparecer a su juicio el día 13 de agosto del 2024 en el caso AJKPXE y se le impuso una purga de $1,000.
let's see what the charge was.
Deje ver qué
That was a no valid driver's license.
Esto fue por no tener una licencia de conducir válida.
Then we have case number AM3VDTE. Let me see here. That is for driving while license suspended.
Después tenemos el caso M3FDTE. Eso es por conducir con su licencia suspendida.
And I have JAJKTTBE. And that is for, what is that for?
Y tengo también a la JKTTBE, y eso es porque,
It doesn't say, let me see.
no lo dice.
Dave, you want to look at it?
¿Quiere mirarlo?
Dave, you want to appear for a second and come up?
Puede acercar un momento.
Oh, this is registration, failed to display registration.
Ah, esto es que no mostró la circulación, la registración.
And then I have okay, those are the two cases. Let me read.
Para los casos voy a leer.
Warrant. This is the warrant case.
Judge, I'm only seeing the
Made
open
contact-
felony and the bench warrant case. I don't see any other.
Made contact with the defendant, residence traffic stop.
Solamente veo el caso por delito grave y el caso por la orden de búsqueda y captura. No veo nada más.
Okay.
Fiscal.
I just see, that's what I see.
In your honor,
An A form for a warrant.
Un formulario por una orden de búsqueda y captura.
the two cases I have in front of us is the bench warrant NBDO, as well as the DWS ending in DTE.
Right.
Lo único que
But there's
veo
no A,
es
there's no A form, just a ticket then? Because let me see what the ticket
la
says.
orden de búsqueda y captura y algo que tiene que ver con el asunto de conducir con la licencia suspendida.
Okay, the
Pero
ticket
entonces no hay
does,
formulario de arresto.
the first ticket, AM3VDTE indicates driving while license suspended, operating while driver's license suspended, canceled, revoked. So it does indicate that on the ticket itself. There's no A form for it, but there's a ticket.
But Judge, you're
Entonces,
finding
en
a
aquel caso,
Wait, and the
AM3
second one is no
VDTE,
driver's license.
solamente
Never had
conducir con la
one
licencia
issued
suspendida.
if valid at time of citation was issued. And that's also on ticket number AJK7, AJK So, okay, I see it here. I found the A form. While on routine patrol, I observed a black scooter.
Y entonces el segundo caso es por no tener jamás licencia y conducir un vehículo. Aquí veo el formulario de arresto. Estaba conduciendo un motoneta negra.
No driver's license issued.
No se le expidió licencia.
Judge, I only have a copy of the warrant A form, but you're saying you have an A form.
I have an A, yeah, I have an A form for, I have the tickets and then I have an A form. And it says on top, unless this is, oh yeah, that's the one for the bench warrant. So no, I don't have an A form. I just
Because-
have the tickets.
Judge, my argument is that you can't find probable cause based on the tickets themselves. The reason you can find probable cause based on a warrant is because it's a sworn statement. So the tickets themselves do not provide probable cause for anything.
Señoría, no se puede determinar que hay suficientes indicios en base solamente a la multa, al citatorio, porque ese es un documento que no está juramentado. Y si no hay una declaración juramentada, no puede haber suficiencia de indicios.
Yeah.
Sí.
Yeah, I know.
I can't hear the state.
No, it wasn't
No
the
puede.
state, it was the clerk. I know the charging document is the ticket itself.
Sí, el documento acusatorio es el citatorio en sí.
But Judge, the fact that there's a charging document does not mean that there's probable cause. Your Honor still has to make a finding of probable cause based on.
Yes, and it says on the charging document, DWLS operating, there's not a Richardson violation in this, DWLS operating while driving suspended, canceled, revoked. And so that's specified in the ticket on ticket number AM3VDTE, and also on ticket number DW, no driver's license, never had one issued if valid at time of citation was issued, and that's ticket number AJKTSXE. I'm finding probable cause for both.
Judge, just if I may
Sí,
lay the record, please.
aquí
Yes, go ahead.
I'll
hay
let the interpreter go.
aquí se alega que él estuvo conduciendo con la licencia, el privilegio de conducir cancelado, revocado o anulado en relación al citatorio AM3BDTE y que él nunca recibió ninguna licencia en el caso AJKTSXE.
Judge,
He also has a hold for immigration.
Okay.
Señoría de Inmigración también nos ha pedido que lo retengamos.
Judge, a charging document is not something upon which Your Honor can base a finding of probable cause. If Your Honor could, if a charging document could replace any finding of probable cause necessary by the court, the state would just file informations for every single case at first appearance to take away that authority from Your Honor to have to go through and find probable cause. Just like the fact that if an A form is not signed by the officer, then someone has to be released outright because there's no probable cause. Your Honor cannot rely on anything other than a sworn statement at this point to find probable cause. A ticket is not a sworn statement, and any finding of probable cause based on a ticket is improper under the law.
El tribunal no puede basarse en un documento acusatorio para determinar que hay suficientes indicios. Si el documento acusatorio fuese suficiente para establecer suficiencia de indicios, en todos los casos la Fiscalía presentaría un documento acusatorio y, por ejemplo, un formulario de arresto que no haya sido firmado por el policía no es suficiente para establecer la suficiencia de indicios.
Okay, there's a signature here. It says it was signed by Officer J. Pineda, 44286.
And did he swear to it under penalty of perjury? That is the question. That is the only question relevant to this finding.
Okay,
Hay una firma aquí, dice que fue firmado por J. Pineda, el policía, pero eso está juramentado. Si no está juramentado, entonces no es suficiente. Fiscal.
In your honor, the defendant's traffic printout shows that his license was suspended in February and notice was given.
Okay.
Señoría,
I'm talking about the new
de
cases.
tránsito
The new
del
tickets.
acusado dice que le suspendieron el privilegio de conducir en febrero de este año y que él recibió notificación. Estoy hablándole del nuevo caso, fiscal.
Your honor, with the license suspension?
Go ahead and make the argument.
Con la licencia suspendida.
The
Haga tu
traffic
argumento.
printout itself shows that there was a suspension given in February and that notice was given.
Well,
And
the
that is not a
argument,
sworn
right, but the
statement.
argument from the defense is that this was not sworn to. It's a ticket, there's a normal ticket like any other ticket that's received and is signed by the officer, but she's arguing that there's no, I can't find PC because the officer didn't swear to.
Sí, pero el argumento de la defensa es que este documento no está juramentado, es un citatorio normal, pero la defensa me alega de que no está juramentado y que no puede usarse para establecer suficiencia de indicios.
In your honor, is this for the DWS or the NBL arguments?
For
Y
both.
señoría, esto es por el conducir con la licencia
I'm
suspendida
not even addressing the
o
bench
sin
warrant
licencia.
yet.
Todavía no estoy
Addressing the two
dirigiéndome
tickets.
a la orden de búsqueda y captura, me dirijo a los dos citatorios.
The argument is simple, that whatever the officer wrote on the ticket, that's what the defense argument is, not sworn to, therefore it's not, I can't find PC.
It's
I
the
could
same
hold
argumento
it-
reason.
sencillo
I could
es
hold it
que
for tomorrow.
lo que el policía puso en
We
el
can waive
ticket no es
interpretation for this
suficiente.
issue, please.
Podemos prescindir de la interpretación para este asunto, por favor.
For this issue particular, we can waive.
En particular, esto lo podemos prescindir.
All right, so you want to reset it for tomorrow? To have the officer come in?
Excuse me, Your Honor, may the interpreter cease interpreting until directed to interpret by the court?
Yeah, I don't know what the issue was, but go ahead, you can continue interpreting. I'm asking the state, does he What is the argument as it relates to the defendant's argument of that whatever is in the ticket, I can't consider because it's not sworn to. It is signed by the officer.
Le
And
pregunto a la fiscalía.
and I
I'm
know,
waiving, I'm
and I
waiving
know,
interpretation for this issue because I cannot hear what's going on while the interpreter is going. So I would like to waive interpretation as it pertains to whether something needs to be sworn to, please and thank you.
okay, all right, go ahead. So state, the question is, the defense is arguing that because it's not sworn to, it is signed by the officer. And all these are the charging documents and a violation. This is all there is, but there she's arguing because it's not signed, it's signed to but not sworn by the officer. It's not, the court can't make a probable cause finding based on just a signature.
That's
So
exactly
basically,
correct.
I have to ignore everything that's in the ticket.
Your Honor, we would ask for a reset for a PC hearing.
All right, got it. Set for tomorrow.
Señoría, pedimos que se postergue esta vista hasta mañana. Muy bien, el caso queda postergado hasta mañana.
Reset.
So Judge, both, the bench warrant and the traffic. citation-
Everything will be reset for tomorrow.
Thank you, Judge.
Okay,
Entonces, todo queda
reset
postergado. Sí.
for PC. Two. There you go. Okay, case number AM or ticket number AM3VE0E. It has a pending felony case.
Yes, Judge, he has a new felony. Actually, a related felony case, Judge.
Right, related felony.
He requires the services of the interpreter.
Este es el caso AM3BE0E. Su señoría, él tiene un caso por delito grave pendiente y necesita un intérprete.
Okay, I'm finding probable cause for no valid driver's license.
Determino que el cargo de carecer de licencia
And I'm
válida.
finding probable cause for count 2, resisting an officer without violence to his person.
está sustentado por los suficientes indicios y que también hay suficientes indicios del segundo cargo, resistirse contra el policía sin violencia.
Judge, that count is related to the felony, Judge.
Señoría, aquel cargo está vinculado al delito grave.
Right, but it's still a misdemeanor.
Correcto, pero sigue siendo un delito leve.
Judge, for case, he's on your felony calendar.
All right, so you just want me to address the ticket? All right,
Just
so
the
let-
ticket.
all
You'll
right,
see him
so-
again on your felony calendar.
All right, so I find probable cause as to count 2, and we'll address count 3 later.
Bueno, determinó suficientes indicios en el segundo cargo, el tercer
first-
cargo lo ventilaremos más adelante.
State priors.
The defendant has
Antecedentes.
no prior convictions. There is a withhold of adjudication in 2010 for petty theft, as well as a withhold of adjudication for concealed substance possession and possession.
We cannot hear the state, Judge, yet again.
I apologize, counsel. I am very close to the mic. I just don't think the mic is very good. There are no prior convictions, Your Honor. There are a few withholds of adjudication, but no prior convictions for this defendant.
Okay,
No
so
hay condenas, hay unas retenciones del fallo condenatorio anteriores, pero ninguna
what's your
condena.
recommendation for bond?
¿Qué me recomienda en fianza?
Your Honor, the state is requesting the standard bond for the no valid driver's license charge, which is $500. And the reason the state is requesting this and asking Your Honor to issue a monetary bond in spite of the presumption that the defendant be granted a non-monetary bond is because of the circumstances of the arrest, which Your Honor is allowed to consider under the bond statute. The circumstances in this situation include allegations that he was fleeing and eluding police officers, which we will address later, and resisting officers in their investigation. So because this is intertwined with those, the state would be requesting a monetary bond.
Y, señoría, le pedimos una fianza estándar y en este caso pedimos este monto que refuta la presunción en contra de una fianza económica. Es las circunstancias del arresto que su señoría puede tomar en cuenta a la hora de fijar la fianza, de acuerdo con la ley que tiene que ver con el fijar fianzas. En este caso, el acusado estuvo huyéndole a la policía y estuvo obstaculizando su investigación. Por tanto, pedimos que se le ponga la fianza estándar, $500.
Okay.
Judge, if I may respond.
Yeah, go
¿Puedo
ahead.
contestar? Adelante, sí.
First of all, the standard bond here is not $500. The standard bond here is $150. Just want to correct that from the state.
Primeramente quiero corregir lo que ha dicho la fiscalía. La fianza estándar por esto no son $500, son $150. Quiero corregir eso.
Second of all, Judge, precisely the reason that you have to set bond for all counts is because all counts should be considered separately. And so the circumstances of the case are captured by those other counts and should be reflected in the bonds of those counts. I'm not done yet. I'll just let the interpreter go.
Y sería la razón por la que usted debe fijar la fianza en todos los cargos es porque todos los cargos se deben tomar en cuenta por separado y cada circunstancia de cada cargo se toma en cuenta en relación a ese cargo.
Despite the fact that there are allegations of fleeing and eluding and resisting, there are no allegations within the A form that indicate that anyone's physical safety was at risk based on the alleged actions that Mr. Aguilar Sales took.
Y a pesar de que hay indicación de que hubo esfuerzos para eludir o huir, no hay ningún tipo de indicación de que lo que hizo el señor Villegas Salazar puso en peligro la seguridad de nadie que estuvo ahí presente.
So the
Okay,
fact,
go ahead.
Judge, the fact that he has absolutely no prior convictions and the fact that even here the allegations do not allege that anyone's physical safety was at risk, we are asking for a $1 bond in this case. The allegation is no valid driver's license. That is
Okay,
appropriate.
I'm issuing the standard bond 150.
Dado que él no tiene condenas anteriores y que nadie corrió peligro por su seguridad personal, pedimos una fianza de $1. Impongo la fianza y dispongo la fianza estándar, $150.
Okay, I have a felony warrant in case, let me see, what was the case? It's
Judge, are you on
A,
the
that's
next
the,
case now?
yes, I'm on the next case. That was this one? Okay. I'm on the next case is AJOB M8E is Goldwire Asal, bench warrant 250, Failed to appear arraignment on October 24th, 2021. Is he present? Okay,
He's present, Judge.
all right. Does he have priors?
One moment, Your Honor. Your Honor, the defendant in this case does have priors. He has a previous battery conviction from 2009. It was a domestic violence battery conviction, which included 2 charges of domestic violence battery. It also included probation violation for which probation was terminated. Your Honor, there is also a 2008 conviction for open carrying a weapon. And there's a 1994 conviction for petty theft, Your Honor.
Okay, those are over 10, the 94 is way over 10 years, but any current conviction?
Your Honor, the oldest convictions for this defendant are from 2009 and 2008.
Okay. All right, what's your stand on the bench warrant? The 250?
Your Honor, for this case, the bench warrant amount is 250. The state would ask that that be retained and that the defendant post that before being released.
State defense?
Judge, first of all, whether Mr. Goldwire is a danger to the community based on any of his priors would have been addressed by the bond at his, or by the bond hearing judge at his first bond hearing, and that judge clearly determined that he was not a risk to the physical safety of the community as it pertains to whether he is a risk of not appearing at court. Mr. Goldwire has a good address. It is the address listed on the A form. He never received notice of his previous court date, which is why he did not attend. But should any future notice go to that address, he will receive it and he will be in attendance. So we're asking that his original bond of ROR be reinstated.
Thank.
And Your Honor, I don't believe that any of these considerations are proper for a bench.
I agree. I mean, if a judge gives you a bench warrant 250, who am I to set it aside? At this point, I'm keeping the bench warrant for 250. I mean, I'm issuing a bond for 250. He can.
Judge, the reason it's appropriate to mention at this stage is because the bond, when someone doesn't appear, the judge who issues the warrant has no idea why the person doesn't appear. That is precisely why it is relevant here, because this is information that the original issuing judge of the bench warrant did not have. That is why it is relevant. I'm not sure why there's any argument that it's not relevant.
Oh, that's fine. I mean, and I'm hearing your arguments, but a judge issued a warrant for 250. I'm going to maintain it. I'm going to reissue it as a bond for 250. If if he can't post a bond, then you could put it on the motion calendar in front of the judge to reduce it. But at this point, I'm going to keep the bond as is.
And counsel, just so the state's position is clear for future cases, what the state is arguing is not relevant. It's information.
I still can't hear you, state.
Thank you, counsel. What the state is arguing, just so it's clear for future cases, of course, information about why the defendant did not appear is relevant to the bench warrant discussion. I was arguing more to the fact of questions about safety to the community, things like that, normal considerations under the bond statute. When it is a bench warrant, that is when the state's position is that information is not relevant.
All right.
Well, the state was the one that was bringing up all the priors, so I don't know why you're now saying it's not relevant.
Counsel, I'm just letting you know for future cases.
Give me a second.
Okay, then I think the priors aren't relevant to bring up.
Give me a second. What's going on?
This case for to set aside the D6. That's an suspension.
So set aside this.
Yeah, to do here, just like set aside DL suspension. Can make it for the PC hearing.
Okay, so I'm setting, the clerk is informing me I should set aside the driver's license suspension
On Carrillo Garcia.
on Carrillo Garcia, so it will reset on AJKTTBE and the purpose for that.
For the PC hearing tomorrow.
So there'll be a PC hearing tomorrow in front of the division.
Continue.
All right, next case. Jordan Lewis Perez.
I believe he's a bond out.
Case number AM4RTHE. And that is Penton, Heriberto Penton. Is that Mr. Heriberto Penton present?
Yes.
All right. This is case number AM4RTHE. Okay, this is, I'm finding PC for driving while license suspended knowingly. Priors,
Your Honor, the defendant in this case has a previous conviction from 2017 of trafficking in oxycodone. In that case, there is also a conviction for cannabis possession, 0 to 20. Aside from that, Your Honor, the defendant has no prior convictions.
does the defendant want to take a plea? A CTS?
Judge, we don't generally advise people to take pleas at first appearance.
I know, I'm making an offer to close the case if he wants to take a plea.
Okay, well, I would need time to speak to him, Judge, if we can have a moment.
Okay, go ahead.
Judge, can we pass? My colleague is going to speak to him while we continue
Go ahead.
calling cases.
All right, next case. I have a bench warrant. Failed to appear arraignment on 8/28/25 in Judge Nelson.
He's not present yet, Judge.
He's not present, okay.
Not yet. If we could wait 1 minute.
Yeah, I'll wait.
Mr. Kemp? Okay, he's present.
All right, sir, you have an outstanding bench warrant, failed to appear for arraignment on 8/28/2025 in front of Judge Nelson. This was a ticket for, let me see, DWLS, driving with a suspended driver's license knowingly. And the bench warrant was issued at $3,000.
Judge.
Defense, you want to make an argument?
Yes, Mr. Sheldon is homeless and never received notice of that court date. So his original bond of ROR should be reinstated and he should be given a date certain. That it was not a willful failure to appear.
Defense?
One moment, Your Honor.
That's what I was looking for.
Into something.
Judge, I can't hear what's going on.
No, I was getting the plea colloquy in case your defendant wanted to take the plea. That's all. So state, you were looking at something?
I guess, it's the state's position that the event warrant shouldn't be set aside. There's a repeated disregard showing up to court with this respective case, and there are multiple other prior DWS and traffic.
When you say repeated, that he has failed to appear, what do you mean?
He's had multiple other criminal failure to appears, aside from this case, Your Honor.
Okay, so what do you propose the bond should be?
And Your Honor, the state would be asking that this bond be set at.
Can the state please speak into the microphone? We cannot hear you.
And Your Honor, the state would just be asking that the bond be set at $500.
Okay, let me see. What is he charged with in this case?
Driving with a suspended license.
I'll give him does he want CTS on this one too?
Judge, we would have to pass again so we can speak.
All right, go ahead. I have a few more and then we can address them. All right, the next one I have is Alexander Soriano Glenn. His case, is he present?
One moment, Judge. We're waiting for Mr. Soriano. One moment, please.
He's also in collections, so could you also put collections next to that? To take him out of that too.
Judge, we can recall Mr. Penton.
Okay, Mr. Okay, Heriberto Penton.
Yes, Judge, Mr. Penton wishes to accept the court offer of adjudication with credit for time served.
Okay, sir. And have you seen the rights video played, sir?
Yes, I have before.
Okay. All right, so you're familiar with the rights you're waiving based on what was on the video, correct?
Correct.
All right. So to summarize, you accept the plea offer today. This case will be closed and you will be assessed court costs. If you are not a U.S. citizen, it could subject you to deportation. If you commit a crime in the future, your future penalty might possibly be enhanced. If you do not wish to accept the plea offer today, your case will be set for trial and your custody status prior to trial will be addressed by me. Are you willing to accept the plea today of credit time served?
Yes, sir.
Are you pleading guilty?
Basically, right? Correct? Yes.
Yes, okay. I find that you are, have willingly accepted a plea, that you have willingly waived your, oh my God. Yes, you have willingly waived your rights. I am finding you guilty of, let me see, driving while license suspended, and I'm giving you credit time served. All right, so you're free to go. Thank you, sir.
May I just request that you waive his court costs, given that he's indigent?
You can write it down.
Okay.
It's down here, you're putting, guilty,
Okay,
and it'll be,
TTS,
CTS right there,
right?
and then waive court costs.
I will waive court cost. Right?
Initial here for waived. And then sign at the bottom, this is for the PD fee.
All right. That's not waived.
Well, you have to, that's why it's separate order. It's not
Okay.
automatic.
All right. All right. Going back to let me see, going back to Alexander Soriano Glenn. He has a related felony.
We're still waiting for him to come in,
Okay,
Judge.
all right.
Soriano? Oh.
Communication, guilty, that check mark there.
Mr. Soriano is present.
Okay, sir. Good afternoon.
Good afternoon, Judge.
You have here, we're doing the traffic violation. You have a pending felony, which will come up afterwards. Right now, we're dealing with the traffic infractions. Okay, so it's ticket number AM 88 NYE. And that is DWS, driving with a suspended license. And then we have reckless driving, case number AM 66 MPE. Let me read the A form.
Judge, I do have a probable cause argument.
Yes, go ahead, make it.
Again, I may have missed it, but I don't see any probable cause in the A form to support the driving with a suspended license count.
That's what I was looking for too.
I don't see any portion that states that his license was suspended.
Judge, corrections, if I may, I'm so sorry, Judge. Mr. Soriano has 2 new felony. It will be
Right.
under bond hearing calendar, Judge.
Yeah, I know that. I'm just addressing the misdemeanor, the traffic infractions.
Yes, Judge, thank you.
Yes, Your Honor, the state also is unable to find the probable cause for the respective DWF charge.
All right. I do find probable cause for the reckless driving.
And
You want to
Judge, that's for
address?
a standard bond of $150 for the reckless count.
Okay. State?
No objection.
Yeah, I would tend to agree. And on the DWLS, no PC. Release. All right, and we'll address the felonies when he comes back. I think I signed everything, yeah. Okay, I think the last, no, two more traffics, right? Let me see. King Hernandez. Yes, I have two more traffics. I have the first one is Melvin Rutledge. Case number ALC6J8E. DWI. Is driving while intoxicated with property damage and injuries, probable injuries. Is driving under the influence. And there's a felony, which will come in later, but right now is DUI, driving under the influence, and damage to property or person, under AL6CJ8E. I find probable cause for the DUI. I am not going to enter, let me see. Okay, I do find probable cause for the DUI, damage to property or person. And priors and
Judge, yet again, we cannot hear the state. I don't know how many times I have to repeat myself.
Thank you for your vigilance, counsel. The defendant in this case has no priors.
okay. And well, let me hear from the defense as it relates to bond.
Judge, we're asking for standard bond in this case.
Okay. All right, nothing more further needed. 1,000. Bond. And then we'll address the bond on the felony. Don't worry. All right, the last one I have for the traffic, we're still pending on the other one, if he wanted to take a plea or not.
Judge, can we have Sheldon Kemp?
Okay, all right. Mr. Sheldon, how are you? Mr. Sheldon Kemp, okay, I offered a plea of CTS, or credit time served. Would you like to take that plea? Can you bring up the felony stuff? We can get started right away.
Judge, if,
Yes, go ahead. Is there fun? Is there no A forms?
The paperwork is not gonna work.
Okay,
There.
all right, so let's get that so we can get started because we're running late.
Judge, he's not taking the plea.
He's not?
No, he's
Okay.
saying we're pressuring him into it, so it's not
No,
appropriate.
that's
for him to take
fine.
a plea right now.
What was his original bond?
Because
No,
He was ROR, okay, all right, sir. That's fine, sir, don't worry. What was his original bond?
A bench warrant judge?
Right, but do you know what the original, was he ROR first?
Last tender bond, you gave the last is 150.
What was the original bond he got when he first, do you know?
Well, it was the,
It's showing 3,000 on the jail card, Judge.
That was the bench warrant, but do you know how much was when he first came to first appearance, what the bond was?
Judge, I believe it was ROR.
Okay. I'm not inclined to give him 3,000. I don't know why it was given, but I will give him a bond.
hey, come on. It was a bench warrant at arraignment judge.
Originally?
Yes.
So how many bench warrants does he have?
No, it was just this one, judge.
Okay, so when he first got here,
Yeah.
was he released just ROR?
It was his first appearance. He bench warranted at first appearance, so he never had an ROR.
So he never came to, how did, and then?
He did not bench warrant at first appearance. He's either in custody for first appearance. or
Yeah,
he's
that
out.
that makes no sense, yeah.
And also, we once again cannot hear the state.
No, that's not the state, no, that's not the
Oh.
state, that's the clerk, he's talking to me. I'm asking him.
On 8/28, at first appearance for arraignment with Judge Nelson, he bench warranted.
Oh,
It was arraignment, Judge, not first appearance.
right, that, and what I was trying to get at is, what was the original, did he have an original bond or was it an ROR?
Judge, it was an ROR, I believe.
It was an ROR, okay, I'm not gonna issue a $3,000 bench warrant, I'm gonna issue what's the standard bond in this case?
150.
I'll issue a bond for 150. When will he appear in front of the, for arraignment, on calendar?
Doesn't bond out in 2 days. He does bond out. It will be 30 to 45 days.
Okay. Because is he home? No, he's not homeless. He has an address. All right, so sir, I'm gonna issue a bond of 150. All right. Just make sure you appear for, if you bond out, then you would have a hearing within 30 days. If you don't bond out, then you'll go in front of the court within the next 2 days. All right? There you go. All right, the last case I have. All right, thank you, sir. All right, I have Joaquin Hernandez. You have case number AM4RUCE, operating while driver's license suspended, canceled, or revoked. And there's a warrant, there's a bench warrant of $1,000.
Judge, if I may address the bench warrant, please.
Yes, okay.
Mr. Hernandez has informed me that he moved, and so any prior notice that was sent of that court date presumably went to the wrong address, which is why he missed court. We can file a notice of or change of address so that his updated address can be reflected in the file for both of his open cases, but that is why he missed court. It's not a willful failure to appear, and we'd ask that his initial bond, which I believe was ROR, would be reinstated.
That's on case number ALEIASE.
Yes.
All right, let me read the probable cause as it relates to this case. Not the bench warrant case, the one he was arrested. Okay, I find probable cause for driving while license suspended. Okay, and so the other case was the same type of case, state. He indicated that he moved, that's why he missed the first date.
Yes, Your Honor, it's the state's position that the defendant could have filed a notice of change of address independently.
Okay.
That does not suffice as a good enough reason for the state.
All right, what I'm gonna do is, given the fact that he basically is doing the same thing, driving again, allegedly driving again without a license, I'm gonna issue a $150 bond on both cases.
So Judge, 150 on the bench warrant,
Yes,
the new case?
yes.
Yes, Judge.
So both cases, 150.
Thank you, Judge.
Are we ready for felonies?
They're coming.
All right, I guess we take a break into the felonies, get here.
Judge, they're here. They've been ready, Judge.
Oh, yeah, but not
Recording
here.
stopped.
I don't have anything.
Signature?
So listen, I'm raring to go as soon as they get here, but at this point, I don't have them. There's nothing for me to do. I missed all these.
Yeah, all right.
Like my JA, he keeps track of
That's
everything I do.
That's it.
Thank you.
Me too.
He does, stamp everything and pass it, right? Who gonna be able to, not so Renee gonna be here, yeah, she could go to the. About some of them. There's another attorney, he's
Thank you, guys.
Ready? Oh, bye.
Recording in progress.
This here would be.
Do you see the check?
Hi, how you doing?
Do you look at the price?
Absolutely.
It's number 25 on page 1. Marcus Corridor. Yeah, we have 3 at a time.
Okay,
One for ASA, the ASA, and one for the private attorney.
all right, okay. Matters.
Supposed to be done. We probably took it and. You know how to go to the.
Ready? Are we ready? All right, let me find the priors on this one. Leon leading. Here we go.
Hey, y'all.
I got
The defendants on the screen.
Yes.
Okay, they all legal. Tell them all right.
Okay, well, I just want to get these are the ones that we're doing before, so I'm just trying to get the priors and put it together.
1 second, Judge. Which case are you calling out of turn so corrections can bring the inmate?
All right, so I was handed 3 cases.
Okay.
Let me give you the names. I have Lady Menendez Zabala, Stephanie Canizares, and Marcus Corredor.
Yeah, she's on page 3 at the bottom. So it's Lady Menendez, and then the second one, Judge, was who?
I have Stephanie Canizales. And then the third, I have Marcus Corridor.
Corridor. Okay.
Yes,
And then Lady Menendez has a private?
apparently.
Okay.
I'm trying to find her priors or Marcus's prior. Give me a second.
Judge, this is corrections. Can we pass Miss Connor-Saris? They're gonna try to Zoom her. She's not gonna be able to come physically here.
All right, we'll leave it. Okay, so I'm leaving this one for last, Marcus Corredor. No, wait, which one? The ladies? Okay, so that one, you're trying to get her here, ladies, Mandezabada, right?
Menendez Adala. Judge,
Yeah.
I believe this is Lady Menendez.
Hi, hello.
Menendez.
Nice to see you again.
Latest, Menendez Abdallah case.
Yes.
The state has filed a motion for pretrial detention,
Mhm.
as well as the $250,000 bond on the arrest warrant. Whenever the court is ready, I'm happy to address the matter. Also, Judge, the brother of the deceased in this case is present in court. It hasn't been here all day.
All right, so, who was it that told me that you're trying to get her here?
Judge, that will be number 5. We're talking about number 5, not number 8.
Is
Stephanie Canizares.
okay.
They're running with the.
Okay, I
Judge,
have. All right, so wait. I have Lady Menendez Abdallah. Is one of the persons I was asked to bring up. I have Stephanie Canizales, and I have Marcus Corredor. Which one are you telling me that you cannot bring and you want me to hold them for last out of the three?
Miss Canizares, she's gonna be zoomed, so we could hold her or pass her for a little bit.
Okay, that's fine. If you don't have her available yet?
Not yet. Miss Menendez has an immigration hold just for your
Okay,
reference.
all right. All right, let's wait until they have her. All right, you could, let's see.
They haven't it's my defendant that's missing.
Okay,
And Gonzalez is, mine is all upstairs.
okay, which one's your case, Miss Adams?
Latest Menendez. Sometimes she's the latest Abdallah Menendez and sometimes she's latest Menendez Abdallah.
Okay, that's not, that was,
She's there.
that's the one that I was told that wasn't here, that was supposed to be on.
Stephanie was on.
Stephanie Canizales is the one that's on Zoom, that's not, all right. All right, so let's address a Lady Menendez Carvalho. There's this was an arrest warrant, right?
Correct, Judge, under case F 31634. An arrest warrant was issued for the defendant. The bond amount was set at $250,000. This defendant was basically had fled the jurisdiction before the police could arrest her for the DUI manslaughter, Judge, Your Honor, for about almost 20 years. Her brother and many in law enforcement have sought to locate her. She finally was located in Mexico. Mexico deported her, and the authorities were able to take her into custody. And she was booked into TGK, I believe, Friday night going into early Saturday morning. At that point, the city of Hialeah Police Department also filed an arrest for her under case F 25-18876 for one count of vehicular homicide stemming from the same incident, because she not only was driving with an unlawful blood alcohol level, but she also was driving in a reckless fashion that caused the death of Gloria Hall.
Okay.
So at this point, Judge, the state has filed a motion for pretrial detention. I recognize that there is a hold for her from immigration, but as I put in my motion, because of some of the complexities of immigration law and sometimes the state of flux in which our country is at with
Right.
immigration, I don't want to take any risk that we are going to lose this woman again. It took a
Right.
lot of effort to get her into custody. So I'm asking Your Honor to initially grant the motion for pretrial detention as to both cases, but then for this matter to be printing on Judge Gamez's calendar for tomorrow so that he can then schedule a date and time for the hearing if the public defender's office or any other attorney that may be coming in on the case for this defendant would like to have such a hearing. The state has to be ready within 5 days. I will be ready.
All right, so this was an arrest warrant issued by a judge, so the probable cause has already been made by the judge. Is there any new case that I would have to review at this point?
Your should have a affidavit.
I have it.
Judge, and she does need the services of the Spanish interpreter.
Señoría, ella necesita servicios del intérprete de español.
Okay, now they're telling me that they need the interpreter.
Judge,
Sorry.
the only reason why
Me acaban de decir que necesita servicios del intérprete, lo siento.
Yeah. All right, go ahead.
Adelante.
Do you want to repeat everything, sir?
Excuse me, Your Honor, the interpreter has just become engaged.
I figured that, so I'm assuming you want to repeat of what was said.
It's up to the court judge.
Yeah,
Certainly.
let's repeat it so the defendant can hear it.
Repitamos todo
Miss
para que la
Adams, if you
acusada
could, thank you.
lo pueda escuchar todo. Señora Adams, por favor, adelante.
Go ahead.
The defendant was arrested on an arrest warrant under F 31634, and for that offense, she currently has a bond of $250,000.
La acusada fue arrestada en relación a una orden de búsqueda de captura en el caso F06-31634 y en relación a aquello ya tiene una fianza de $250,000.
Once she was taken into custody on that arrest warrant, the city of Hialeah Police Department filed also an arrest, an A form for under case F 25-18876, charging her with vehicular homicide for the same incident.
Una vez que ella fue arrestada en relación a aquella orden de búsqueda y captura, el Departamento de Policía de Hialeah también presentó una acusación o una denuncia en el caso de F25 188-76 en relación al delito de homicidio vehicular.
The state has filed a motion for pretrial detention to hold this defendant with no bond.
La Fiscalía ha presentado una solicitud de detención pendiente de juicio para que a esta acusada se le retenga sin derecho a pagar fianza.
Because under Florida statute 907.041, she qualifies for pretrial detention as having been charged with a dangerous crime.
Porque conforme a la sección 907.041 de la ley de la Florida, esta acusada amerita detención pendiente de juicio porque ha cometido un delito peligroso.
There's a substantial probability that she committed the incidents that are alleged.
Hay una probabilidad sustancial de que haya cometido los delitos de los cuales se le acusan.
And the state submits that there is no condition of release that the court can impose that will secure the safety of the public and ensure that the defendant will not yet again run away from these charges.
Y la Fiscalía opina que no hay ninguna condición o condiciones que el tribunal pueda imponer que asegurarían la seguridad de la comunidad y la comparecencia de la acusada en el proceso y lo que falta del proceso.
The state is asking, Your Honor, at this time to order that the defendant be held with no bond on each count, and for this matter to be reset for tomorrow before Judge Gamez so that he can schedule a date and time for the pretrial detention hearing, if that's what the defense would like.
La Fiscalía le pide a la señoría que retenga a esta acusada sin derecho a pagar fianza en relación a cada uno de los cargos y que mañana la acusada comparezca ante el juez Gámez para que él determine cuándo se puede celebrar una audiencia para revisar más a fondo la situación de su custodia pendiente de juicio, si eso es lo que pide la defensa.
Okay, and is the defense present?
¿Se encuentra la defensa?
Is there a private attorney or is it the PD?
¿Hay un abogado privado o es el defensor de oficio?
Judge, I want to just confirm that Your Honor had said before her case was called that she did have private.
Yo quería confirmar
No,
que antes de
I don't see
presentáramos el
anybody,
caso,
I don't see anybody here. I will appoint a public defender temporarily pending an affidavit from the defendant.
tenía un
For
abogado
today's
privado.
hearing, as a matter of fact, I'm appointing the public defender for every case heard today unless there's a private attorney present. Temporarily appointing the public defender, if pending an affidavit from the defendants, for today's purposes only. And if there's an attorney representing someone, they can address the court directly. And then that appointment will be void. But, so at this point, it's the public defender.
No veo ningún abogado presente en todos los casos. De hecho, nombro a la abogada de la Defensoría Pública para que represente a cada acusado, a menos que haya un abogado privado y pendiente, naturalmente, el que se presente una declaración jurada que lo sustente. Por tanto, yo en este momento, de manera interina, nombro a los abogados de oficio para que la representen.
Defense has no objection to the pretrial detention motion being reset for tomorrow. She has an ICE hold.
Okay.
La defensa no se opone a que se fije una audiencia en relación a la solicitud de detención previa a
granted.
juicio. Ella tiene una orden de retención por las partes de las autoridades migratorias. Se otorga lo que me han pedido.
So clerk, where do I sign the no bond?
Secretario, ¿dónde firmo la revisión contra la fianza?
Earlier today, but here's the hard copy for the office. It says to both case numbers, F063164 and F251887.
Okay, cool. What do you want that does on?
There should be an arrest affidavit on F251887.
There is an arrest affidavit.
Right on the back of the one.
Okay, that's.
Hay un
Well,
formulario
That's the
reglamentado.
motion I'll put on the copy of the arrest warrant.
En relación a la moción, anexaré una copia de la orden de búsqueda y captura.
He can now grant the motion, but ultimately he must go before the division judge.
Right, so right now there's one count of. Okay, so, right, I'm gonna grant no bond on the
we can fill it out.
Okay, so I'm going to grant no bond on the case number F6-31634. I'm gonna write it at the end of the arrest warrant. I'll make a note there. I'll initial it. Put the date, 9/1.
Pongo que no hay fianza en el caso F06-31634. Le coloco más iniciales y le coloco la fecha.
Okay, that's there. Now, what's the other case?
¿Está ahí? ¿El otro caso cuál es?
Okay, in here, so there's, no bond.
No hay fianza.
Okay,
Judge, what's the other case number?
what's the other case?
El otro número de caso juez, ¿cuál es?
And that was on case number, let me see,
F6,
F06.
31634.
F06-31634.
And then F25 18876. So you can just.
That was just the arrest for the lesser,
So Judge, if I may correction, the F25 18876, she's not in custody. Would you like for us to take her into custody and hold her no bond in that?
yes, please take her into custody on that case and hold her no bond.
She don't, no.
En
Okay,
relación
wait.
al F25-181-72, ¿la retenemos sin derecho a pagar fianza? Sí, detengan la
Right.
relación a eso sin fianza.
All right, all right. All right, so there's no bond on either case. This one seems to be just,
This is another case.
En los dos casos no hay fianza.
Alternatively to her being
If
held
I
no
may,
bond.
Judge.
from the same case.
One manslaughter, one is vehicular homicide.
Okay,
So no bond on both cases.
right, no bond on both cases. Got
No hay
it.
fianza en ambos casos.
All
Thank
right,
you, Judge.
Correcto. Gracias, juez.
all right, and where's that? Got it. And I'm granting the order granting pretrial detention.
Y otorgo y expido una
Nice to
orden
see you again. Are you doing
otorgando
division
la
now?
solicitud de
or-
detención pendiente de juicio.
Oh, okay. All right. Nice to see you. Bye. Marcus Cornelius. Okay, the other one you wanted to call out of turn was Marcus Corridor.
Good evening, Your Honor. Orlando Rodriguez on behalf of Mr. Corridor.
Good evening, Mr. Rodriguez. Long time no see.
It has been.
Let me see if I find the A form, the priors.
He has no priors, Your Honor.
Okay, I have it here. No priors. All right. State, who's handling Marcus Corridor?
One moment, Your Honor, the state's pulling the file.
Let me read the A form.
Your Honor, the state found the file.
Okay, let me read the. Okay, this is robbery carjacking attempt. Seems like
That's correct, Your Honor.
more than,
In addition to burglary with assault or battery, which is a
Yes.
punishable by life offense.
yes, it is, yes.
And if I may be heard on PC, Your Honor.
Okay, wait, let me continue. The offender was. All right, go ahead. Let me hear from PC, on PC.
So, Judge, my client is a 21-year-old young man. He's a college student at the University of Miami. As you saw, he has no prior contacts with the criminal justice system. He's about to graduate the University of Miami with a degree in finance. Judge, the events occurred after last night's University of Miami versus Notre Dame football game. I have present with me his father, a U.S. war veteran who flew in from Jersey this morning to stand by his son's side here today and retain local counsel. Judge, this is a strange set of facts. I think that in light of the fact he's a 21-year-old college student, I think it's pretty clear to the court that he's not just walking into people's cars and punching them for no reason. It's clear that he was severely impaired after the football game and probably thought it was an Uber, and that's why he entered the vehicle. Now, the key to any burglary, Judge, is when you enter a structure with the intent to commit a crime therein. I would submit to the court that due to his impairment, due to the fact that he thought it was an Uber driver, he thought he could enter the vehicle and therefore did not enter the vehicle with the intent to commit a crime therein. I'm not saying there wasn't a trespass. I'm not saying there wasn't a burglary. That there wasn't a battery. What I'm saying, Judge, is that there's no need to hold this young man for an indefinite period of time inside of a jail cell when he's never been in one before, based on these facts. So what I would argue, Judge, is that, or what I would ask the court to do is find PC for trespass and find PC for battery independently and individually, rather than this severe crime of burglary with the battery. This is not what the legislature intended with that. And as for the PC for carjacking, Judge, the defense of impossibility. There was no key inside of the car. You can't carjack a car with no key. Merely getting into a driver's seat does not constitute carjacking or attempted robbery. There was no keys in the
It's
ignition.
attempted carjacking, not carjacking, so.
Right, but you can't even attempt to carjack a car when the person has the key out on the outside. Just sitting in the driver's seat alone does not constitute an attempt to steal a car. Either way, the attempt is still a second-degree felony, felony that is bondable. My bigger concern, Judge, is this Bergbat. I don't want this young man sitting in custody for, as I said, an indefinite period of time based on these facts.
I mean, your argument is great for an Arthur hearing, and you could file one and bring it up, but at this point, the court sees a Bergbat. And I'm gonna hold him no bond as a non-bondable offense. So I'm issuing no bond, I'm finding PC for both. What's the standard bond on the attempted carjacking? It's a second-degree felony. I'm finding PC for both, count 1 and 2. $7,500 bond on count 1. And no bond on count 2. The court is not gonna entertain it. Basically, you're making an argument for an Arthur hearing, which is perfect for an Arthur hearing, but not in this particular case. So.
I understand, Your Honor. I wanted the court to consider these factors.
Oh, I appreciate it. And it's very nice seeing you again, Mr.
It is nice to see you too, Judge.
Rodriguez. Is there a stay away order in this case, or do you want to issue one?
Your Honor, at this time, Your Honor, we have not filled out a stay away order.
I mean, I guess you could issue it when it goes in front of a division.
Your Honor, the state would request 1 moment to fill out a stay away order for the victim in the case, Pierre Bozier.
And so the state is not moving for pretrial detention on this?
No.
Counsel, the judge already held him no bond. The state did pass up its motion, but If
I already
the state's mistaken, Your Honor, is holding the defendant no bond for count two.
Okay.
I believe it to be moot, but it matters because if they do file a motion for pretrial detention, at least we'll get a hearing in front of a judge tomorrow. Or
I
the day
did,
after.
I already signed an order granting pretrial detention.
Yeah, so counsel, for the record, the state did file that motion today.
All right, so I have it, but I still find no bond is, it's a non-bondable offense, so the court is granting no bond. Thank you, Mr. Rodriguez.
Judge, before I go, two things. May I inquire of the clerk? Would this be appearing on Judge Jean's calendar tomorrow, or is this too late in the day for it to appear in tomorrow's calendar for pretrial detention?
If I try to put it in, then yes. I'm gonna try to put it in.
She said she's going to try to put it in, Your Honor.
Okay,
Yes.
yes.
Thank you, Madam Clerk. I appreciate
Okay,
it.
he has, let me see. What is Orlando Rodriguez? All right.
And Your Honor, the state is passing up a stay away order for the victim in this case.
All right, sir, you're gonna be staying, you are ordered to and prohibited from having any contact with the following named person hereinafter referred to as the victim, Pierre Bazier, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. You must stay at least 500 feet away from the victim's home, place of employment, and school at all times. Also, electronic contacts such as emailing, texting, Facebook messages, or by Twitter is prohibited. I'm signing the order now, so just make sure you stay away from the individual, from the victim, Pierre Bozier.
May I address
Thank
my
you.
client? May I address my client briefly, Your Honor?
Yes, go ahead.
Marcus, you should be appearing in court tomorrow. I will be present. If you're not brought over, I will go see you in jail and we'll discuss this, okay? All right, buddy.
Mm.
Thank you, Judge. I appreciate it.
Thank you. There you go. All right, are these priors in order as they come up? Yes, I guess they are. All right, so the first one I have is Stephen Sontobreda.
So just give us a second. Corrections is
Okay.
bringing her.
I'm not going by the calendar, I'm going by the actual. I guess it's in page one. Stephen Sontodrea.
That's what the state has for the first case today.
Ms. Stevens is present before the court, Judge.
Good afternoon, sir. Okay, you're charged with cocaine possession, a third-degree felony, tampering with physical evidence, a third-degree felony, or attempted tampering with physical evidence, a third-degree felony, misdemeanor drug paraphernalia with intent to use, and misdemeanor resisting officer without violence to his person.
Defense stands mute as to PC, but we do have argument as to her release considering the lack of her limited priors and the nature
Okay.
of her priors.
Okay, I find probable cause for tampering with attempted tampering with physical evidence. Yeah, I find probable cause for the first degree misdemeanor, resisting an officer without violence to his person. And I find probable cause, it had residue. I find probable cause for the F3 cocaine possession and tampering. I'm sorry, and drug paraphernalia. So I find probable cause on all four. Do you want her to address the bond?
Yes, Judge, in light of her priors and the non-violent nature of the charges she was arrested for, we'd be asking for pretrial services. She does have ties to the community, and she does not pose a risk or of being a danger to the community.
Okay, does he qualify for pretrial services? No? I'm sorry? Oh, she's homeless. Oh.
Judge, she didn't.
No, I'm not homeless. I live with my mom.
She does have an address, Judge, so.
Okay, she has an address. What I'll do is okay? Yeah, order her into where, I'm sorry. Right. Well, I mean, what I'll do is pretrial service with an alternate bond, and then if she qualifies, then she'll have it. If she, assuming you can find an address for her.
Alternatively, we can.
She
just
says
have-
she's staying, that she can she lives with her mom, so then if she can confirm, if you guys can confirm that, then that's fine, but I'll issue a standard bond, alternate bond, all right? So what's the alternate, so.
Thank you, Judge.
Pretrial service, alternate bond.
So Your Honor, is it pretrial services for each count with the standard bond as the
Yes.
alternate? Okay,
What is the standard bond
for which count, Your Honor?
for all three? Give me individually.
So Your Honor, for cocaine possession, I believe the standard bond is 2,500. For the attempted tampering with evidence, I believe the standard bond is 1,000.
Okay, wait, let me see which one that was.
It's only 2,500.
Okay, so you're going in order, right?
Yes, Your Honor.
All right, so it's how much, 1,000?
Yes, Your Honor, for count 2.
Judge, excuse me, it shows 2,500, so you're lowering to 1,000.
It's an attempt.
It's an attempt. It's still an F3, but. I'll leave it at 1,000. Go ahead.
Your Honor, for count 3, it would be pretrial services alternate bond 500.
All right.
And for count 4, the resisting without violence, it would be pretrial services alternate 500.
All right. Thank you. And let me see what's it. Oh, this one, clerk. Madam Clerk, this was for the other case that we called first. I mean, the second stay away order, which I signed. That was on the no bond case. All right. Thank you. Next case.
Judge, I'm so sorry, off the bat says, correction, they're trying to, come in with the Zoom with Miss,
Number 5, Ms. Carolina Saras.
yes, Judge, can you please let her in, please?
Oh, you found her on Zoom? Is she on Zoom?
Judge, they're on Zoom.
They're in Zoom, Judge. They just need to be let in.
Okay, I need to see her.
I'm sorry, who am I looking for again?
Stephanie Canizares.
Oh, the defendant on Zoom. Yes, I let her in.
Are you Miss Canizares? Who are you representing? Are you represented by an attorney?
Yes.
Yes.
Yes, Giancarlo Casanova on her behalf.
I guess you could see her on the
Here
video
present
there.
In court, I'm gonna be representing you. I'm just gonna remind you not to make any statements or comments to anyone about this case, okay, ma'am?
Yes, sir.
Thank you.
Is she out of custody?
She's in custody, Judge.
Oh, okay.
I'll give your honor just a moment so I can catch up on the A4 before I make my PC argument.
That assault with a fire. Oh. There you go. Thank you. We can discuss.
After it's running all day, you're gonna never.
No, it's literally. Yeah, his name was Vigo. I will. Thank you, Matt.
Yeah, they're just.
Okay, what is your argument for PC?
So first of all, I have the alleged victim, Mr. Albert Vigo. He's in the waiting room of the Zoom. I don't know if we can let him in.
Okay.
It's Vigo, V-I-G-O.
There we go.
He was requesting access. He sent me a text message letting me know
Okay.
that he wanted to be heard. And now,
Sir, can you, I see you here, but I don't see a video. Can you turn on a video?
Mr. Vigo, activate your camera, sir.
We have a stay away order on this.
For the moment, Your Honor, we should have a
And
stay away order.
this didn't come up in domestic?
No, well, it's right, it's a felony, Your Honor. So
Okay.
the domestic are mixed in with the.
All right, so I need a domestic stay away order. Mr. Mr. Vigo, you were raising your hand. Can you turn up?
Yes, Your
Oh,
Honor.
there you go. There you go. Are you an officer, a police officer?
Yes, sir.
Okay.
Can you see him?
All right, sir, let me swear you in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and but the truth?
I do.
Okay. All right. Go ahead.
Good afternoon, Judge. So as you can see, we're here on a misdemeanor public discharge and an aggravated assault with a firearm, where they allege that Ms. Canizares used the firearm to intimidate, harass, or threaten in some manner her significant other, Mr. Vigo. Mr. Vigo indicated to me, number one, that there was a discrepancy in the facts that he, number one, was never in fear or apprehension. Number two, a plain reading of the four corners of this A form demonstrate that the intent component is completely missing. And I say that because the story picks up with Mr. Vigo waking up and hearing a conversation, realizing that his wife or significant other is outside of the home. Okay, at no time is she armed in an effort to intimidate, harass, menace, brandish, or cause any violence to himself or anyone else. He is the one that exits the house on his own volition, asks her to come back in. She refuses. He further insists, at which point he simply says he sees a firearm in her hand. There is no allegation that the firearm was raised or pointed, that it was brandished, that any threat accompanied
Who do I give it to?
her holding the firearm.
Mhm.
So for that, for those two elements missing, the intent component as well as the lack of fear or apprehension caused in the alleged victims, I would argue that there's no PC for the aggravated assault with a firearm.
Okay, State, I don't see it either. I mean, I see that he had he saw a gun, but it never indicated it was pointed to her, to the defendant, to the victim, that it was pointed, that it was discharged while he was inside the house. So I do find probable cause for discharging a firearm outdoors, which is a misdemeanor in the first degree. But as it relates to the aggravated assault with a firearm, I don't see it.
And Judge, just as the state kind of puts their argument together, not to argue balls and strikes, the public discharge, if the only witness is Mr. Vigo only claims to have heard a gunshot. It's possible, completely possible, and within the realm of
All right.
possibility that it was an accidental discharge. When she was putting it away, might have dropped the firearm, but
Okay.
be that as it may, like I said, we're not gonna make our.
I'm not going there. Okay, PC found on count two. Give me, hey, what do you say as to count one?
Your Honor, as to count one, I mean, it's correct to say that the arrest form does not say that she points the firearm at him. The fear element is there clearly in the four corners of the arrest form. It says that he left in fear of his life. He went back in the house in fear of his life. And as he approached her, convincing her to come inside is when she showed him the firearm.
Well, let me see, I'm not sure it showed them because, no, that what I read is that he saw it on
Saw
her.
it in her hand pointing down.
Right,
Correct.
right, so he saw it in her hand pointing downward, which she had it before he showed up outside.
Which, by the way, Judge, this is going on at 2 a.m. It's a female. She's outside. I suggest to the court that the only reason she's armed in the first place is for her own safety.
Right, so I don't see the element of ag assault, so I'm finding no PC for the ag assault. Which is the count one. I'm finding PC. On count two. I'll issue a modified stay away order, but I'm gonna issue a stay away order.
That was my next kind of concern, and I wanted to fill in the court with a little bit of context, and I'm not gonna bore everyone here with details. Mrs. Canizares is the mother of a 5 or 6 month old. As you were told by Mr. Vigo, and he's prepared to give testimony, he is a city of Miami police officer. He cannot take care of the kid, their child in common at all times. He needs mom home. He's not in fear. He's prepared to tell the court that. I don't know if you want to put him under oath and take them testimony, but we do need some contact between the two of them, Judge, so that they can kind of co-parent and.
Okay, sir, Mr. Vigo?
Yes, sir.
All right, so normally in a situation like this where there is a domestic violence, I would issue a stay away order and have her leave the house, and you would stay in the house. She would have to leave. She would have not be able to have any contact with you, or be within 500 feet of where you're at. So she couldn't live in the residence. She couldn't go to your work. If you are not in fear for your life and you testify here, that you don't want that stay away order, I would consider just giving a modified stay away order, which means that she cannot be violent with you. So how do you
I'm okay
feel?
with that.
Okay, are you in fear from the defendant?
No, I am not, sir, and neither was I during the course of the incident.
All right. All right, so I'm gonna issue a modified stay away order, if you have it.
We can prepare it, Your Honor. The state would have a minor objection just in that this incident was a couple of days ago. At least in terms of the sworn statement the officer gave, the information he collected suggested fear, and this involved an incident with a firearm that was discharged in a home with children. The state's.
Well, it was discharged outside.
Outside.
Right.
Outside of a home, but with children nearby inside the home. The state's position or request, rather, Your Honor, is just that a modified stay away order be issued for communication only for the purposes of the kids. If Your Honor would prefer to do no harmful contact, the state can provide that.
I'll do no harmful contact.
Your Honor, may I speak?
Mr. Vito, just 1 second, Judge, for the court's peace of mind, Mrs. Canizares' firearm is in possession of the.
Well, I'm gonna have her turn in the firearm,
It's been
so.
done. That's already, the
All right,
police have.
so it's gonna be on the stay away order, so I wanna make sure she understands
We
it.
completely understand, and I will go over every term with Ms. Canizares with the luxury of detail. Judge, would you consider?
Yes, on the bond for the count two, does she have, I don't see any.
Zero priors. I don't
Yes,
think they
zero
have
priors.
parking tickets, Judge, but what I was gonna say is, police, when they respond to the home, they take 2 cell phones. This is not a fraud case, this is not a
Okay.
stalking case, a virtual case.
I'm not gonna go to entertain
No,
returning
file-
property,
return-
file whatever you
I'll
want.
file it
with
in
the-
division, Judge,
yes.
just wanted to try.
Given the circumstances in this case, I'm just gonna issue the standard bond on count two, which is, it's a misdemeanor.
Yes, sir.
Misdemeanor, what's the bond?
500.
500, so I'll issue a $500 bond.
Perfect. Outright on count 1, Judge?
Okay, I'm released outright.
Outright?
Yes,
Oh, sorry. about this.
okay,
Mr. Ryan, I'm sorry.
you have this.
It was $500 for the public discharge.
I mean, there's bagels there if you want.
Standard one, and then he released outright on the August.
What's that? I haven't had water, no, but that's fine. I have some in my car when I leave. At 10 o'clock. Yeah. Yeah.
I guess. But I waited till after. I didn't do it. Everyone is taking the wrong way.
All right. All right, let's see what we can.
Where do you see them? Can I address my client just 1 second, Judge?
Yeah.
Ms. Canizares, if you can hear me, it looks like you're gonna be being released today. There is no telling what time. I will reach out to your mom and your family and let them know exactly what happened here today and let them know what to expect. And it may be frustrating, it may seem like it takes forever, it may seem like it's never coming, but you will be released, okay, ma'am?
Okay, thank you. Thank you, everyone.
Just remember, no statements, no comments to anyone about this, okay?
Yes, sir. Thank you.
And Your Honor, the state is about to pass up a stay away order, but it has to be a modified non-domestic violence stay away order because the only crime remaining is not a domestic violence
Okay.
crime.
All right.
I will put my initials for like.
It's actually funny because the initials are AV. Believe it or not. It's 20 years. I've never had that. AV is AV.
Do you want me to do only initials because of Marcy's law? Okay. Okay. Okay.
Another family. All right, I'll do it in I'll do that at the cell phones. You know what the agent's one has no bill one.
Yeah, the name.
All right.
And Your Honor, did you issue a bond for count 2?
Yes, the standard bond, 500. All right, so, ma'am, there's a state, you're allowed to have contact with the victim in this case, but you're prohibited from being physically threatening or violent towards the victim in any manner whatsoever. And the victim's initials are AV. Is that
These the initials. It just happens to be the same as alleged victim.
okay? All right. All right. Thank you, ma'am.
Everyone did.
Thank you, sir. May I be excused?
Yes.
Thank you. Everyone have a great day.
You too.
Thank you.
Here you go.
Have a good day.
Who gets this? Who gets? Okay. All right, let's move it along. All right, I have Marlene Mercedes Angolopena.
Judge, Miss Angolopena has an immigration hold.
Okay,
Your Honor, what number in the calendar today?
Number 2.
Okay.
all right, this is possession and sale of controlled substance, MDMA, field, and then 2 counts of possession of controlled substance. One count with intent to sell, and the other one is just possession.
Judge, and I apologize. She does need the services of the Spanish interpreter.
Okay.
Cargo es posesión con intento de vender éxtasis o MDMA.
Defense stands mute as the PC.
La defensa no tiene argumento en relación a la suficiencia de indicios.
Okay, I find probable cause for count 1 and count 2.
Determino que hay suficientes indicios que sustentan el cargo 1 y el cargo 2.
No, seems like the defendant this is the only priors.
Aparentemente, la acusada no tiene antecedentes además de estos. Excuse me, Your Honor, the interpreter also heard earlier that she has a detainer from ICE,
Right,
but
ICE
the interpreter was
detainer,
unable to
correct.
interpret that. May the court inform her of that, or?
That's correct, Your Honor, on the priors.
Okay.
Es correcto, señoría, en relación
What's
a
the
los
standard bond? 7,500 per count?
La fianza estándar, ¿cuánto es? 7,500 por cada cargo.
No,
I believe it's 2,500 for the possession of controlled substance, Judge.
Creo que son 2,500 por la posesión de sustancia controlada, pues.
It's 500 for count. It's 5,000 for count 1, Your Honor, for the second-degree felony controlled substance. After a positive field test.
Okay, and the second count is 2,500?
Son $5,000 en relación al cargo
Count
de
one,
delito grave en
and
segundo
count two
grado.
is what, 2,500?
That's
Cargo
correct, Your
dos.
Honor.
All right, so I'm
Son
issuing a
2,500.
bond, 2,500 on count two, 5,000 on count one.
Dispongo fianza de $5,000 en relación al primer cargo y de $2,500 en el segundo cargo.
You go. Beverly Goodlow,
Judge, MBC, can we reset her for tomorrow?
yes. What do I put, where do I put reset? Where do I put it? Hmm? Here, just reset?
You read it, yes.
No.
Yeah. But 9 to 25.
On initial,
Yeah. That's
there you go, keep it with the. Maria
Good evening, Your Honor.
Elena Lay,
Yes, sir.
child neglect, no harm, count one, driving under the influence, count two. We had this one, this is the one that came in the, for the misdemeanors. We did the traffic on this one, I forgot what the bond was on the traffic cases.
That's correct, Your Honor.
I did review this, I did find that there was probable cause. When I read it before, I did find probable cause for child neglect, no great bodily harm. Let me look at the priors.
And Your Honor, the defendant does have some convictions, Your Honor, the most recent being a 2009 felony case. It was battery, it was 2 counts of battery on a law enforcement officer with convictions in both counts, as well as resisting without
Thank you.
violence. And a conviction in that count, Your Honor.
And she did 6 years in prison. So she could be a perp, she could be, well, not a perp, but a HO or,
of violent felony of
Yeah.
special concern.
yes. So I'm gonna issue the standard bond.
Your Honor, we've given the priors, the state would ask for an elevated bond of 8,000.
Okay, I already found PC on the misdemeanor cases. So I'm finding PC on count one. And what is the amount that you're seeking? 8,000?
The state's requesting $8,000. Your Honor.
8,000.
Judge, I would just ask for the standard bond.
I'm sorry?
I would just ask for the standard bond if that wasn't the standard bond.
And what was what is the standard bond?
For this case, Your Honor, would be 5,000.
I would ask for the standard bond, Judge.
And the reason?
Priors are over 15 years old.
Well, it was 09 and she was sentenced, it was closed in 11 and she served 6 years. So it was 2016 when she was released.
She was released in 2014, I believe, Judge.
When was it?
I believe it was 2014.
Her probation ended on 7/26/2015. So that's within 10 years. I'm gonna keep the bond at 8,000. All right, go to the next one. I just want to make sure I have the right price. I don't take them out of order. There we go. All right. Howard or Alana Howard. And this is the defendant's charged with 1 count of child abuse, no great bodily harm. Is case number F25-018942. Misdemeanor contributing to the delinquency of a child, and then misdemeanor battery. This must have come before me.
And defenses have argument as to count 1 and count 2, Judge, whenever the court is ready.
Okay.
As to count 1, the child abuse, no great bodily harm. There is no, within the 4 corners of the affidavit, there is nothing with regards to how old the nephew is. The nephew could technically be anywhere between 18 and however old. And same argument as to count 2, contributing to the delinquency or the dependency of a child. With regards to that, there is no, within the 4 corners of the affidavit, there is no mention as to the age of the victim, which I believe is Mr. Mr. Dwell.
State.
Your Honor, I realize this is attenuated, but at the bottom of the facts and the narrative, it does say that, actually, never mind, Your Honor. Yeah, Your Honor, I mean, for child abuse, no great bodily harm, the officer did not put in the narrative any description of the victim's age.
Okay, so what do you want to do? I can't find PC the way it is now.
Your Honor, we'd ask to reset this case for a PC hearing.
Okay, reset for tomorrow.
Judge, can you give us a second? Do you want me to? Judge, we will waive the PC determination for tomorrow
so
and ask
wait.
for a bond be set as to counts 1 and 2 and also
Okay.
3.
There's
They are-
no other priors here, so. What is the standard bond?
The standard for child abuse, no harm is 5,000.
Okay, so I'll issue a bond. So PC waived. 5,000 on count 1. And what is the standard bond on the misdemeanor battery and the misdemeanor contributing to the delinquency of a dependency of a child?
Your Honor, is a non-violent first degree misdemeanor, I believe it would be $500.
On each?
Even though it doesn't. Even though there's no. I trust you, Madam Clerk, but. I know they're printed here, but I always thought the law was if it's a non-violent first degree misdemeanor, it's $500.
I would just ask for a $500 bond on each count, considering.
Yeah,
that
I'll do 500 on each
Thank you,
count. So it's 500, so total 1,000. So total would be $6,000 bond.
Yeah.
Judge, there's 4 counts.
There's a count 4?
Let's count 4.
Where?
Well, the count 3 is the battery, but I believe there's only 3 counts.
I
Oh,
see.
that's correct. So 500 per,
Oh, you're right. They did charge it twice. So it's 500. So I'm just putting 500 on all the counts.
Thank you, Judge.
What is 500?
Yeah, is 2 to 4 is 500. So total 6,500. Leo Delin Castellanos. There's a multitude of cases here. I don't think I have all of them. I just have one. This one, F25 18954. Which is okay. This is grand theft, 3rd degree, organized fraud, 20,000 or less. Fraudulent use of a credit card and scheme to defraud. I'm finding probable cause on all counts. So this, I have 1, 2, 5 counts. See? No, wait, you're right,
Judge, we have 6
6.
counts.
6 counts, and it says hold for magistrate. Oh, okay.
Wait, I apologize, guys, but I only have one count for count one is,
Yeah, there's
One.
there's 2 counts on count 3.
but then that would be 5.
No, and there's another count in the next second page. So it's 6 counts.
Oh. Wait, I see it, I think,
All right,
oh my gosh, okay, thank you.
and she has, at least she has a lot of pending cases coming up, not just this one. Yeah, okay. Well, at this point, I'm just gonna go forward on these. I find probable cause for all 6 counts. What's, as it relates to bond, what's the standard?
3 and 4, 7,500 each. 5 and 6, 2,500.
I think that should be enough. So 2,500 on count 1. 2,500 on count 2. 7,500 count 3, you said, clerk?
Yes.
7,500 count 4. 2,500 count 5. And 2,500 on count 6.
Judge, is that with a Nevia?
Yes, please.
The state is.
All right, thank you.
And Your Honor, there is a stay away order in this case from the Trust Bank at 69 Westward Drive in Miami Springs, Florida.
All right. So ma'am, you have to stay away from the bank. Trust Bank, 69 Westwood Drive, Miami Springs, Florida.
Judge, what's her total bond? She's
The total bond, let's add it up. I could tell you 7,500, 75 earners, 15. 25 and 25 is 5, that makes it 20. 25 and 25 is another 5, so it's 25 total. 25,000. Okay, driving while license suspended, 3rd and subsequent conviction. This is Pope Richard, case number F25018961. And there's a second case, F25018960. And you have aggravated assault with a firearm.
Your Honor, are we skipping number 9?
And 10?
Mr. Pedrosa James?
Yeah.
I'm just going by the order that's.
Yeah. Now that I messed up.
I just have a stack and I'm taking from the top of the stack, so I'm not sure what order they're in.
He's a couple ahead, but there were just 2 cases in between the last one we called and this one.
Okay. Okay,
But this one's Richard Pope, correct, Your Honor?
yeah.
It's what they have before you.
Judge, can we go in order?
Yeah, all right, so can you put it
Can
in
we start
order?
number 9, please?
Okay, let me go.
Number on page 4 at the top, James Pedroso, he refused, so he needs to be reset for tomorrow.
I'm sorry, what happened with James Pedroso?
He refused, so he needs to be reset for tomorrow.
Okay, reset. 9 2.
she needs a Spanish interpreter? And for Edwin Aguilar Salas, he needs the services of the Spanish interpreter. He's the next one on page 4 after Mr. Pedroso.
All right.
Edwin Aguilar Salas, él necesita un intérprete español, él está en la página 4 después del señor Pedrosa.
Okay, I have here, Edwin Alberto Aguilar Salas.
Tengo a Edwin Alberto Aguilar Salas.
That's the one you're asking for?
Ese es el que usted tiene.
Yes, Judge.
All
Mr.
right.
Aguilar Salas.
Okay, he's charged with three counts. The first one's fleeing or eluding a police officer with siren. The second was resisting officer without violence. And then the third one was a no valid driver's license. I believe he came before me earlier.
That is correct, Judge. He did.
Yeah, that's correct, Your
Tiene
Honor.
3 cargos, el huir de la policía con las luces y las sirenas activas. El segundo es resistirse contra la policía sin violencia. El tercero es conducir sin violencia, sin licencia válida.
I find probable cause I already found probable cause on the resisting officer without violence and the no valid driver's license. I'm finding probable cause for the fleeing and eluding police.
Ya determiné que había suficientes indicios del cargo de resistirse sin violencia y del conducir sin licencia válida. Determino que también hay suficientes indicios en relación al cargo de eludir y evadir a la policía.
Yeah, I'm not sure if I found PC on the no valid driver's license. I can't remember, but I did find PC on the resisting officer without violence to his person, and I'm finding PC on the fleeing or eluding a police officer with siren. Let me see.
De hecho, no recuerdo si determiné que habían suficientes indicios en relación al cargo de conducir sin licencia válida, pero sí lo hice en relación al cargo de resistirse sin violencia y determino que hay suficientes indicios en relación al cargo de huir y eludir a la policía.
He was on he had prior charges that are old. He was on probation all the way up to July 29, 2022. So what is the state's position on bond?
Él tiene antecedentes. Él estuvo con libertad vigilada probatoria hasta el 29 de julio del 2022. ¿Qué me pide la fiscalía?
The state's requesting a $2,500 bond for count 1 and a $500 bond for count 2. The $2,500 and $500, that's the standard bond for each count.
Did I enter on the previously when I had the misdemeanor? Do you remember if I entered a bond on that one?
Your Honor,
Judge, you gave him a $150 bond.
All right, so let's leave it at what I gave before. So I'm not addressing count 2 or count 3, whatever happened before in the misdemeanor, that's what stands.
Well, Your Honor, I apologize to interrupt you. I believe you set a bond in count 3, but not count 2 for this case.
Oh.
Judge, and
La fianza estándar en relación al cargo número 1 son $2,500 y 500 en relación al 2. Eso es lo que le pido, su señoría. Tengo entendido que usted fijó una fianza en relación al cargo 3, pero no en relación al cargo 2.
Okay, corrections, what do you have?
Judge, I would ask for a reduced bond, considering the fact that he did complete probation successfully. It doesn't look like he had any violations, and his priors, besides the fact that his probation terminated in 2022, are relatively old. He has nonviolent priors, and this stems from basically a traffic infraction.
Señoría, pido que se le reduzca la fianza en relación, porque él tuvo probatoria, pero la terminó con éxito. Fueron asuntos que no fueron violentos y esto es un asunto de tránsito.
Okay, and this is the one I read before where he cut off several vehicles. He caused several vehicles to have to brake suddenly. Police officers went after him. He deactivated the lights. And the defendant continued driving and showed no indication of slowing. I'm not going to reduce the bond. It's $2,500. What was the bond I gave before?
Este fue el caso que yo leí anteriormente. Aquí se dice que él interrumpió el tránsito o el camino de varios vehículos que tuvieron que frenar y después los policías lo siguieron con las luces y las sirenas encendidas y él siguió huyéndoles. No voy a reducir la fianza.
The reason is because the attorney said that I only did one of the counts, not the other 2. I thought I had taken care of the other 2. That's why I'm asking corrections.
Le pregunto al Departamento de Prisiones
He has
si
two counts before me? Okay,
Yes,
All
Judge,
right.
he
tiene dos
only
cargos
has two
ante mí,
counts in
sí.
front of you right now.
okay.
Él tiene solamente dos cargos ante usted, juez.
Okay, so it's the misdemeanor and the F3. Okay, so on the misdemeanor, what's the standard bond? 500? All right, so I'm finding PC on count 2, 500.
Determino que hay
Total
suficientes indicios
3,000.
en relación al cargo 2,
So count
500,
one is 2,500, correct?
y el primer cargo son
Right.
2.500, total 3.000.
Right, 2,500 and 500.
Correcto,
Judge.
2.500, 1.500. Gracias, juez.
All right, next is Richard Pope.
Próximo es
Just give me a second, because corrections just stepped out.
And he has two cases. And a multitude.
Defense has argument as to PC, Judge.
Okay,
Judge, for the felony DWLS, per the change in the law, it has to, a felony DWLS has to be DW, the current violation or the most recent prior violation must be the result of a DUI refusal, a traffic accident causing death or great bodily harm, or a fleeing and eluding. There's no mention of either within the four corners of the arrest affidavit. And his license was just suspended as of July 2025. So I would even argue that considering considering the recentness of when his license was suspended, he did have a good license up until this is August 31st. I would argue that there would even be maybe even a no knowledge element here.
okay.
And Your Honor, the state would stipulate to the defense counsel's representations as to the new DWLS law changes, Your Honor.
Okay, so no PC on case number 25018961. He'll be released on that one.
Well, depending on Your Honor's findings on the second case,
You might want a dollar bond.
that is correct, Judge. Thank you.
All right, let's do a dollar bond.
I'm sorry, Judge, a dollar bond on which one?
On case number, count 1 of case number F25-08961. And then on the second one, assault or assault, aggravated assault with a firearm.
Judge, and defense stands mute as to PC as to the new case, but defense does have argument as to release.
Okay,
As to release, Judge, Mr. Pope's priors are extremely old. They're definitely over 10 years old. I know he does have a good amount of priors, but none of them are particularly violent or alarming. Also, I would like to say that the aggravated assault case did arise in his home. And considering the age of his priors, I'd be asking for house arrest with an alternate bond being the standard bond.
pointed a firearm. Okay, I do find probable cause as it relates to the ag assault with a firearm. Let me look at the priors. mean, most of them, most of them are over 10 years.
Correct.
He has a lot of them, but they're over 10 years.
Yes, the most recent one, Your Honor, reckless driving conviction in 2019.
Okay, so what's your position on bond?
House arrest, Remy, state?
And Your Honor, the state would be asking for a standard bond.
Okay, which is? Okay, he did point a gun at someone, so I am gonna issue a standard bond of 5,000. All right. Chandler Dion Drell. Oh, and there's a Mr. Pope, there's a stay away order from Demetrius Hunter. You're prohibited from having any contact with the following named person, which is Demetrius Hunter, directly or indirectly, in person, in writing, in telephone or pager, fax, or through third person. You must stay at least 500 feet away from the victim's home, place of employment, and school at all times. Also, electronic contacts such as emailing, texting, Facebook messages, or by Twitter is prohibited. And you have to stay away from the defendant's address, which is 4020 Northwest 12th Avenue, Miami, Florida, 33127.
Judge, could it be that is also his address, so could it just be a stay away order from the victim, and should the victim
I
leave
can't do that. The victim's not present. I can't do that. If he needs to take something out of the house, he can contact the police department and have someone go with him so he can remove the items.
Morning.
Go ahead.
How you doing, Judge? God bless you, sir. Good morning.
Good morning, sir. This is Chandel Diandrell.
Yes, sir. God bless you, sir.
God bless you, sir. I was dispatching Biscayne Boulevard. Okay, you're charged with let me see, 4 counts. The first one is battery on a police officer or corrections officer, resisting an officer with, second count is resisting an officer with violence to his person. The third is a misdemeanor, resisting an officer without violence to his person. And number 4, trespass on property after warning. Did I do any of these in misdemeanor, the 2 misdemeanor cases, or no? Everything came in today?
I don't believe so, Your
Okay. Okay, I find probable cause on all counts. Let's see here.
Judge, I would ask for house arrest with an alternate bond being the standard bond. He does have somewhere where he can live.
He has priors. He has a 2022 case. Which looks like it's still open. I'm not sure. Oh, no, he got 3 years probation on that, which ended on August 29, 2025. Just barely.
If it's house arrest level 2, Your Honor, the state would stipulate to that with alternate bond being the standard bond for each count.
Okay, what's the difference between level 1 and level 2?
Well, so level 2, the defendant would be able to go to pre-approved places, the grocery store, school,
Right.
work, doctor's office. That's the state is just offering that as opposed to level 3, which is roaming basically.
Okay, and level, so you're asking for level 2, right?
House arrest level 2, alternate standard bond for each count.
And, okay, so house arrest. Level 2. On all counts, what's the alternate bond for,
So count 1 would be $5,000, Your Honor.
in count 2?
Count 2 would be 500, and as would counts 3 and 4.
And corrections will explain what level 2 means to the defendant?
Yes, I believe that's correct, Your Honor.
Yes,
Okay.
sir. So just house arrest alternate on all counts, correct?
Right. Alternate 500 and 5,000 on count 1. So that's a total of 6,500. Thank you. Jonathan, Joaquin Ulysses Fernandez. This is an F3 controlled substance, possession of controlled substance and petty theft. I find probable cause for both counts. Priors.
In the honor, he does have a petty theft conviction from this year.
Has a few cases on. Isn't he out on felony bond? In F25-17213 and F25-17388?
That's correct, Your Honor. It's up for arraignment next week.
Okay, when were those cases, when was he arrested on those cases? It predates this case, right?
Yes, Your Honor, it does.
So I'm gonna hold him, I'm gonna hold him for the felony. A felony hold in this case. I'm finding PC on both and felony hold. As it relates to, there's 2 cases, F25. Okay. F25. 017213. F25. 017388. Do you still need a bond for this one?
Oh, which one, Your Honor?
On this case here, I'm doing a felony hold, so he's not getting out into.
Standard bond is fine, Judge.
All right, so what's the standard bond on possession?
2,500, I believe.
All right, 2,500 on. Okay, and 150. So that's 2,650 on this case, but he has, I'm putting a felony hold based on the other 2 open cases he has. And Mr. Fernandez, you're to stay away from the following address, 8700 Mills Drive, 33183, Town and Country Mall, Miami-Dade County.
All right.
No
Good luck.
sense? Thank you. Jose Humberto Ojeda, petty theft. I have one count of petty theft, two or more convictions, 4 counts of controlled substance, possession of controlled substance, Xanax, and 1 count of drug paraphernalia.
Judge correction, Mr. Ojeda has an open case, F25-10132, and he also have an open misdemeanor, B25-16436.
All right, so I'm gonna hold him, felony hold based on the open case. And, as it relates to, let me see.
Judge, are you gonna hold them both on the felony and the misdemeanor?
Yes. Well, on the felony case, felony hold. Okay, I find probable cause on all counts.
And
Just
Your
4,
Honor,
5, 6.
because the defendant does have prior convictions, including several convictions that are similar to the charges alleged here, the state would be requesting standard bond on all counts.
Yeah, I am gonna issue standard bond. So what's the standard bond on the first, petty theft?
That should be 2,500, Your Honor.
2,500. And then the others are, controlled substance possession. There are 4 counts. What's this?
That's correct, Your Honor. That should also be 2,500.
Okay. 5, 75. 1,000. Well, 50, and then on drug paraphernalia,
That should be 500, Your Honor.
so total is 13,000 with a felony hold.
That's correct, Your Honor.
F25. 01897. There a stay away order? Let me see.
Yes, Your Honor. There's a stay away order from the Walmart at 8400 Southwest 24th Street.
Okay, so it's a stay away order from Walmart, 8400 Southwest 24th Street, Miami, Florida, 33155. Thank you, sir. Good luck. Jimmy Lagos.
Judge,
Okay,
he's a
now I think
bond
we're
out.
out of order again.
He's a bond out, Judge.
He's a bond out, okay.
Yes,
Jimmy Lagos
Judge.
is a bond out. Judge, Mr. Glenn Soriano's in the bathroom. If we could just pass his case. The next person that I have in front of me is Jamel Cortedano. Spanish or English?
Okay, give me a second.
Hold on, what- you guys.
Yeah, I think that one's, I gave, that one goes with. Which one are we doing now? You said?
This is
James Cortellano, right?
that's correct, Judge.
Yeah, that was a bond out. Let me make sure.
No,
Yes,
this
bond
is-
out.
Wait, Cortedano?
Yes,
No, Cortedano's right here.
Yes.
okay, that's the one we're doing. Okay. And you passed Glenn Serrano.
Correct.
And your charge, sir, in case number F25018975. Assault, aggravated assault with a deadly weapon. I find probable cause, count one. Yeah, some priors,
Judge, I would just ask for the standard bond.
yeah. That, I agree. What's the standard bond?
5,000.
Okay. 5,000 it is. Thank you, sir. Oh, and wait, before you leave, there's a stay away order from Adrian Polo. You're prohibited from having any contact with the following named person. Adrian Polo, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at the time. Also, electronic contact, such as emailing, texting, Facebook images, or on Twitter is prohibited. You're also to stay away from the address of 801 Northwest 148th Street, Miami, Florida 33168. If you currently live there, then you have to contact the police department so they can escort you there so you can retrieve your personal items. Yeah, I think that goes with that. Thank you, sir. Melvin Rutledge.
Judge, Mr. Soriano is back.
Oh, I got it. Okay.
And Judge, Mr. Soriano has an open felony, Judge.
All right.
It's the open felony case number is F24 26714.
Okay, the court is going to hold him a felony hold based on that case, F24 26714. See, there's PC. Sir, you've been arrested in this case, F25018973, and you're charged with 2 counts of aggravated assault with on a law enforcement officer, grand theft, 3rd degree with a firearm use, display while committing a felony, and cocaine possession. Let me read.
Judge, standard bond is fine.
I'm sorry?
Standard bond is fine.
Yeah. State?
Your Honor, did I hear the public defender correctly say that standard bond in every count is fine?
Yes,
For the case ending in 7-3?
yes,
The state would agree to that.
okay. And he also has another case.
That's correct, Your Honor.
All right, so let's go through them. You have 2 counts aggravated assault on law enforcement officer, 2 counts. What's the standard bond for that?
If I'm not mistaken, Your Honor, I believe it would be 7,500 each.
All right, 7,500 each. That's 15,000. How about firearm use, display while committing a felony?
Your Honor.
That's a 2nd-degree felony.
Judge,
Oh, I'm sorry, the grand theft, third, of a firearm,
That's correct, Your Honor. I believe that would be 5,000.
5,000. So we're 20.
And then, Your Honor, for count number 4, firearm
Judge,
use or display.
I'm sorry, before you continue, we have 2,500 for the grand theft third degree firearm.
All right, so 2,500. And the other count 4 and 5?
I believe count 4 would be 7,500, Your Honor.
On cocaine possession? No, I'm sorry, on firearm use display, 7,500. All right, 7,500. That's 10,000, that's 25,000 total, and then count 5 would be cocaine possession, what's that? 2,500. So I think if my math is correct, it's 27. Oh, it
still
keeps
have two
going, wow. What is it? Count 6 is how much? 7,500. 2,500. And there's still reckless driving. We addressed that one, I believe.
That's
Okay. Yeah. All right, so I can't add it all. There's a lot already.
I'm sorry, Judge, what was the firearm, weapon, ammunition, possession, convicted felon? How much was that? And the fleeing duty?
7,500. Right, and let me read the other case.
Judge, correction, before you go any further, Judge, count 6 is 7,500 and count 7 is 2,500, Judge?
Count 6 is
The fleeing.
7,500 and count 7 is 2,500.
Thank you, Judge.
All right. And let's look at the other case. The second case you have, sir, is F-25018972, and that's grand theft vehicle. And it's a 1st-degree felony. And I find probable cause, 10,000 on that one. And also felony hold. All right. Thank you. I have Melvin Rutledge.
Judge, I believe that we need to take one out of turn,
Yes, Judge, number 40, please, Mr. Menendez de la Cruz.
right now.
Number 40, I don't have a 40. I have up to 22. I don't have 40. What's the name?
Menendez de la Cruz Lewis, we did him earlier this morning. If we could take him out of turn, please.
I don't.
He needs the services of the Spanish interpreter, Judge.
Él necesita servicios del intérprete de español, juez.
This is on the bottom of page 12.
Está al pie de la página 12.
Luis Menendez.
Oh, page
de la
12,
Cruz.
okay.
Mira, 12, Luis Menéndez.
I got it.
Lo tengo.
Okay, sir, you're charged with, in case number F25-18893, battery on a police officer, or corrections officer or firefighter in transit.
En el caso F25-188-93 se le acusa de agresión contra un policía, un oficial de un correccional o un bombero en sus funciones.
He bit the correction officer. I find probable cause.
Mordió al señor representante del penal. Determino que hay suficientes indicios.
Let me look at his priors.
Permítame ver los antecedentes del caballero.
You have it with you, or
We do have.
that way I don't have to go through this whole stack.
¿Quieren? No tengo que
Your Honor,
revisar
the
todo lo que
defendant
aparece.
doesn't have any prior conviction.
No priors?
And Judge, I would
Este
ask,
acusado no tiene condenas anteriores.
Yeah, but he has a felony, a pending felony, right?
Bueno, pero tiene un delito mayor pendiente.
no, he doesn't, Judge. It
No,
looks
it
like-
was closed on February 12, 2025.
Yes,
No,
this is,
cerró el 12 de febrero del 2025.
his only open cases are the misdemeanor that was addressed earlier and also in this.
And a misdemeanor, yeah.
The
Correct.
state would request standard bond, Your Honor.
Lo
What's
único
the
que tiene
standard
pendiente-
bond?
Delito leve. ¿Cuál es la fianza estándar?
Okay, I'll issue a $5,000 bond.
Judge,
Muy bien.
the defense would be asking for pretrial services with the.
No, he bit an officer. No, I'm not gonna give him pretrial services.
Pedimos servicios previos a juicio. No,
La
él
fianza
mordió
para
a
que
un
pase
oficial del
directo.
correccional. No le voy a dar servicios
5,000
previos a
dólares,
juicio.
Melvin Rutledge. And, is he present?
Yes, sir.
1 second, Judge. He is present, but just let me turn back to the page.
All right, hi, good morning, good afternoon, sir.
Good afternoon, sir.
You're charged with, a third-degree DUI. It's fourth or subsequent offense.
Judge, defense's argument as to PC. I believe there is no PC as to the other prior DUIs within the four corners of the affidavit.
In your honor, he has prior convictions from 94, 1999, and 2023.
Are they on the A form?
Not listed on the A, your honor.
They're not-
I mean, this is a felony charge for, was this an upgrade from, county court?
Not that.
Bind up, Your Honor.
Yeah, bind up.
And not that I see, your honor, because the date of incident is the 31st, your honor. This is.
Right, so if you want, unless you want to hold it for a PC hearing and tomorrow, I don't see anything on the A form that he has other priors. I don't see, as far as the priors that I have here, he only has one. So unless you want to,
We would ask for a reset for the PC.
okay, let's reset. Reset for PC. Nine, 2. All right. Okay. Next,
Judge, I'm sorry, is he able to bond out or?
no, we're holding it till tomorrow.
Thank you.
Judge, I would ask for it to be the standard bond on the charge as is for now, and then be reset for tomorrow, should he not be able to bond out for PC determination, which I believe is what would be appropriate.
I
Because
mean,
had he not come to first appearance today, he would be able to bond out on the standard bond regardless of your
Yeah.
auto determination.
I could give him standard bond.
I would just ask for the bond to remain.
All right, so at this point, he has a bond
That's
when he was arrested, so he doesn't need me to make the determination. He could just bond out whenever he
Perfect.
wants.
And then we can just reset tomorrow for the PC determination, should he not be able to post that bond.
If he doesn't post a bond, if he comes in tomorrow and he bonded out, then he bonded out.
Amazing, thank you, Judge.
All right, so, I mean, the bond was set already.
So
when he was
Judge,
arrested.
PCH no hold,
What is it?
No hold,
PCH no hold.
no hold. There shouldn't be a hold.
Okay.
So I can blind that tonight?
Yes, you can.
How much is it?
All right. Byron Ivan Velasquez Brosio. Carjacking, robbery, second-degree felony.
Judge, he needs the services of the Spanish interpreter.
El caballero tiene un cargo por asalto vehicular, agresión vehicular y por robo con fuerza.
Defense stipulates us to PC, Judge.
Right.
La defensa estipula que existen suficientes indicios, juez. Correcto.
Right. All right.
In light of, but we do have argument as to his release in light of his lack of priors. We would be asking for house arrest, total lockdown with an alternate bond.
Okay.
En vista de que no tiene antecedentes, pedimos que se le permita salir con arresto domiciliario, encierro total, con una fianza alternativa, porque no tiene antecedentes.
Date?
Fiscal.
Your Honor, we would just be requesting the standard bond.
What's the standard bond?
$7,500.
7,500.
Pedimos la fianza estándar, juez. ¿Cuánto es la fianza estándar? 7,500.
Stay away order?
Orden de alejamiento.
Stay away order from Archie Venegas.
Okay, sir, you're to stay away from the victim in this case, which is Archie Venegas. All right?
Caballero, está obligado a mantenerse alejado de la víctima en esta causa, Archie Venegas.
You cannot have any contact with that person in writing by telephone, pager, fax, or through third person. You must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. All electronic contacts such as emailing, texting, Facebook messages, or by Twitter is prohibited. You're also to stay away from the address of 253 Northeast 9th Court, Homestead, Florida 33030.
Caballero tiene que mantenerse alejado de este señor y no puede tener contacto con él directo o indirectamente a través de teléfonos, a través de Viper, a través de fax o a través de cualquier otro dispositivo electrónico. Tiene que mantenerse además alejado del lugar que queda en el 253 noroeste de la 9 Court en Homestead, Florida, y no puede tener ningún contacto con él a través de Twitter o a través de ninguna otra medio social o sistema electrónico.
Okay, Eugene Gabriel.
Judge, excuse me, before we continue, Mr. Velasquez had an immigration hold.
Okay. All right.
And his charges was 7,500 each count?
Whatever, he can.
How many counts did he have? Let me see.
2 counts, Your Honor.
Yeah,
He had 2 counts.
7,500 each count.
Thank you, Judge.
Okay.
Immigration hold. Ice hold. Yes, okay, this person has 2 cases. Okay, sir, Eugene Gabriel Cruz, you have 2 cases.
He needs
You
the
have-
services, Spanish interpreter, Judge.
Okay. You have F25018919 and F25018918.
Pero usted tiene 2 casos, F25018919 y y F25018918.
Okay, you have on the first one, on 891819, you're charged with battery of a police officer or corrections officer or firefighter. That's a third-degree felony, a misdemeanor assault of a police officer, firefighter, and a misdemeanor resisting an officer without violence. And you have a second count of burglary of a dwelling or structure with damages. That's a first-degree felony.
Entonces, en relación al primer
And
caso, usted está encarando el cargo de agresión contra un policía, un oficial correccional o un bombero. Es un delito mayor de tercer grado, un delito grave de tercer grado. También tiene delitos de resistirse contra un policía y de agresión contra un policía, que es un delito menor o leve. También está encarando otro cargo que es allanamiento de una estructura o de una vivienda.
okay, I'm finding probable cause as it relates to the case number 25018918.
Primero que hay
On
suficientes
all three
indicios
counts.
en relación al caso F25 en 89 18 919 en los tres cargos.
Judge, we'd be asking for house arrest, level 2 with an alternate bond.
Pedimos detención domiciliaria, encerrona domiciliaria nivel 2 como alternativa a la fianza.
Okay, I also find probable causes relate to the battery on the police officer. The misdemeanor assault on the police officer and the resisting an officer without violence. That's on case number 25018919. So I'm finding PC on both, on all three counts.
Bien, determino que hay suficientes indicios en
State,
relación
what's your argument?
a la agresión,
As it
el delito
relates-
grave de agresión contra el policía y también el delito leve de agresión contra el policía y de resistirse sin violencia contra el policía, que los dos son delitos leves o menores.
What's your argument as it relates to the defendant's or the defendant's request for house arrest level 2?
Fiscal, ¿qué me dice en relación a la solicitud del acusado que se le permite salir con arresto
Doesn't seem
domiciliario?
like the defendant has priors.
Parece
That
que el
is
acusado
correct.
no tiene antecedentes.
And the state would have no objection so long as the alternate bond stays in effect.
Okay, and that's true. I'll do
La
that. All right, so I'm
fiscalía no
issu-
se opone, siempre y cuando que se le imponga la fianza como alternativa. Lo
Okay,
haremos.
so house arrest level 2.
Arresto domiciliario nivel 2.
Alternate bond was F3 battery on a police officer is what? 5,000. Alternate bond
El,
on misdemeanor. Go
en
ahead.
el delito mayor de tercer grado, ¿cuánto es la fianza? $5,000. En los delitos leves,
On the two misdemeanor counts,
los dos
ag
cargos de
assault
delitos
on a
leves,
police officer and resisting an officer without violence.
acometimiento contra un policía y resistirse sin violencia.
What is alternate bond
500
on
¿Cuánto es
both?
la fianza
on the
alternativa?
resisting, Your Honor.
And the other one
The other one, Your Honor, can you repeat again, Your Honor?
was resist.
500.
One is resisting an officer. The other one assault of a police officer.
Uno es resistirse
They're
contra el
both
policía.
first degree misdemeanors.
Los dos son delitos leves de primer grado.
Yeah, it should be 1,000, Your Honor.
Y
On
deben
which
ser
one?
$1,000.
On assault on law enforcement officer.
En el de la agresión contra
Okay,
el
so
policía.
count 2 is 1,000.
El segundo cargo son
Count
1,000.
2 is 1,000. Count all. That's the alternate bond. Count 1 is
El cargo son
5,000.
1,000. El cargo 1 son $5,000.
It's count 2 is 1,000 and count 3 is 500. That's on
Cargo
case
2,
number
$1,000.
F25 18919.
En el tercer
Then on
cargo
case
son 500.
number F25 18918, I found PC. I'm holding house arrest Level 2 on
En el caso F25 18918 determinó que hay suficientes indicios. Arresto domiciliario nivel 2.
and alternate bond on a first degree burglary of a dwelling.
Como alternativa, la fianza
That's no bond?
por allanamiento de morada. ¿No califica para fianza en eso?
Let me see, because burglary, dwelling, structure, damage.
Allanamiento de vivienda o estructura.
What makes it a first degree?
¿Qué es lo que lo convierte en algo de primer grado?
Your Honor, there is a charge for burglary of a dwelling, but it's under case number F25-18918.
Yeah, that's the one I'm looking at,
That's the
25.
case you're looking at?
Yeah, I'm seeing the vehicle.
Hay un cargo de allanamiento de morada, señoría, en relación al caso F25-18918. Ese es el que estoy mirando.
So, Your Honor, because that is a punishable by life felony, the state at this time does move for pretrial detention pursuant to Florida statute 907.0415P.
Señoría, como este cargo puede ser castigado con un máximo de cadena perpetua, la Fiscalía pide que se le retenga pendiente juicio conforme a la ley 907.041
Oh, yes, it is, because he went inside her vehicle while she was there. All right,
Lo es.
so
But
it's
the
no,
non-bondable, Judge, the non-bondable is on the dwelling, not necessarily the vehicle.
Sí, porque él ingresó al vehículo cuando ella estaba ahí. Señoría, lo que lo descalifica de fianza es lo de la vivienda, no el vehículo.
it says here, the defendant arrived, the defendant then entered into Ms. Figueroa's vehicle through the unsecured front passenger door. While inside the vehicle, the defendant began to ransack the vehicle and remained inside the vehicle. Ms. Figueroa became altered, stepped outside and began to advise the defendant she was telephoning and calling the police.
Aquí dice que el acusado ingresó al vehículo de la señora Figueroa por la puerta trasera del pasajero y empezó
Where
a
is the burglary
alterar
of a
cosas ahí.
structure?
La señora Figueroa llamó a la policía y le
Damage
dijo
of
que le estaba
1,000
llamando a
or
la policía.
more. Let me see.
In your honor, from the state's understanding of the arrest form, the defendant had.
Total property was 2,500. I got it. Uh-huh.
Yeah, no. It's the same.
Yeah, I see it there.
La
All
propiedad
right, so the
fueron
first,
2.500.
all right, so forget about the, forget about the house arrest. He has to be hold no bond.
Olvídense de los arrestos domiciliarios. Tiene que ser retenido sin fianza.
No bond as it relates to F 25-18918. I will issue the standard bond on count 2 and 3 of that case. How much is the standard bond for criminal mischief?
No hay
I'm
fianza en
sorry,
relación al primer cargo.
2,500? Okay, so
F25.
no bond on count 1,
139.
2,500 on count 2, and 2,500 on count 3. As it relates to revisiting the other case, F 25-01-8919, I am eliminating the house arrest and just entering the alternate bond of 5,000 on count 1, 1,000 on count 2, and 500 on count 3.
Entonces, en relación al primer cargo, en el MF25-189-18, no hay fianza en relación al primer cargo, 5,000 en relación al segundo cargo, 2,500 en relación al tercer cargo, en relación al caso F25-018-919, en relación al primer cargo, las fianzas son $5,000, en relación al segundo cargo son $1,000.
Okay, yeah, I'm issuing a stay away order from the vape shop, 4334 Southwest A Street, Miami, Florida, 33134.
Una orden de alejamiento de la pastelería que queda en el 4334 de la calle 8, Miami, Florida, 33134.
Go. Avila Suarez, Kimberly Manuel Avila Suarez.
David.
Okay, no, this is cocaine possession. He has no priors.
Defense stands made us to PC. If the state is inclined to stipulate, we'd be asking for pretrial services with an alternate bond.
Case, Your Honor, last name?
This is Kimberly Manuel Avila Suarez.
Never mind, Judge. I was just informed that he does have an ICE-hold, so we'd be asking for $1 bond.
And there are no priors for this defendant, Your Honor, but as the clerk pointed out, there is an immigration.
Okay, right, so
Asking for $1 bond.
ICE-hold. He has no priors. I'll issue $1 bond. I find PC, $1 bond. Next. Giuseppe D'Amico, battery on a person 65 or older, and I'm assuming there's a stay away order. Disorderly conduct.
Italia.
Oh, Jesus.
Interprete.
Oh, my goodness. Judge, he speaks Italian.
Buonasera.
We need an Italian interpreter.
I will try to make arrangements through language line, Judge. It will take a moment or two. So this interpreter speaking, the Spanish interpreter.
All right, let's wait. Let's pass it. Go to the next one. Roberto Jose Nodal. Okay, sir, you're charged with possession of controlled substance within 1,000 feet of a church, convenience store, and it was crack cocaine, with intent to sell. There are 2 counts, and then 2 counts of drug paraphernalia. I find PC for both. He has some priors. And there were
Your Honor, the defendant.
oh, well, actually, there were no action 2025 cases, and I have some 2002 and 2000, so he really has no priors.
So in light of that, Judge, we would be asking for pretrial services with an alternate bond.
Now, the first one is an F1.
That's correct, Your Honor, and the state is going to move to hold the defendant no bond pursuant to Florida statute 907.041.
Okay.
Is the state seeking pretrial detention?
Apparently,
And I apologize, Your Honor, I wasn't able to hear the public defender.
she's asking if you're seeking pretrial detention.
That's correct.
Okay, so I would ask for this to be reset for tomorrow in front of division so it could be scheduled for a hearing.
All right. I mean, I don't have an issue with that. Is there something that I need to do to reset it for tomorrow?
I don't believe so, Judge. I just think it needs to be reset in front of
It
division.
might be the next day.
Judge, on which count was that? I'm sorry.
Count 1, no bond.
And I believe count 2 as well, Your Honor. There are both counts of
Yes.
controlled substance possession with intent to sell within 1,000 feet of it.
And I find PC on count 3, which is count 3 and count 4. And what's a standard bond for that? On this 100? 500. All right, 500 on both. All right, thank you. Is there something I need to sign for it to be reset? All right, next is Rogelio Carrillo Varga.
He needs a Spanish interpreter, Judge.
Interpreter present.
Hi.
Go ahead.
Adelante.
All right, this is, sir, you're here on case number F-25-018957. You're charged with 2 counts, 1 count of cocaine sale of crack cocaine, another count of possession of crack cocaine and driving while license suspended. I'm assuming I already did the driving while license suspended, so we're just addressing the cocaine possession.
A ver, usted se encuentra aquí en relación al caso F25-01957, posesión de crack y venta de crack y otro cargo de conducir con la licencia suspendida. Me imagino que ya ventilamos lo de la licencia suspendida, ahora vamos a lidiar con lo del crack.
He does have an ICE hold.
Él tiene una orden de retención por
All
parte
right,
de la
I'm going to
autoridad
issue a
migratoria.
standard bond. I find PC on all counts.
Impongo la fianza estándar. Determino que todos los cargos
What is
están
the standard
sustentados por
bond for
indicios.
cocaine sale?
La
2,500, Your Honor.
fianza estándar por venta de cocaína, ¿cuánto es? 2.500.
Or, Your Honor, for possession is 2,500.
Y por
2,500.
posesión son 2.500.
And for sale, how much was it?
Por venta, ¿cuánto es?
75.
7.500.
All right, so on count 1 is 7,500, count 2 is 2,500.
Primer cargo 7.500, cargo 2, 2.500.
All right, thank you.
Gracias.
Babatude Kelim Payiga. And good morning, good afternoon, sir. You're here on case number F-25-018915. Second degree grand theft, 1 count of second degree grand theft, 1 count of sale, manufacture, delivery, or possession of a hallucinogen, cannabis possession, 1 count, and all right.
Judge, I believe there's a warrant already on in a Nebia hold, or I could be wrong.
Let me see. Is there a Nebia hold on the, is there? Hello? State?
I apologize, Your Honor.
Yeah, what was it, corrections? That you said on this case?
It wasn't correction, Judge, it was the PD, it was myself.
Okay, I'm sorry, what was it that you said?
It looks like this was a warrant with a Nebia hold, but I could be wrong. If you look at count number 4, it says hold for magistrate, and in the first number, in the beginning of the narrative, it says hold for Nebia hearing.
Correct, that's what we had, Judge. Correction has the same thing.
So, Your Honor, we would be asking for that after we set the bond amounts in this case.
Right.
We'd be asking for a Nebia hold.
Okay,
But as to each count, aside from that, Your Honor, we'd be requesting standard bond.
yeah, I find PC on count 1, 2, 3. And what's the standard bond?
Your Honor, I believe for count 1, it would be 7,500, and then for counts 2 and 3, it would be 2,500.
Okay, 2,500. So count 1 is 7,500, count 2 is 2,500, and count 3?
It is 2,500.
2,500. So a total of 1,250 with a Nebia. Okay. Diane Zahara Lorenzo.
You need to
Yes,
finish
sir.
it for the judge.
Interpreter present.
Okay, sir, you're here on case number F25018916. You're charged with possession of controlled substance, sale, manufacture, of methamphetamine and drug paraphernalia, a misdemeanor.
Caballero, usted está acusado en el caso F25-01816 de posesión de una sustancia controlada y metanfetamina y de la venta de metanfetamina y de parafernalia para uso de drogas.
Okay, he does have some priors.
Él tiene
I'm gonna-
antecedentes.
I'm gonna issue the standard bond. What's the standard bond on count one?
Le impongo la
A
fianza.
second degree
¿Cuánto es?
felony.
Un delito mayor de segundo
I'm
grado.
sorry? 7,500. And on
7.500.
count two?
Y en el cargo 2,
500, Your Honor.
500.
So 8,000 total.
En total son 8,000.
All right, thank you.
Gracias.
Eduardo Sarabia. F25018917. You're charged with one count of resisting an officer with violence to his person, possession of alcoholic beverage, prohibited drinking and possession, basically within 100 feet of a store. So you have two counts of alcohol possession and one count of resisting an officer with violence. I'm sorry? Oh.
Judge, this correction, this is for the clerk. Can you please check number 18 and see just?
I find probable cause on all three counts. I'm going to issue ROR on count 2 and 3.
And we're gonna-
And what's the standard bond on count 1?
Will Your Honor consider pretrial services with an alternate bond?
2,500.
Yeah,
2,500.
okay, that's fine. Pretrial services. Alt 2,500. Thank you. Christopher Simmons. Mr. Simmons, you're charged with one count on case number F25018924, one count of possession of controlled substance, 1 gram total MDMA, that's a third degree felony, fleeing or eluding police officer and use of a weapon or display while committing a felony.
Judge, defense stands mute as to count 1 and 2. As to counts 3, our argument is that there is no nexus of the weapon and the possession of narcotics. Only that there is proximity. Not that the weapon was displayed or used in any particular way in possessing the drugs.
This search incident to arrest, okay.
So, Your Honor.
Does it apprehend him on foot? Arrested, it's not.
They found the firearm on him at the same time that they found the.
That's how I'm reading, that's how I'm reading it, so I find,
I apologize.
no, go ahead.
Even if it weren't, even if we couldn't make it work with the controlled substances, the fleeing and eluding is also a felony, and he was also caught with firearms.
Right, so I'm finding PC on all counts. That's 4 counts.
And Judge, in light of his priors, I would ask for, do you have somewhere you can go? An address.
I'm sorry, what was your argument?
Sorry, Judge, in light of his priors, if Your Honor will consider pretrial services or in the alternative house arrest, with an alternate bond, he does take care of his mother who does have congestive heart failure, and she doesn't know that he's here right now.
The state would stipulate to house arrest level 2, alternate standard bond for every count.
House arrest 2. Give me the standard bond for
count 1, Your Honor, and for count 2, it would be 2,500 for each.
that's an F3. Okay, 2,500 each. Count 3.
Count 3 is also 2,500, Your Honor.
Count 4.
Your Honor, I believe well, that one I believe is 5,000.
Okay.
House arrest alternate on all counts?
Yes. Thank you. Jordan Taylor and Miller. Okay, you're charged with 1 count of cannabis sale possession within 1,000 feet of school and cannabis possession with more than 20 grams. The first one's a 2nd-degree felony. The third one is a 3rd-degree felony. Yeah, I find probable cause for both.
Judge, considering the nature of the charges and considering his priors, I would ask for pretrial services with an alternate bond if the state has no objection.
State?
Your Honor, I couldn't hear the public defender.
Okay.
If you could repeat, counsel?
Sure. We'd be asking for pretrial services with an alternate bond in light of the charges, if the state has no objection.
State?
Your Honor, the state would have no objections.
Okay, level 2?
An alternate bond.
Pretrial
Okay.
services, Judge, not house arrest.
Oh,
And just to repeat, counsel, is it for pretrial services?
Yes.
Mr. Jordan Miller?
Yeah.
And he verified his address, so we show that he doesn't live in Florida.
Is the defendant able to verify his address? We're
Could
currently
that be
unsure if he
determined
still
by pretrial
resides.
services later on? And then he can just, if anything, post an alternate bond. We can just set pretrial services with an alternate bond, and then we can address that, should it become an issue.
The state would be asking for standard bond.
I'm gonna issue standard bond given the charges. So what's the standard bond?
For the selling within 1,000 feet, it's 7,500. And then for the possession, Your Honor, it's 2,500.
One sec. All right. Thank you, sir.
Your Honor, this is video. I believe we have the Italian interpreter on the line.
Okay, I didn't sign this one. Okay. Did we call Jordan Taylor Miller?
Your Honor, that's the case we're calling right now.
Oh, that's the one we're calling right now. Okay.
Are we recalling the
No, let's call the one, Giuseppe D'Amico.
Perfect. And that is number 2.
We have an interpreter, Italian interpreter.
I can't read that.
Buonasera, sono Giuseppe De Micco.
Is the interpreter present?
Yes, I am, Your Honor.
Okay,
I'm present.
have you been sworn in as an interpreter?
Yes.
Okay, you have. All right.
Defense does have argument as to probable cause. There is no, within the 4 corners of the affidavit, there is no mention of any age as to the charge for battery on an elderly person or battery on a person 65 years or older.
I don't see it.
And Your Honor, the state would be saying that the battery or regular battery would be sufficient in this case, Your Honor. And
Sure.
if that doesn't suffice, we would ask for a reset for a PC.
All right, I'll find PC for just a regular battery.
Can the interpreter interpret?
Okay, so
I'm sorry, I couldn't hear.
Okay.
Could you repeat that, please?
Okay, the court found no probable cause for battery on someone over 65, but the court did find probable cause for just battery. And I'm finding
la cosa-
probable cause for disorderly conduct.
Probable cause for disorderly conduct?
Yeah.
Allora, la Corte non ha trovato causa probabile per violenza aggravata per una persona di età superiore ai 65 anni, comunque possibile presenza di aggressione o violenza aggravata su persona non di persona sopra i 65 anni e anche causa probabile per comportamento inaccettabile.
Sì.
Okay.
Sì.
All right. Doesn't look like he has any priors.
Non vedo altre cause in corso o passate.
That is correct, Your Honor.
Okay. Sir, I'm going to issue a stay away order. You are prohibited from having any contact with the following person, hereinafter referred to as the victim, Mohammed Masafari, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. If you can interpret that.
Stiamo rilasciando un ordine di lontananza. Non puoi essere in contatto, nessun contatto, né fisico, né verbale, né per iscritto, né per messaggio, né per fax, né per via lettera, niente, con il signor Mohammed Masafari.
Va bene, ok. Ok, va bene.
You must stay at least 500 feet away from the victim's home, place of employment, and school at all times. Also, electronic contacts such as emailing, texting, Facebook messages, or by Twitter is prohibited. You're also to stay away from Islands Queen Bayside Marina, 401 Biscayne Boulevard, Miami, Florida, 33132. If you live there, you're gonna have to contact a police officer and have him go there with you so you can remove your personal items.
Can the interpreter please tell Mr. Giuseppe D'Amico not to speak about the facts of his case, but he does have some information that he does want to talk to the court about, and I just don't understand him.
I'm sorry, so you would like
Just inform him that to not
not
talk about the facts of his case, but he does have stuff that he wants to bring to the court's attention that I do not understand.
Okay, and you could tell him that whatever he says is doesn't matter. The court's not gonna take it into consideration at this point. So he's better off just staying quiet.
Okay. I do have one need for clarification. The Islands Island Queens Bayside Marina. When you said the address, I didn't get that. I wasn't fast enough in writing it.
Okay, let
Sorry.
me get that. Okay. It's Island Queen Bayside Marina, 401 Biscayne Boulevard, Miami, Florida, 33132.
Biscayne Boulevard, Miami. Could I get the zip code again?
33132.
Allora, la Corte aggiudica che devi rimanere in tutti i momenti a almeno 500 piedi di lontananza dalla vittima, dalla casa della vittima, dal posto di lavoro della vittima, dalla scuola della vittima. Non devi essere più vicino di 500 piedi a questa persona. Inoltre non puoi avere nessun contatto a livello tipo di messaggistica o su Twitter, Facebook, nessuno dei social, niente del genere. Non puoi avere nessun contatto con questa persona. Non puoi andare entro i 500 piedi da Island Queens Bayside Marina a 401 Biscayne Boulevard, Miami, Florida 33132. Se tu dovessi abitare in questa zona e hai bisogno di andare a ottenere delle tue cose, i tuoi indumenti o quello che sia, devi chiamare la polizia e ti devi fare accompagnare da loro per andare a prendere le tue cose, perché là non ci puoi stare. Inoltre, la signora, che credo che sia la persona che ti sta facendo da avvocato, ha detto che ha capito che volevi dire delle cose alla corte, però ti consiglia di non dire nulla in questo momento. Poi il giudice ha detto anche a volta sua che se vuoi dire qualcosa lo puoi dire, però loro non cambieranno idea e non prenderanno in considerazione quello che tu dici in questo momento, perciò sarebbe opportuno per te non dire niente.
Ok, va bene.
Okay, that's fine.
Va perfetto.
All right. What is any argument as to relates to bond?
Hai qualcosa da dire a riguardo della tua cauzione?
Sì,
No, not from the defendant.
Judge, I cannot really understand him. I would ask if he does have an address, I would ask for pretrial services with an alternate bond. I'm considering there's only PC for misdemeanors here.
Okay, so what is it that you're seeking? Pretrial services with an
Pretrial
alternate
services.
bond?
Correct, Judge.
I'm gonna enter pretrial services. If he has an address, perfect. If he doesn't, then he's gonna have to post the bond.
Perfect.
What is the bond for a battery? 1,000?
Yeah.
And I find probable cause on both counts and the disorderly conduct,
500.
alternate bond,
It was $500, sir.
right? Alternate bond for 1,000 count one. And 500 on count two. All right, thank you, sir.
This was for Giuseppe, Your Honor.
Yes. All right, Kevin Abreu Rodriguez.
Sure, fine.
I'm sorry?
Rodriguez.
I'm sorry, on the other person, the one we just did? There's another one that needs an Italian interpreter? Oh, what's his name? Okay,
Zero D'Amico.
Zero D'Amico, got it. Is the interpreter still here? Because we're gonna need her again.
Excuse me, Your Honor, is this the court needs an Italian interpreter again?
Yes, because we have a
Unfortunately,
co-defendant.
I logged off, Judge. I'm gonna have to go through that again. Sorry, I have to, it takes some time to set it up.
All right, that's fine. If you can get that, please, we'll pass it. That's on, so we'll pass, Cito D'Amico. The Cito D'Amico speaks, well, if he speaks Spanish, English, but. All right, Kevin Abreu Rodriguez. who's there with you? Ma'am, counsel?
Sorry, Judge, he is present.
That's Kevin Abreu Rodriguez.
Yes, Judge.
Okay, you're charged with one count on case number F25-018926, one count of cannabis possession within 1,000 feet of a school, and one misdemeanor count of cannabis possession. The felony count is a second-degree felony. He has a lot of cases, but a lot of no actions.
Your Honor, the state would be requesting standard bond in count one, but the state does have an announcement in count two.
Okay, go ahead.
Your Honor, the state has an announcement in case F25-18926. As to count two, the state announces a no cross, but only as to count two of F25-18926.
Okay, is there, just put it here? AMP?
And so, Your Honor, for the count one, the state's requesting a $7,500 bonds and a stay away order from the Breakwater Hotel.
Mm-hmm. You have the stay away order?
Yes, Your Honor.
All right, got it. All right, sir, you're to stay away you're to stay away from the Breakwater Hotel, 900 Block Ocean Drive, Miami 33139. All right, I find probable cause for count one. What's the standard bond?
$7,500.
I'm issuing the bond for 7,500. All right, thank you, sir. Juan Oliva.
Judge, I'm sorry, I believe you skipped number 33, Pereira Salgado. Page 11.
Page 11. Is it there? Did I give it to you or? What is it?
Pereira Salgado, first name Yandis.
Page 11, page 11.
Oh, page 11. Wait, did we skip? No, D'Amico. Oh, he's the son. Judge, so for the next one, on the bottom of page 10, Cito D'Amico, he also needs the services of.
Yeah, I know that. Yeah,
Oh, okay.
I passed that one.
Oh, okay.
Okay, I got it. Pereira here. Got it.
We're gonna get the interpreter and then we'll address that. I don't understand. I'm sorry.
Okay, Pereira Salgado, is a person present?
Olivia? You're Juan Oliva?
I'm Yandis Daniel Pereira Salgado.
What's your name?
Oliva.
Or did we skip Pereira Salgado? Okay.
Pereira Salgado, Yankees. Scared. Y'all check him out?
Judge, the person I have right next to me is Juan Oliva. He is
Okay, so what happened to Pereira Salgado? Because I was told that we passed him.
we are looking for him right now. So if we can just
I'll pass him too. Okay.
until
And Juan Olivas, I have Juan Olivas. All right, sir. Good afternoon, sir. You're charging F25018937, aggravated assault with a firearm and cocaine possession.
Defense does have argument as to the aggravated assault. It does stay within the four corners of the A form that the victim said that she was not scared, which is one of the necessary elements for probable cause as to aggravated assault. Or one of the necessary elements for assault, period, not necessarily aggravated assault. So I would argue that there's no PC for assault at all, neither aggravated nor misdemeanor assault. Do you need the Spanish interpreter? And can we have the services of the Spanish interpreter?
Okay.
Se podría disponer de los servicios del intérprete. Se podría disponer de los servicios del intérprete español. Muy bien.
All right. All right, sir, you're here on case number F25018937. You're charged with aggravated assault with a firearm and cocaine possession. State, there's an argument, a PC
Caballero, usted se
argument.
encuentra aquí en relación a la causa F2501-8937. Se le acusa de asalto con un arma de fuego y posesión de cocaína. Fiscal, antecedentes.
I mean, Your Honor, off the four corners of the arrest form, the state would agree that there is not probable cause for aggravated assault. The state would ask for probable cause for improper exhibition of a weapon.
I agree. Is that what count is that?
So that
No
would be,
figuran indicios de
Third degree felony?
agresión con arma de fuego.
I'm double checking, Your Honor.
It's a misdemeanor.
Solamente hay suficientes indicios de agresión.
It's a
¿Es
first
un
degree
delito mayor de
misdemeanor.
tercer grado? No, es un delito leve.
It's a first degree misdemeanor, Your Honor, but given the fact that it was a first degree misdemeanor which involved exhibiting a firearm in an apparently threatening manner, we would be asking for $1,000 bond for that count.
Señoría, es un delito leve de primer grado, pero en vista de que tuvo que ver con la exhibición de un arma de fuego, pedimos que se le imponga una fianza de $1,000 en relación a ese cargo.
Okay, I'm gonna enter a $1,000 bond. How about for cocaine possession, 2,500?
That's correct, Your Honor.
Bueno, voy a disponer una fianza de $1,000. ¿Y qué me puede decir del cargo 2? $2,500 por posesión de cocaína. Eso es correcto, su señoría.
Thank you. Okay, thank you.
Gracias. Muchas gracias.
Mr.
Excuse me, Your Honor. This is a Spanish interpreter. The Italian interpreter is in the meeting.
All right.
Judge,
Okay.
really
I am
quick.
here.
Your Honor, for that last defendant, there is a stay away order from Adelaida Solivan.
Oh, wait, sir, don't leave yet.
En relación a este último
No, bring it
acusado,
back.
hay una orden de alejamiento. Tráiganlo de vuelta.
Okay, sir, you're to stay away from Adelaida Soliva. You cannot have contact directly or indirectly in person, in writing, by telephone, pager, fax, or through third person. You must stay at least 500 feet away from the victim's home, place of employment, and school at all times. And you have to stay away from 1543 Northwest 38th Street, Miami, Florida, 33142. If you live there, you are going to have to leave the property. You can have a police officer go with you so you can take your personal items. All right.
Caballero, está obligado a mantenerse alejado de Adelaida Oliva. No puede tener contacto con ella ni directa ni indirectamente, ni a través de terceros, ni por teléfono, ni por mensaje. No puede comunicarse con ella a través de ningún medio social, ni teléfono, ni beeper, ni fax, ni de ninguna manera. Además, tiene que mantenerse en todo momento por lo menos a 500 pies de distancia de ella, del hogar de ella, del centro de trabajo de ella y de la escuela de ella. Además, tiene que mantenerse alejado de la dirección que le voy a dar, que es el 1543 noroeste de la calle 38, Miami, Florida 33142. Si usted vivía allí, se le permitirá regresar allí acompañado solamente de un policía para que pueda recoger sus pertenencias personales. ¿Comprende?
All right. Thank you, sir.
Gracias, caballero.
Okay, who we have now?
We have, back
32.
on page
The
10, we
Micio
have-
cereals.
yes,
Demicchio Serial, that's a gentleman there?
yes, Judge.
Right, has Italian interpreter been sworn?
I'm here, Your Honor.
Have you been sworn?
Yes, I was the previous interpreter.
Okay, perfect. All right, ma'am. All right, sir, you're charged in case number F25018930 with battery on a person 65 or older and disorderly conduct on the establishment. I'm assuming you're making the same argument you did before?
I sure am, Judge. No PC.
All right, so I'm gonna define PC as to battery only. And I'm issuing pretrial services. Alternate bond 1,000. I'm filing PC on count 2 and a pretrial services, alternate bond. What was that one for the sort 500?
I'm
What
sorry,
was it?
Judge, I got $150.
150. All right, 150. All right, so you could explain that to the gentleman.
Allora, per il primo reato minore stiamo
Stay away.
mettendo come aggressione violenta solamente, stiamo togliendo la parte del sopra i 65 anni e lasciando solo violenza contro la persona, stiamo rilasciando, richiedendo servizi prima della corte, che puoi avere i servizi necessari per poi attendere la corte, ovviamente pagando la cauzione di $1.000 per questo reato minore. Per il secondo lo stesso servizi come per il primo reato minore, in questa seconda la cauzione di $150.
Okay.
And Your Honor, the state will also be bringing forward a stay away order with the same condition
Okay.
as the prior defendant in the respective case.
Okay, then can I have it?
Yes, one.
What? Okay, it's finished? No, I think they're doing the stay away order.
Oh.
They won't let you.
Di- più 39. Is number.
Okay.
I think there was a stay away order provided. Give me the name of the person.
It's Mahmoud Mozaffari.
Mahmoud?
27.
Mozaffari, Your Honor.
Uno.
Okay. All right, sir, you're to stay away from Mahmoud
Uno,
Masafari. You cannot have any contact with that person.
Okay.
Only WhatsApp. This number.
Okay, but pay
All right.
attention.
Sir, you have to stay away from Mahmoud Mosafari. You can have contact directly or indirectly in person, in writing, by telephone, pager, fax, or through third person. You must stay at least 500 away from the victim's home, place of employment, and school at all times. Also, electronic contacts. You must avoid electronic contacts such as emailing, texting, Facebook messages, or by Twitter. So all that is prohibited. All right, thank you, sir.
Allora, anche
Is this number right?
Anche qui c'è l'ordine di lontananza, devi rimanere, come detto prima, almeno un minimo di 500 piedi di lontananza dalla vittima Mahmoud Mosafari, sia da dove abita che dal suo posto di lavoro, posto di scuola, nei suoi dintorni. Non puoi stare vicino a lui, non puoi avere nessun contatto con questa persona, con la vittima, in nessun modo, né tramite SMS, telefonicamente, per iscritto, né per sui social, Twitter, Facebook, queste cose, Messenger, queste cose di qua, WhatsApp, niente, non puoi avere nessun contatto assoluto con questa persona.
All right, thank you, sir.
Judge, excuse me, before we continue, we need some clarification on number 18, Mr. Rutledge, that you have resented for PCH and you held them no bond. The bond's still good at 5,000.
Number
Is that
18.
correct?
Correction, we're not gonna have it in the system. It's just gonna be a reset, but he could bond out because he have standing bond.
That is correct.
Right.
Thank you.
Excuse
right,
me, Your Honor, this is the Spanish interpreter. Is the court finished with the Italian interpreter?
As far as I know, there's no more Italian.
As far
Yes,
as I
so-
know as well, Judge.
Yes, okay, thank you. Thank you, interpreter.
Okay.
Have a good evening. Of course, thank you for using our services. Have a good evening.
Thank you. All right, I have here, probation violation, case number F15-19460.
Well, so Your Honor, in
And
this case,
he picked up a new case, F25,
that's correct. Your Honor.
018951. So he's gonna be held for the probation violation hearing
That's correct.
or probation violation. So he'll be held on that case. So he's being held on F14-19460.
And
That does
Your Honor,
F15?
given the fact that he was on felony probation when he picked up the new case and the significance of the case that he was on felony probation for, the state would be requesting an elevated bonds in the amounts of $8,000.
All right. I find probable cause on both counts.
And Your Honor, for the current case, it would just be one count. And then the second, I guess, Your Honor, would be referring to the probation violation.
Right, well, I'm talking about the case F25-018951. There's two counts. Oh, it's a non-valid driver's license. I already addressed that, so.
correct, Your Honor.
All right, so I'm finding probable cause. What's the bond you're seeking, 8,000?
That's correct, Your Honor.
All right, that's 8,000 and hold no bond on the probation violation. All right. Thomas Peter,
Judge, I'm sorry, before we continue, Mr. Pereira Sagallo refused. He was number 33.
huh?
Number 33, we had skipped him. He refused. Pereira Salgado.
Oh, okay, so reset.
Yes, Judge.
9-2. All right, thank you. Perez, Tomás Peter Ceres. All right, sir, you're charged with 1 count of cocaine possession. The court finds probable cause. You have lots of priors.
Defense would ask for a tap with an alternate bond.
State.